Before the episode begins, I would like to mention a couple of things. First of all, as you can probably already tell, this is an extremely long episode. There was a lot to read in this case, a lot to talk about in this case, so it took quite a lot of effort, quite a lot of work to get everything recorded and edited and put together for you, the listener. So I greatly appreciate anybody who listens to it all the way through. I hope I'm not the only one who ever whoever actually finishes this episode. And for those of you who do listen to the episode all the way through, we're doing something a little bit different today. I have invited a friend of mine on to join me for the thoughts and opinions section of the episode after I've finished reading through all of the justices' opinions in the case. And he tends to have quite different views on a lot of things than I do, so it should be a little bit more interesting to listen to than just me talking at you about what I think. So, with that said, I won't take up any more of your time on this stuff, and we can get into the episode. In episode 25 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Learning Resources versus Trump. The case was decided February 20th, 2026. And as always, we will begin with the syllabus. The question presented is whether the International Emergency Economic Powers Act, IEEPA, authorizes the president to impose tariffs. Shortly after taking office, President Trump sought to address two foreign threats: the influx of illegal drugs from Canada, Mexico, and China, and large and persistent trade deficits. The president determined that the drug influx had created a public health crisis and that the trade deficits had led to the hollowing out of the American manufacturing base and undermined critical supply chains. The president declared a national emergency as to both threats, deeming them unusual and extraordinary, and invoked his authority under IEEPA to respond. He imposed tariffs to deal with each threat. As to the drug trafficking tariffs, the president imposed a 25% duty on most Canadian and Mexican imports and a 10% duty on most Chinese imports. As to the trade deficit reciprocal tariffs, the president imposed a duty on all imports from all trading partners of at least 10%, with dozens of nations facing higher rates. Since imposing each set of tariffs, the president has issued several increases, reductions, and other modifications. Petitioners in Learning Resources and respondents in VOS Selections filed suit, alleging that IEEPA does not authorize the reciprocal or drug trafficking tariffs. The Learning Resources plaintiffs, two small businesses, sued in the United States District Court for the District of Columbia. That court denied the government's motion to transfer the case to the United States Court of International Trade, CIT, and granted the plaintiffs' motion for a preliminary injunction, concluding that IEEPA did not grant the president the power to impose tariffs. The VOS Selections plaintiffs, 5 small businesses and 12 states, sued in the CIT. That court granted summary judgment for the plaintiffs, and the Federal Circuit, sitting en banc, affirmed in relevant part, concluding that IEEPA's grant of authority to regulate importation did not authorize the challenged tariffs, which are unbound in scope, amount, and duration. The government filed a petition for certiorari in VOS Selections, and the Learning Resources plaintiffs filed a petition for certiorari before judgment. The court granted the petitions and consolidated the cases. Held: IEEPA does not authorize the president to impose tariffs. The judgment in case number 24-1287 is vacated, and the case is remanded with instructions to dismiss for lack of jurisdiction. The judgment in case number 25-250 is affirmed. The following is still part of the syllabus. The Chief Justice delivered the opinion of the court with respects to Parts 1 and 2A1. Article 1, Section 8 of the Constitution specifies that the Congress shall have power to lay and collect taxes, duties, imposts, and excises. The framers recognized the unique importance of the taxing power, a power which very clearly includes the power to impose tariffs. And they gave Congress alone access to the pockets of the people. The framers did not vest any part of the taxing power in the executive branch. The government thus concedes that the president enjoys no inherent authority to impose tariffs during peacetime. It instead relies exclusively on IEEPA to defend the challenged tariffs. It reads the words regulate and importation to effect a sweeping delegation of Congress's power to set tariff policy, authorizing the president to impose tariffs of unlimited amount and duration on any product from any country. The Chief Justice, joined by Justice Gorsuch and Justice Barrett, concluded in Part 2A2, the court has long expressed reluctance to read into ambiguous statutory text extraordinary delegations of Congress's powers. In several cases described as involving major questions, the court has reasoned that both separation of powers principles and a practical understanding of legislative intent suggest Congress would not have delegated highly consequential power through ambiguous language. These considerations apply with particular force where, as here, the purported delegation involves the core congressional power of the purse. Congressional practice confirms as much. When Congress has delegated its tariff powers, it has done so in explicit terms and subject to strict limits. Against that backdrop of clear and limited delegations, the government reads IEEPA to give the president power to unilaterally impose unbounded tariffs and change them at will. That view would represent a transformative expansion of the president's authority over tariff policy. It is also telling that in IEEPA's half-century of existence, no president has invoked the statute to impose any tariffs, let alone tariffs of this magnitude and scope. That lack of historical precedent, coupled with the breadth of authority that the president now claims, suggests that the tariffs extend beyond the president's legitimate reach. The economic and political significance of the authority the president has asserted likewise provides a reason to hesitate before concluding that Congress meant to confer such authority. The stakes here dwarf those of other major questions cases, and in those cases a reasonable interpreter would not expect Congress to pawn such a big-time policy call off to another branch. There is no exception to the major questions doctrine for emergency statutes, nor does the fact that tariffs implicate foreign affairs render the doctrine inapplicable. The framers gave Congress alone the power to impose tariffs during peacetime, and the foreign affairs implications of tariffs do not make it any more likely that Congress would relinquish its tariff power through vague language or without careful limits. Accordingly, the president must point to clear congressional authorization to justify his extraordinary assertion of that power. He cannot. The Chief Justice delivered the opinion of the court with respect to Part 2B, concluding, Part A. IEEPA authorizes the president to investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit importation or exportation. Section 1702A1B. Absent from this lengthy list of specific powers is any mention of tariffs or duties. Had Congress intended to convey the distinct and extraordinary power to impose tariffs, it would have done so expressly as it consistently has in other tariff statutes. The power to regulate importation does not fill that void. The term regulate, as ordinarily used, means to fix, establish, or control, to adjust by rule, method, or established mode, to direct by rule or restriction, to subject to governing principles or laws. The facial breadth of this definition places in stark relief what regulate is not usually thought to include: taxation. Many statutes grant the executive the power to regulate, yet the government cannot identify any statute in which the power to regulate includes the power to tax. The court is therefore skeptical that in IEEPA and IEEPA alone, Congress hid a delegation of its birthright power to tax within the quotidian power to regulate. While taxes may accomplish regulatory ends, it does not follow that the power to regulate includes the power to tax as a means of regulation. Indeed, when Congress addresses both the power to regulate and the power to tax, it does so separately and expressly. That it did not do so here is strong evidence that regulate in IEEPA does not include taxation. A contrary reading would render IEEPA partially unconstitutional. IEEPA authorizes the President to regulate importation or exportation, but taxing exports is expressly forbidden by the Constitution. The neighboring words with which regulate is associated also suggest that Congress did not intend for regulate to include the revenue-raising power. Each of the 9 verbs in Section 1702A1B authorizes a distinct action a president might take in sanctioning foreign actors or controlling domestic actors engaged in foreign commerce, as presidential practice confirms. And none of the listed authorities includes the distinct and extraordinary power to raise revenue, a power which no president has ever found in IEEPA. Part B. Several arguments marshaled in response are unpersuasive. First, the contention that IEEPA confers the power to impose tariffs because early commentators and the court's cases discuss tariffs in the context of the Commerce Clause answers the wrong question. The question is not whether tariffs can ever be a means of regulating commerce. It is instead whether Congress, when conferring the power to regulate importation, gave the president the power to impose tariffs at his sole discretion. And Congress's pattern of usage is plain. When Congress grants the power to impose tariffs, it does so clearly and with careful constraints. It did neither in IEEPA. Second, the argument that regulate naturally includes tariffs because the term lies between 2 poles in IEEPA, compel on the affirmative end and prohibit on the negative end, is unavailing. Although tariffs may be less extreme than an outright compulsion or prohibition, it does not follow that tariffs lie on the spectrum between those poles. They are different in kind, not degree, from the other authorities in IEEPA. Tariffs operate directly on domestic importers to raise revenue for the Treasury and are very clearly a branch of the taxing power. Thus, they fall outside the spectrum entirely. Third, the argument based on IEEPA's predecessor, the Trading with the Enemy Act, and the Court of Customs and Patent Appeals decision in United States v. Yoshida International, Inc., cannot bear the weight placed on it. A single expressly limited opinion from a specialized intermediate appellate court does not establish a well-settled meaning that the court can assume Congress incorporated into IEEPA. Fourth, the historical argument based on the court's wartime precedents fails. Those precedents are facially inapposite, as all agree the president lacks inherent peacetime authority to impose tariffs, and the attenuated chain of inferences from wartime precedents through multiple iterations of TWEA to IEEPA cannot support, much less clearly support, a reading of IEEPA that includes the distinct power to impose tariffs. Finally, arguments relying on this court's precedents lack merit. Federal Energy Administration versus Algonquin SNG Inc. bears little on the meaning of IEEPA. Section 232B of the Trade Expansion Act of 1962 contains sweeping, discretion-conferring language that IEEPA does not contain, and the explicit reference to duties in Section 232A renders it natural for Section 232B itself to authorize duties. Nor does Dames and Moore v. Reagan offer support because that case was exceedingly narrow, did not address the president's power to regulate, and did not involve tariffs at all. Justice Kagan, joined by Justice Sotomayor and Justice Jackson, agreed that IEEPA does not authorize the president to impose tariffs, but concluded that the court need not invoke the major questions doctrine because the ordinary tools of statutory interpretation amply support that result. Justice Jackson would also consult legislative history, in particular the House and Senate reports that accompanied IEEPA and its predecessor statute, TWEA, to determine that Congress did not intend for IEEPA to authorize the executive to impose tariffs. And now on to the opinions. Chief Justice Robert announced the judgment of the court and delivered the opinion of the court with respect to parts 1, 2A, 1, and 2B, in which Justices Sotomayor, Kagan, Gorsuch, Barrett, and Jackson joined, and an opinion with respects to Part 2A2 and 3, in which Justices Gorsuch and Barrett joined. We decide whether the International Emergency Economic Powers Act, IEEPA, authorizes the President to impose tariffs. Part 1, Section A. Shortly after taking office, President Trump sought to address two foreign threats. The first was the influx of illegal drugs from Canada, Mexico, and China. The second was large and persistent trade deficits. The president determined that the first threat had created a public health crisis, and that the second had led to the hollowing out of the American manufacturing base and undermined critical supply chains. He invoked his authority under IEEPA to respond. Enacted in 1977, IEEPA gives the president economic tools to address significant foreign threats. When acting under IEEPA, the president must identify an unusual and extraordinary threat to American national security, foreign policy, or the economy originating primarily outside the United States, and he must declare a national emergency under the National Emergencies Act. He may then, by means of instructions, licenses, or otherwise, take the following actions to deal with the threat: investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercising any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or a national thereof has any interest. President Trump declared a national emergency as to both the drug trafficking and trade deficits, which he deemed unusual and extraordinary threats. He then imposed tariffs to deal with each threat. As to the drug trafficking tariffs, the president imposed a 25% duty on most Canadian and Mexican imports and a 10% duty on most Chinese imports. As to the trade deficit or reciprocal tariffs, the president imposed a duty on all imports from all trading partners of at least 10%. Dozens of nations faced higher rates, and these tariffs applied notwithstanding any extant trade agreements. Since imposing each set of tariffs, the president has issued several increases, reductions, and other modifications. 1 month after imposing the 10% drug trafficking tariffs on Chinese goods, he increased the rate to 20%. 1 month later, he removed a statutory exemption for Chinese goods under $800. Less than a week after imposing the reciprocal tariffs, the president increased the rate on Chinese goods from 34% to 84%. The very next day, he increased the rate further still to 125%. This brought the total effective tariff rate on most Chinese goods to 145%. The president has also shifted sets of goods into and out of the reciprocal tariff framework. And he has issued a variety of other adjustments. Section B. Petitioners in learning resources and respondents in VOS selections filed suit, alleging that IEEPA does not authorize the reciprocal or drug trafficking tariffs. The learning resources plaintiffs, 2 small businesses, sued in the United States District Court for the District of Columbia. The VOS selections plaintiffs, 5 small businesses and 12 states, sued in the United States Court of International Trade, CIT. The government moved to transfer the learning resources case to the CIT. It argued that the district court lacked jurisdiction under 28 U.S.C. Section 1581 I-1, which gives the CIT exclusive jurisdiction of any civil action commenced against the government that arises out of any law of the United States providing for tariffs or their administration and enforcement. The district court denied that motion and granted the plaintiff's motion for a preliminary injunction, concluding that IEEPA did not grant the president the power to impose tariffs. In the VOS selections case, the CIT granted the plaintiff's motion for summary judgment. The Federal Circuit, sitting en banc, affirmed in relevant part. It first concluded that the CIT had exclusive jurisdiction because the plaintiff's claim arose out of modifications to the Harmonized Tariff Schedule of the United States, HTSUS. On the merits, it agreed with the CIT that IEEPA's grant of authority to regulate importation did not authorize the challenged tariffs, which are unbounded in scope, amount, and duration. Judge Cunningham concurred for 4 judges, reasoning that IEEPA did not authorize the president to impose any tariffs. Judge Taranto dissented for 4 judges, concluding that IEEPA authorized the challenged tariffs. The government filed a motion to expedite and a petition for certiorari in VOS selections, and the learning resources plaintiffs filed a petition for certiorari before judgment. We granted the motion and petitions and consolidated the cases. Footnote 1. We agree with the Federal Circuit that the VOS selections case falls within the exclusive jurisdiction of the CIT. The plaintiff's challenges arise out of modifications to the HTSUS, whereas here such modifications are made under an act affecting import treatment. They are considered to be statutory provisions of law for all purposes. Thus, the plaintiff's challenges arise out of a law of the United States providing for tariffs. For the same reasons, the United States District Court for the District of Columbia lacked jurisdiction in the learning resources case. Carrying on. Part 2. Based on two words separated by 16 others in Section 1702A1B of the IEEPA, Regulate and Importation, the President asserts the independent power to impose tariffs on imports from any country of any product at any rate for any amount of time. Those words cannot bear such weight. Section A, subsection 1. Article 1, Section 8 of the Constitution sets forth the powers of the legislative branch. The first clause of that provision specifies that the Congress shall have power to lay and collect taxes, duties, imposts, and excises. It is no accident that this power appears first. The power to tax was, Alexander Hamilton explained, the most important of the authorities proposed to be conferred upon the Union. It is both a power to destroy and a power necessary to the existence and prosperity of a nation, the one great power upon which the whole national fabric is based. The power to impose tariffs is very clearly a branch of the taxing power. A tariff, after all, is a tax levied on imported goods and services. And tariffs raise revenue, the defining feature of a tax. Indeed, the framers expected that the government would for a long time depend chiefly on tariffs for revenue. Little wonder, then, that the first Congress's first exercise of its taxing power and its second enacted law right after the one providing for the new officials to take an oath was a tariff law. Recognizing the taxing power's unique importance and having just fought a revolution motivated in large part by taxation without representation, the framers gave Congress alone access to the pockets of the people. They required all bills for raising revenue to originate in the House of Representatives, and in doing so they ensured that only the House could propose the supplies requisite for the support of the government, thereby reducing all the overgrown prerogatives of the other branches. They did not vest any part of the taxing power in the executive branch. The government thus concedes, as it must, that the President enjoys no inherent authority to impose tariffs during peacetime, and it does not defend the challenged tariffs as an exercise of the President's war-making powers. The United States, after all, is not at war with every nation in the world. The government instead relies exclusively on IEEPA. It reads the words regulate and importation to effect a sweeping delegation of Congress's power to set tariff policy, authorizing the President to impose tariffs of unlimited amount and duration on any product from any country. Subsection 2. We have long expressed reluctance to read into ambiguous statutory text extraordinary delegations of Congress's powers. In Biden v. Nebraska, for example, we declined to read authorization to waive or modify statutory or regulatory provisions applicable to financial assistance programs as a delegation of power to cancel $430 billion in student loan debt. In West Virginia v. EPA, we declined to read authorization to determine the best system of emission reduction as a delegation of power to force a nationwide transition away from the use of coal. And in National Federation of Independent Businesses v. OSHA, we declined to read authorization to ensure safe and healthful working conditions as a delegation of power to impose a vaccine mandate on 84 million Americans. We have described several of these cases as major questions cases. In each, the government claimed broad, expansive power on an uncertain statutory basis, and in each, the statutory text might, as a matter of definitional possibilities, have been read to delegate the asserted power. But context counseled skepticism. That context included not just other language within the statute, but constitutional structure and common sense. Both separation of powers principles and a practical understanding of legislative intent suggested Congress would not have delegated highly consequential power through ambiguous language. These considerations apply with particular force where, as here, the purported delegation involves the core congressional power of the purse. Congress would likely intend for itself the basic and consequential trade-offs inherent in uses of this most complete and effectual weapon. And if Congress were to relinquish that weapon to another branch, a reasonable interpreter would expect it to do so clearly. What common sense suggests, congressional practice confirms. When Congress has delegated its tariff powers, it has done so in explicit terms and subject to strict limits. Congress has consistently used words like duty in statutes delegating authority to impose tariffs. It has capped the amount and duration of tariffs, and it has conditioned exercise of the tariff power on demanding procedural prerequisites. Footnote 2. The same is true of Section 232 of the Trade Expansion Act of 1962, which we have held authorizes sector-specific import license fees. Section 232A expressly references duties, and Section 232C authorizes the President to adjust the imports of an article, but only after the Secretary of Commerce, in consultation with the Secretary of Defense, conducts an investigation and prepares a report finding that the article is being imported into the United States in such quantities or under such circumstances as to threaten to impair the national security. Carrying on. Against this backdrop of clear and limited delegations, the government reads IEEPA to give the President power to unilaterally impose unbounded tariffs. On this reading, moreover, the President is unconstrained by the significant procedural limitations in other tariff statutes and free to issue a dizzying array of modifications at will. All it takes to unlock that extraordinary power is a presidential declaration of emergency, which the government asserts is unreviewable. And the only way of restraining the exercise of that power is a veto-proof majority in Congress. That view, if credited, would represent a transformative expansion of the President's authority over tariff policy. And indeed, as demonstrated by the exercise of that authority in this case, over the broader economy as well. It would replace the long-standing executive-legislative collaboration over trade policy with unchecked presidential policymaking. It is also telling that in IEEPA's half-century of existence, no president has invoked the statute to impose any tariffs, let alone tariffs of this magnitude and scope. Footnote 3. Indeed, even before IEEPA was enacted, only one president relied on its predecessor, the Trading with the Enemy Act, TWEA, to impose tariffs, and then only as a post hoc defense to a legal challenge. Those tariffs were also of limited amount, duration, and scope. Carrying on. Presidents have, by contrast, regularly invoked IEEPA for other purposes. At the same time, they have invoked other statutes, but never IEEPA, to impose tariffs on products ranging from car tires to washing machines. And those tariffs did not even begin to approach the size or scope of the IEEPA tariffs at issue here. The lack of historical precedent for the IEEPA tariffs, coupled with the breadth of authority that the President now claims, is a telling indication that the tariffs extend beyond the President's legitimate reach. The economic and political significance of the authority the President has asserted likewise provides a reason to hesitate before concluding that Congress meant to confer such authority. The President's assertion here of broad statutory power over the national economy is extravagant by any measure, and as the government admits, indeed boasts, the economic and political consequences of the IEEPA tariffs are astonishing. The government points to projections that the tariffs will reduce the national deficit by $4 trillion, and that international agreements reached in reliance on the tariffs could be worth $15 trillion. In the President's view, whether we are a rich nation or a poor one hangs in the balance. These stakes dwarf those of other major questions cases. As in those cases, a reasonable interpreter would not expect Congress to pawn such a big-time policy call off to another branch. The government and the principal dissent attempt to avoid application of the major questions doctrine on several grounds. None is convincing. The government argues first that the doctrine should not apply to emergency statutes, but this argument is nearly identical to one it already advanced in Nebraska. There, the government contended that a different emergency statute should be interpreted broadly because its whole point was to provide substantial discretion to respond to unforeseen emergencies. We rejected that argument in Nebraska, and we reject it here as well. Emergency powers, after all, tend to kindle emergencies. Dozens of IEEPA emergencies remain ongoing today, including the first, declared over 4 decades ago in response to the Iranian hostage crisis. And as the framers understood, emergencies can afford a ready pretext for usurpation of congressional power. Where Congress has reason to be worried about its powers slipping through its fingers, we in turn have every reason to expect Congress to use clear language to effectuate unbounded delegations, particularly of its one great power. The government's and the principal dissent's proposed foreign affairs exception fares no better. As a general matter, the President, of course, enjoys some independent constitutional powers over foreign affairs even without congressional authorization, and Congress certainly may intend to give the President substantial authority and flexibility in many foreign affairs or national security contexts. But flipping the presumption under the major questions doctrine makes little sense when it comes to tariffs, as the government admits the President and Congress do not enjoy concurrent constitutional authority to impose tariffs during peacetime. The framers gave that power to Congress alone, notwithstanding the obvious foreign affairs implications for tariffs. And whatever may be said of other powers that implicate foreign affairs, we would not expect Congress to relinquish its tariff power through vague language or without careful limits. The central thrust of the government's and the principal dissent's proposed exceptions appears to be that ambiguous delegations in statutes addressing the most major of major questions should necessarily be construed broadly. But it simply does not follow from the fact that a statute deals with major problems that it should be read to delegate all major powers for which there may be a colorable textual basis. It is in precisely such cases that we should be alert to claims that sweeping delegations, particularly delegations of core congressional powers, lurk in ambiguous statutory text. There is no major questions exception to the major questions doctrine. Accordingly, the President must point to clear congressional authorization to justify his extraordinary assertion of the power to impose tariffs. He cannot. Section B. To begin, IEEPA authorizes the President to investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent or prohibit, importation or exportation. Absent from this lengthy list of powers is any mention of tariffs or duties. That omission is notable in light of the significant but specific powers Congress did go to the trouble of naming. It stands to reason that had Congress intended to convey the distinct and extraordinary power to impose tariffs, it would have done so expressly, as it consistently has in other tariff statutes. The power to regulate importation does not fill that void. Regulate, as that term is ordinarily used, means to fix, establish, or control, to adjust by rule, method, or establish mode, to direct by rule or restriction, to subject to governing principles or laws. This definition captures much of what a government does on a day-to-day basis. Indeed, if regulate is as broad as the principal dissent suggests, then the other 8 verbs in section 1702A1b are simply wasted ink. But the facial breadth of regulate places in stark relief what the term is not usually thought to include: taxation. The U.S. Code is replete with statutes granting the executive the authority to regulate someone or something. Yet the government cannot identify any statute in which the power to regulate includes the power to tax. The government concedes, for example, that the Securities and Exchange Commission cannot tax the trading of securities, even though it is expressly authorized to regulate the trading of securities. We are therefore skeptical that in IEEPA and IEEPA alone, Congress hid a delegation of its birthright power to tax within the quotidian power to regulate. Taxes, to be sure, may accomplish regulatory ends, but it does not follow that the power to regulate something includes the power to tax it as a means of regulation. Congressional practice suggests as much. When Congress addresses both the power to regulate and the power to tax, it does so separately and expressly. That is unsurprising, as the power to regulate commerce is entirely distinct from the right to levy taxes. That Congress did not grant those authorities separately here is strong evidence that regulate in IEEPA does not include taxation. A contrary reading would render IEEPA partially unconstitutional. IEEPA authorizes the President to regulate importation or exportation. Taxing exports, however, is expressly forbidden by the Constitution. The neighboring words with which regulate is associated also suggest that Congress did not intend for regulate to include the revenue-raising power. Regulate is one of 9 verbs listed in Section 1702A1B. Each authorizes a distinct action the President might take in sanctioning foreign actors or controlling domestic actors engaged in foreign commerce, blocking imports, for example, or prohibiting transactions. Presidential practice under IEEPA demonstrates as much. None of IEEPA's authorities includes the distinct and extraordinary power to raise revenue, and the fact that no president has ever found such power in IEEPA is strong evidence that it does not exist. We do not attempt to set forth the metes and bounds of the president's authority to regulate importation under IEEPA. That interpretive question is not at issue in this case, and any answer would be plain dicta. Our task today is to decide only whether the power to regulate importation as granted to the President in IEEPA embraces the power to impose tariffs. It does not. Footnote 4. The principal dissent surmises that the President could impose most, if not all, of the tariffs at issue under statutes other than IEEPA. The cited statutes contain various combinations of procedural prerequisites, required agency determinations, and limits on the duration, amount, and scope of the tariffs they authorize. We do not speculate on hypothetical cases not before us. Carrying on. The government, echoed point for point by the principal dissent, marshals several arguments in response. First, it contends that IEEPA confers the power to impose tariffs because early commentators and this court's cases discuss tariffs in the context of the Constitution's Commerce Clause. But that answers the wrong question. The question is not, as the government would have it, whether tariffs can ever be a means of regulating commerce. It is instead whether Congress, when conferring the power to regulate importation, gave the President the power to impose tariffs at his sole discretion. And Congress's pattern of usage is most relevant to answering that question. That pattern is plain. When Congress grants the power to impose tariffs, it does so clearly and with careful constraints. It did neither here. The government raises another contextual argument. Because regulate lies between 2 poles in IEEPA, compel on the affirmative end and prohibit on the negative end, the term naturally includes the less extreme, more flexible tool of tariffs. But tariffs, as discussed above, are different in kind, not degree, from the other authorities in IEEPA. Unlike those authorities, tariffs operate directly on domestic importers to raise revenue for the Treasury. Even though a tariff is, in some sense, less extreme than an outright compulsion or prohibition, it does not follow that tariffs lie on the spectrum between those poles. They are instead very clearly a branch of the taxing power, and fall outside the spectrum entirely. Finding no support in the statute the President invoked, the government turns to one he did not, IEEPA's predecessor, TWEA. In 1975, the Court of Customs and Patent Appeals held that the authority to regulate importation in TWEA authorized the President Nixon to impose limited tariffs. When Congress enacted IEEPA 2 years later, the government contends it conveyed that same authority except without the limits. This argument cannot bear the weight the government places on it. While this court sometimes assumes that Congress incorporates judicial definitions into legislation, we do so only when the term's meaning was well settled before the adoption. A single expressly limited opinion from a specialized intermediate appellate court does not clear that hurdle. Footnote 5. The government, citing the IEEPA House Committee report, contends that Congress indisputably knew of Yoshida's interpretation of TWEA, but even taking the report at face value, it hardly helps the government. The report explains that successive presidents have seized upon the open-endedness of TWEA Section 5B to turn that section through usage into something quite different from what was envisioned in 1917. That is not exactly a stamp of approval on the action Yoshida guardedly endorsed. In any event, the government's knew of standard falls well short of the broad and unquestioned judicial consensus we have required to conclude that Congress incorporated a judicial definition into a statutory term. Carrying on. The tariff authority asserted by President Nixon, moreover, was far removed from TWEA's original purposes of sanctioning foreign belligerents. We are therefore skeptical that Congress enacted IEEPA with an eye towards granting that novel power. The government has another historical argument based on this court's wartime precedents. According to the government, those precedents acknowledge an inherent presidential power to impose tariffs during armed conflict, and, the argument goes, Congress in TWEA and then in IEEPA codified those precedents, but this argument fails at both steps. Insofar as the government relies on our wartime cases themselves, they are facially inapposite. Regardless of what they might mean for the president's inherent wartime authority, all agree that the president has no inherent peacetime authority to impose tariffs, nor are we persuaded that the dots connect from our wartime precedents through multiple iterations of TWEA to IEEPA such that IEEPA should be interpreted to grant the president an expansive peacetime tariff power. This argument relies extensively on a series of inferences drawn from scant legislative history. Such an attenuated chain cannot support, much less clearly support, a reading of IEEPA that includes the distinct power to impose tariffs. Turning to this court's precedents, the government first relies on Federal Energy Administration versus Algonquin S&G Inc. There we held that Section 232B of the Trade Expansion Act of 1962, which allows the president to adjust the imports of particular goods to protect national security, includes the power to impose license fees. But that holding bears little on the meaning of IEEPA. As a textual matter, Section 232B authorizes the president not only to adjust imports, but, as the government emphasized in Algonquin, to take such action as he deems necessary to adjust the imports of a good. IEEPA does not contain such sweeping, discretion-conferring language. As for context, Section 232A states that no action shall be taken to decrease or eliminate an existing duty or other import restriction if doing so would threaten national security. This explicit reference to duties preceding Section 232B renders it natural for Section 232B itself to authorize duties. Thus, we decline to extend Algonquin's expressly limited holding any further. Finally, the government invokes Dames and Moore versus Reagan, but that case offers no support. Dames and Moore was exceedingly narrow, did not address the president's power to regulate, and did not involve tariffs at all. Footnote 6. There's a number of citations to quotes from the opinion emphasizing its narrowness. This is not quite a no, 1,000 times no, but should have sufficed to dissuade the principal dissent from invoking the case with respect to the quite distinct legal and factual issues present here. Carrying on. If anything, that case highlights the importance of close attention to IEEPA's text. The terms of IEEPA we held do not authorize the suspension of claims. So too here, the terms of IEEPA do not authorize tariffs. Part 3. The President asserts the extraordinary power to unilaterally impose tariffs of unlimited amount, duration, and scope. In light of the breadth, history, and constitutional context of that asserted authority, he must identify clear congressional authorization to exercise it. IEEPA's grant of authority to regulate importation falls short. IEEPA contains no reference to tariffs or duties. The government points to no statute in which Congress used the word regulate to authorize taxation. And until now, no president has read IEEPA to confer such power. We claim no special competence in matters of economics or foreign affairs. We claim only, as we must, the limited role assigned to us in Article 3 of the Constitution. Fulfilling that role, we hold that IEEPA does not authorize the President to impose tariffs. The judgment of the United States Court of Appeals for the Federal Circuit in case number 25-250 is affirmed. The judgment of the United States District Court for the District of Columbia in case number 24-1287 is vacated, and the case is remanded with instructions to dismiss for lack of jurisdiction. It is so ordered. Justice Gorsuch concurring. The President claims that Congress delegated to him an extraordinary power in the International Emergency Economic Powers Act, IEEPA, the power to impose tariffs on practically any products he wants, from any country he chooses, in any amount he selects. Applying the major questions doctrine, the principal opinion rejects that argument. I join in full. The Constitution lodges the nation's lawmaking powers in Congress alone, and the major questions doctrine safeguards that assignment against executive encroachment. Under the doctrine's terms, the President must identify clear statutory authority for the extraordinary delegated power he claims, and as the principal opinion explains, that is a standard he cannot meet. Whatever else might be said about Congress's work in IEEPA, it did not clearly surrender to the President the sweeping tariff power he seeks to wield. Not everyone sees it this way. Past critics of the major questions doctrine do not object to its application in this case, and they even join much of today's principal opinion. But they insist they can reach the same result by employing only routine tools of statutory interpretation. Meanwhile, one colleague who joins the principal opinion in full suggests the major questions doctrine is nothing more than routine statutory interpretation. Still others who have joined the major questions decisions in the past dissent from today's application of the doctrine. Finally, seeking to sidestep the major questions doctrine altogether, one colleague submits that Congress may hand over to the President most of its powers, including the tariff power, without limit. It is an interesting turn of events. Each camp warrants a visit. Part 1. Start with the critics. In the past, they have criticized the major questions doctrine for two main reasons. The doctrine they have suggested is a novelty without basis in law, and they have argued the doctrine is rooted in an anti-administrative state stance that prevents Congress from employing executive agency officials to do important work. Today, the critics proceed differently. They join a section of the principal opinion that applies the major questions doctrine. And rather than critique the doctrine, they say only that it is unnecessary in this case because ordinary principles of statutory interpretation lead to the same result. Section A. Unpack that last claim first. My concurring colleagues contend that as a matter of straight-up statutory construction, IEEPA does not grant the President the power to impose tariffs. In doing so, they make thoughtful points about the statute's text and context, but their approach today is difficult to square with how they have interpreted other statutes. Dissenting in past major questions cases, they have argued that broad statutory language granting powers to executive officials should be read for all it is worth. Yet now, when it comes to IEEPA's similarly broad language granting powers to the President, they take a more constrained approach. Consider some examples of how they have proceeded in the past. Dissenting in National Federation of Independent Business versus OSHA, two of my concurring colleagues confronted a statute charging the Occupational Safety and Health Administration with promoting safe and healthful working conditions. They read that language as authorizing the agency to impose a vaccine mandate on 84 million Americans. In support of their reading, my colleagues stressed the statute's expansive language, another provision authorizing the agency to issue temporary emergency standards, and the scope of the crisis the agency was trying to address. Dissenting in Alabama Association of Realtors versus Department of Health and Human Services, my colleagues addressed a statute permitting the Centers for Disease Control and Prevention to issue regulations necessary to prevent the transmission of communicable diseases. As they saw it, those terms granted the agency the power to regulate landlord-tenant relations nationwide during COVID-19. In reaching this conclusion, my colleagues again highlighted the statute's broad language and suggested that it permitted the agency to impose even greater restrictions than the one at issue in the case. Dissenting in West Virginia, my colleagues faced a statute allowing the Environmental Protection Agency to ensure power plants employ the best system of emissions reduction. They read that provision as authorizing the agency to effectively close many power plants and transform the electricity industry from coast to coast. In support, they once more argued that the statutory language was broad and expansive, with no ifs and or buts. They stressed, too, that the relevant statutory terms appeared in major legislation intended to address big problems, and that the statute authorized actions in the agency's traditional lane or wheelhouse. Finally, dissenting in Biden versus Nebraska, my colleagues took up a statute permitting the Secretary of Education to waive or modify any statutory or regulatory provision applying to a federal student loan program during a national emergency. They said that language allowed the Secretary to cancel $430 billion in federal student loan debt because of COVID-19. Once again, they argued that the statutory terms were broad, expansive, capacious, and designed to afford the Secretary a potent power to respond to national emergencies that were major in scope. Now compare all that to how my colleagues proceed here. This case, they say, is nearly the opposite. While straight-up statutory interpretation granted executive officials all the power they sought in those other cases, my colleagues insist this one is different because IEEPA simply does not give the president the power he wants. That's a striking turn given the statutory terms before us. When the president declares a national emergency to deal with any unusual and extraordinary threat to the national security, foreign policy, or economy of the United States, IEEPA permits him to regulate importation of any property in which any foreign country or a national thereof has any interest. Surely the authority granted here is broad and expansive. It has no ifs, ands, or buts either. But as a matter of ordinary meaning, the term regulate means to fix, establish, or control, adjust by rule, method, or established mode, direct by rule or restriction, or subject to governing principles or laws. They fix rules that control, adjust, or govern imports of property in which any foreign country or a national thereof has any interest. Without question, IEEPA is also major legislation to address big problems and crises. By its terms, the statute applies only during declared national emergencies involving threats to the national security, foreign policy, or economy of the United States, and it tasks the president personally with responding to those emergencies, a responsibility surely more in his lane or wheelhouse than that of any other executive official. Notably, too, IEEPA grants the president the power to impose even greater restrictions than tariffs, because the statute also permits him to nullify, prevent, and void imports. Why do my concurring colleagues read IEEPA so much more narrowly than they have other broad statutory terms found in other major legislation addressing other emergencies? They say contextual clues justify a narrowing construction here. But what the concurrence calls context looks remarkably like the major questions doctrine's rule that when executive branch officials claim Congress has granted them an extraordinary power, they must identify clear statutory authority for it. Take some examples. The concurrence points to the unparalleled authority the president asserts to impose a tariff of any amount for any time on only his own say-so. In other words, the president claims an extraordinary power. The concurrence observes that no president until now has understood IEEPA to authorize imposing tariffs. In other words, the power is an unheralded one. Along the way, the concurrence also adds a modicum of common sense about how Congress typically delegates and consideration of whether Congress ever has before or likely would delegate the power the executive asserts. In other words, the statutory text must be read in light of separation of powers principles. Having borrowed all those concepts from the major questions doctrine, the concurrence then turns to the key statutory terms before us, regulate importation, and observes that they say nothing, or at least not expressly, about imposing tariffs. And why is that fatal to the president's case? Because the president is attempting to exercise the core congressional power over taxes and tariffs, a power Article 1 of the Constitution vests in Congress alone. If my colleagues all but apply the major questions doctrine today, maybe they are simply recognizing what they have in other separation of powers cases involving the delegation of legislative power, that the guidance needed is greater when the executive branch seeks to take actions that will affect the entire national economy. Or maybe my colleagues believe the power the president asserts here outstrips even those powers executive officials asserted in our past major questions cases. But whatever the case, my concurring colleague's course today suggests that skeptics owe the major questions doctrine a second look. All of which leads me to take up the challenges they have posed to it in the past. Is the doctrine really some special canon that has only recently magically appeared? And is it really grounded in an anti-administrative state stance that prevents Congress from using executive branch officials to perform important work? Section B. The major questions doctrine teaches that to sustain a claim that Congress has granted them an extraordinary power, executive officials must identify clear authority for that power. Far from a novelty, much the same principle has long applied to those who claim extraordinary delegated authority, whether in private or public law. Subsection 1. Examples stretch across many fields. Consider first the common law of corporations. In early modern England, corporations could be formed only with an explicit ex ante and direct authorization. That authorization could be given by the Crown, an Act of Parliament, or a combination of the two. Some of these corporations exercised regulatory functions not unlike those performed by modern administrative agencies. Indeed, the initial settlements in Virginia and Massachusetts Bay, among others, were structured as corporations. English law treated these corporations as having authority to issue bylaws, but that authority was subject to restrictions, one of which was that the corporations could not regulate on major subjects without express authorization. Take Kirk versus Nowill. That case involved the Company of Cutlers, a corporation for makers of knives and other cutlery. An Act of Parliament gave the company broad authority to regulate its members. The company used that authority to adopt a bylaw allowing its officials to enter its members' workshops and warehouses and search for deceitful and unworkmanly cutlery. After the company seized supposedly unworkmanly forks, the aggrieved owner challenged the company's actions in court, arguing that the bylaw under which it acted was bad in point of law because the power to incur a forfeiture was not expressly given to the company by Act of Parliament. Applying a clear statement rule, the King's Bench declared the bylaw and therefore the seizure unlawful. Lord Mansfield explained that the power of making bylaws to incur a forfeiture was an extraordinary power over and above the default powers of corporations created by charter. For this reason, the power needed to be expressly given by the company's progenitor, Parliament. Since no such power had been clearly conferred, the seizure was unlawful. The same principle applied in American law. In re-election of directors of Long Island R Company, a New York court addressed a case involving 2,700 shares of stock in the Long Island Railroad Company that the company had declared forfeited. All agreed that the company had broad power to regulate its shares. Still, the court called the forfeiture an extraordinary penalty and held that no such power had been expressly conferred on the corporation by its charter. In fact, the court borrowed the clear statement rule from Nowill. If extraordinary authority is intended to be given, it must be by express words to that effect. The court in Ex parte Burnett proceeded similarly. That case involved the incorporated town of Cahaba, Alabama. The town set the price of a liquor license at $1,000, fined James Burnett for failing to obtain one, and eventually imprisoned him for not paying the fine. Burnett sought a writ of habeas corpus and argued that Cahaba had acted beyond the scope of its corporate authority. Without a clear statement rule, Burnett's argument would have stood little chance. That's because the town's charter granted it the authority to make and establish all such rules, bylaws, and ordinances respecting the streets, markets, buildings, and police of said town that shall appear to them requisite and necessary for the security, welfare, and convenience of said town, or for preserving the health, peace, order, and good government within the same. The charter even specifically gave the town the privilege of granting licenses for retailing of spirituous and other liquors. Semantically, the town's power was broad indeed and encompassed liquor licensing, but the court sided with Burnett anyway, reasoning that the town's exorbitant licensing fee effectively banned the sale of liquor. The court held that Cahaba did not enjoy such extraordinary prohibitory power because it was not authorized by any express grant of power in the town's charter. These cases are not outliers. Treatises confirm that the extraordinary power principle was fundamental to municipal corporations. A statute could not by implication invest a body with any extraordinary authority. Extraordinary powers required express words to that effect, and any fair, reasonable doubt concerning the existence of power was resolved by the courts against the corporation, and the power was denied. The takeaway is simple enough. Early corporations often functioned much like today's executive branch, exercising delegated regulatory authority, and when interpreting the scope of that authority, the common law had a clear statement rule that looks strikingly like the major questions doctrine. Historically, a similar precept applied in agency law. As the leading early American treatise put it, instruments conferring powers of attorney were ordinarily subjected to a strict interpretation. So, for example, in Atwood v. Munnings, a principal had delegated broad power to an agent to act generally for him and in his name, including in all things as should be requisite, expedient, and advisable to be done in his affairs and concerns, and as he might or could do if personally acting therein. The agent then accepted certain debts on behalf of the principal. The question for the court was whether this action was within the scope of the agent's authority. The court said no. Powers of attorney are instruments to be construed strictly, and the power of attorney contained no express power to accept debts, so no such power had been given. Other examples abound. A power to sell casks of whiskey did not include the unusual and extraordinary power to offer a warranty against future seizures of the casks unless guaranteed by express authority. Under power of attorney, authority to enter contracts for a principal was subject to strict interpretation and generally did not authorize contracts of an extraordinary character outside those connected with the principal's ordinary business. And a power to manage a mine did not authorize an agent to borrow money for the mine's operations on the principal's credit because there was no express authority for such a departure from the usual manner of running a mine. This was true even in cases of necessity, where the manager borrowed funds to address an emergency suddenly arising. Much the same principle applied to executive officials. Often, the legality of an executive action depended on the relationship between the size of the asserted power and the clarity of the underlying legal authority. Entick v. Carrington offers an illustration. There, as part of an investigation for seditious libel, the English Secretary of State claimed authority to issue a warrant for the seizure of an author's papers. Lord Camden declared the seizure unlawful, reasoning that the power asserted by the executive ought to be as clear as it is extensive. Or, as another reporter described Camden's decision, one should naturally expect that the law to warrant the exercise of power should be clear in proportion as the power is exorbitant. The seizure represented an extraordinary exercise of power, Lord Camden found, and no legal authority clearly authorized it. Accordingly, the warrant was unlawful and the seizure could not stand. Subsection 2. Perhaps unsurprisingly given this history, American courts applied the extraordinary power principle when Congress and the states started delegating new regulatory powers to executive agencies in the late 19th century. Take railroad commissions. After the Civil War, governments worried about the increasing power of railroad companies responded by creating new agencies and imbuing them with broad regulatory authority. These bodies were among the first modern administrative agencies. And when they claimed some extraordinary delegated power, both state and federal courts enforced a clear statement rule. The railroad commissions may have been the first, but they were not the last. Whether executive officials claimed the power to criminally punish noncompliance with regulations, force employers to retain employees regardless of their unlawful conduct, or regulate intrastate candy sales, this court held them to much the same standard. Because their claimed powers were so substantial, executive officials had to identify a distinct authority for them. A clear legislative basis, a definite and unmistakable expression, or a clear mandate. It is no mystery why the court proceeded this way when interpreting legislative directions to the executive branch. Article 1 of the Constitution vests all federal legislative power in Congress, and Article 2 charges the executive branch with seeing that Congress's laws are faithfully executed. In a very real sense, then, when it comes to legislative power, Congress is the principal and executive officials are the agents. So what is the basis for the charge that the major questions doctrine represents some magical innovation? Part of the answer may have to do with the fact that in the latter half of the 20th century, this court began experimenting with a very different approach. The court pushed aside its long-held skepticism of claims of extraordinary delegated powers and began affirmatively encouraging them. Chevron deference is just one example of this phenomenon, though a stark one. That case established a presumption that was nearly the opposite of the major questions doctrine. When Congress failed to speak clearly, courts put a thumb on the scale in favor of delegated power. Given that development, the long-standing principles animating the major questions doctrine may have receded from view for a time. After all, the two doctrines often applied in the same cases and counseled opposite results. But with Chevron gone, so is the conflict. This court's application of the major questions doctrine is not invention so much as return to form. Section C. Now turn to my concurring colleague's other charge, that the major questions doctrine is premised on an anti-administrative state stance. It is important, they argue, to allow Congress to delegate expansive powers. Members of Congress, unfortunately, often don't know enough, and know they don't know enough, to regulate sensibly on an issue. Nor can Congress easily anticipate changing circumstances. For these reasons, members of Congress must rely on more adept and less constrained people found in agencies. Indeed, my colleagues say, administrative delegations have helped to build a modern nation. And the major questions doctrine, they worry, could jeopardize that astonishing progress. This policy complaint, of course, is no reason to disregard our precedents or long-standing legal principles, but even taken on its own terms, it is a bit perplexing. The major questions doctrine is not anti-administrative state. It is pro-Congress. Common law courts understood that few written instruments can anticipate every eventuality and that principles sometimes draft broad delegation language to account for this. At the same time, courts appreciated the corresponding risk that delegees could easily exploit loose language in their commissions for their own benefit and to the detriment of those they purported to serve. So, common law courts often strictly construed delegated powers, not because they were anti-delegee, but because they were pro-principle. The major questions doctrine performs a similar function. Article 1 vests all federal legislative power in Congress, but like any written instrument, federal legislation cannot anticipate every eventuality, a point my concurring colleagues have observed in the past. And highly resourceful members of the executive branch have strong incentives to exploit any doubt in Congress's past work to assume new power for themselves. The major questions doctrine helps prevent that kind of exploitation. Our founders understood that men are not angels, and we disregard that insight at our peril when we allow the few, or the one, to aggrandize their power based on loose or uncertain authority. We delude ourselves too if we think that power will accumulate safely and only in the hands of dispassionate people found in agencies. Even if unelected agency officials were uniquely immune to the desire for more power, an unserious assumption, they report to elected presidents who can claim no such modesty. Another feature of our separation of powers makes the major questions doctrine especially salient. When a private agent oversteps, a principal may fix that problem prospectively by withdrawing the agent's authority. Under our Constitution, the remedy is not so simple. Once this court reads a doubtful statute as granting the executive branch a given power, that power may prove almost impossible for Congress to retrieve. Any president keen on his own authority, and again, what president isn't, will have a strong incentive to veto legislation aimed at returning the power to Congress. Perhaps Congress can use other tools, including its appropriation authority, to influence how the president exercises his new power. Maybe Congress can sometimes even leverage those tools to induce the president to withhold a veto. But retrieving a lost power is no easy business in our constitutional order. And without doctrines like major questions, our system of separated powers and checks and balances threatens to give way to the continual and permanent accretion of power in the hands of one man. That is no recipe for a republic. This case offers an example of the problem. Article 1 grants Congress, not the President, the power to impose tariffs. Still, the President claims Congress passed that power on to him in IEEPA, permitting him to impose tariffs on nearly any good he wishes, in any amount he wishes, based on emergencies he himself has declared. He insists as well that his emergency declarations are unreviewable. A ruling for him here, the President acknowledges, would afford future presidents the same latitude he asserts for himself. So another president might impose tariffs on gas-powered automobiles to respond to climate change, or really on virtually any imports for any emergency any president might perceive. And all of these emergency declarations would be unreviewable. Just ask yourself, what president would willingly give up that kind of power? I recognize the concerns about the major questions doctrine, but it is not so novel as some have supposed, and it serves Article 1 values we all share. My concurring colleagues all but endorse it today. I hope past skeptics will give it another look. Part 2. Now turn to the second camp. If some have criticized the major questions doctrine, others have responded by seeking to soften its blow. Though joining today's principal opinion, holding that clear statutory authority is required to sustain the exercise of an extraordinary power, Justice Barrett has suggested that the major questions doctrine might be reconceived. On her view, the doctrine need not be understood as a substantive canon designed to enforce Article 1's vesting clause, a value external to a statute. Instead, the doctrine might be thought of as a common-sense principle of communication that counsels skepticism when executive officials claim extraordinary powers derived from Congress. It is a thoughtful effort, but I harbor doubts. For one thing, there is no need to reconceive our doctrine. Past critics all but apply the doctrine today, and their previous criticisms fall flat. For another, this gloss on our major questions doctrine presents problems. Common sense principles of communication do not explain many of our major questions cases, this one included, and if common sense really does go so far as to embrace a rule counseling skepticism of claims by executive officials that Congress has granted them extraordinary powers, that is common sense in name only. The reason for such skepticism must be Article 1, a substantive source external to any statute. Section A. Introducing her view that common sense principles of communication can sometimes help resolve disputes over the meaning of statutory terms, Justice Barrett points to an old chestnut. Suppose a legislature used the phrase, "whoever drew blood in the streets" in a criminal statute imposing punishment. As a matter of common sense, Justice Barrett says, it would go without saying that the law doesn't apply to a surgeon accessing a patient's vein to save his life. That is because the phrase "drew blood" is susceptible to two conventional idiomatic meanings, one applicable to violent encounters with man or beast, and the other to medical procedures. And any ordinary person faced with that phrase in a penal law would find it obvious which meaning applies. The difficulty is our major questions cases are different. Often little about them goes without saying. Take FDA versus Brown and Williamson Tobacco Corporation. There, the question was whether the FDA could regulate tobacco products. Looking only to common sense, the answer would have been yes. Congress authorized the FDA to regulate drugs, which Congress defined expressly and broadly as articles other than food intended to affect the structure or any function of the body. As a matter of common sense, nicotine qualifies as a drug based on this statutory definition, as it might even as a matter of everyday speech. Still, we held the FDA could not regulate tobacco products. Other cases follow suit. We have ruled that the term air pollutant does not include greenhouse gases, even though greenhouse gases pollute the air. We have held that the phrase regulations necessary to prevent the spread of communicable diseases does not include eviction moratoriums, even without questioning that eviction moratoriums were necessary to prevent the spread of COVID-19, a communicable disease. And we have said that closing coal power plants is not the best system of emission reduction, even while acknowledging that closing them would reduce emissions. None of these cases can be readily explained by common sense principles of communication. None involved a phrase like "drew blood" susceptible to two conventional idiomatic meanings, one of which any English speaker faced with the law at issue might quickly rule out. Quite the opposite. In each case, the agency had a strong argument that the statutory language, commonsensically read, granted the power it claimed. Meanwhile, all our major questions cases can be easily explained by reference to a rule requiring the executive branch to identify clear statutory authority when it claims Congress has granted it an extraordinary power. And that is a dice-loading rule, plain and simple, one designed to protect Article 1, a substantive value external to the statutory terms at hand. Common sense not only fails to explain many of our major questions cases, it doesn't explain even some of the cases Justice Barrett has held up as examples of common sense. In Bond versus United States, for example, the court confronted a statute that defined chemical weapon to include any chemical which through its chemical action on life processes can cause death, temporary incapacitation, or permanent harm to humans or animals. Despite that broad definition, the court held that an arsenic-based compound didn't fit the bill. To reach that result, we did not use common sense alone. How could we have? It hardly goes without saying that arsenic doesn't qualify as a chemical which can cause permanent harm to humans or animals. Instead, we relied on a clear statement rule grounded in the substance of the Constitution, namely the federalism canon. So Bond may well be like our major questions cases, but that is only because it applied a clear statement rule grounded in another substantive feature of the Constitution. Consider as well the babysitter hypothetical Justice Barrett has posed. Imagine a parent of young children who hands a babysitter a credit card, says, "Make sure the kids have fun." Now suppose the babysitter takes the kids on a road trip to an amusement park where they spend 2 days on roller coasters and 1 night in a hotel. Was the babysitter's trip consistent with the parent's instruction? Justice Barrett believes the answer is likely no as a matter of common sense. Really though, unless one is to believe children do not have fun on roller coasters and at hotels, the babysitter hypothetical can be explained only with reference to some external and substantive norm. And in fact, just such a norm is baked into the babysitter hypothetical, one we encountered in Part 1b. The babysitter is exercising authority the parents have delegated to her. She is acting as their agent. As a result, one might expect a clear statement from the parents before the babysitter may do something extraordinary like take the kids on a road trip. This substantive norm, without delegated powers, not only lurks beneath the surface of the babysitter hypothetical, it loads the dice against her. Doubtless, she would see it that way. The babysitter would argue that a trip to an amusement park is fun, and she would be right under a common sense understanding of the word. But because the babysitter is exercising delegated authority, she cannot exercise such extraordinary power without clear authorization for it. Notice too, the same outcome is no longer guaranteed when we remove the delegated power feature. If one parent leaves the children with the other parent, the trip to the amusement park might well be fine. No other contextual clues are needed. So if the answer to the babysitter hypothetical seems a matter of common sense to many Americans, that is only because the substantive norms associated with parental delegations to babysitter agents are so deeply rooted in our society. Say the same instruction were given to a babysitter in a community where children are raised collectively, like a kibbutz. Same answer? Hardly obvious. Footnote 1. Today, Justice Barrett protests that the foregoing discussion takes down a straw man. But it was Justice Barrett who previously wrote that the major questions doctrine grows out of common sense principles of communication, and it was Justice Barrett who used the various illustrations recounted above to suggest that our major questions decisions can be explained by reference to the kind of common sense that goes without saying. If Justice Barrett now means to put all that to the flame, the major questions doctrine is better for it. Carrying on. Section B. To be sure, in places, Justice Barrett concedes that her gloss on the major questions doctrine requires resort to something more than common sense instincts about what would go without saying to an ordinary English speaker. Sometimes, she suggests, common sense doesn't just help illuminate the most natural meaning of an idiomatic term like drew blood based on its presence in penal law. Sometimes, she says, common sense principles of communication go much further. So much so that they wind up dictating a rule counseling skepticism of executive claims to extraordinary delegated powers. Why? Because, Justice Barrett says, a reasonable observer consults our constitutional structure. But if that's true, this version of common sense does require us to account for values entirely external to a statute, including, specifically, the substance of Article 1. And in doing so, the expanded version of common sense just becomes the substantive major questions doctrine by another name. Today's decision illustrates the point. The principal opinion gestures at common sense, but throughout, this common sense is linked to constitutional structure and separation of powers principles. The principal opinion begins with the Constitution observing that Article 1 vests the tariff power in Congress, not the executive branch. The principal opinion recounts the President's claim that Congress has delegated an extraordinary amount of its tariff power to him in IEEPA, and from there the principal opinion proceeds to apply a clear statement rule. It acknowledges that the ordinary meaning of the key statutory term in IEEPA, the word regulate, is capacious, so much so that it could be understood to capture much of what a government does. Still, the principal opinion reasons that is not enough to sustain the President's claim because the statute does not clearly grant him the extraordinary delegated power he seeks. When it comes down to it, common sense serves as little more than a segue to Article 1's vesting clause. That is as it must be. The statutory terms contain no ambiguity we could use or need common sense principles of communication to resolve. This case is nothing like the Drew Blood illustration, where it might go without saying that any ordinary person would immediately understand which of the two idiomatic meanings a penal statute employed. Indeed, today's principal opinion does not even attempt to set forth the metes and bounds of IEEPA's key phrase regulate importation, much less find the best or most natural meaning of those words. Instead, we need go no further than to recognize that IEEPA fails to clearly authorize tariffs, and the only reason we can stop there is because Article 1, a substantive value external to a statute, imposes a clear statement rule when executive officials claim Congress has afforded them an extraordinary authority. There's another problem, too. The equivocation on whether common sense principles of communication include only those things that might go without saying, or also include external and substantive Article 1 values, leads to a further equivocation on how much skepticism common sense might dictate when assessing an executive official's claim to an extraordinary delegated power. Common sense, we are told, does not impose a clarity tax, but it does add an expectation of clarity. Common sense does not load the dice, but it does counsel skepticism. Common sense means never foregoing the most natural reading of a statute, but it always means expecting that Congress will make the big-time policy calls. I'm uncertain what to make of this, except that it seems to toggle between a clear statement rule and nothing at all. Footnote 2. To the extent Justice Barrett suggests any skepticism common sense principles of communication might or might not advise derives from a practical understanding of legislative intent rather than external and substantive Article 1 values that poses still further and familiar problems. Down that road lies all the pitfalls associated with reliance on legislative history and those associated with conflating unenacted legislative intent with the law. Justice Barrett has offered no evidence about what people expect when confronted with different congressional delegations, and to the extent she believes their expectations would reflect an appropriate consideration of the whole corpus juris, including the Constitution, that just circles us right back to the external and substantive Article 1 values she strives so hard to sideline. Carrying on. I am certain of one thing. Our cases hold a clear statement is required to support a claim to extraordinary delegated power. We required Congress to speak clearly in utility air. We demanded clear congressional authorization in NFIB. We did the same in Nebraska and in West Virginia, and we do so again today. Nor do I see cause for being quite so reluctant about acknowledging this. The common law recognized many clear statement rules. Our own cases have applied a host of Constitution-enforcing clear statement rules as well. We just encountered the federalism clear statement rule in Bond. Add to the list clear statement rules against laws that might apply retroactively, waive or abrogate sovereign immunity, or create enforceable rights under the taxing clause, to name just a few. Maybe all these rules could be recast as common sense, at least if common sense means taking account of external and substantive values found in our constitutional structure. But whatever the label, it hardly requires some judicial flex to recognize that the external constitutional values at stake in our major questions cases are no less weighty than those at play in other settings where we routinely apply a clear statement rule. Footnote 3. Notably, past critics of the major questions doctrine have not hesitated to apply many of these clear statement rules. Nor have they hesitated to adopt and apply other clear statement rules with far less grounding in the Constitution than the major questions doctrine. Carrying on. Part 3. That brings us to the third camp, My dissenting colleagues have defended the major questions doctrine in the past, and they do so again today. They agree that the doctrine is grounded in the Constitution. They agree that the doctrine requires us to deviate from routine statutory interpretation principles and instead place a thumb on the scale, one requiring executive officials to identify clear congressional authorization when they seek to exercise some major power. But, my colleagues say, IEEPA provides the clear statement needed to sustain the president's tariffs. Alternatively, they submit we shouldn't apply the major questions doctrine to any statute like IEEPA that implicates foreign affairs. And this exception, they add, is particularly warranted here because Congress has historically granted the president large discretion in setting tariffs. Once again, the points are thoughtful and merit careful consideration. Section A. My dissenting colleagues begin by taking the major questions doctrine as they find it. They accept that the president's challenged actions are of major economic and political significance. They accept as well that he must identify clear congressional authorization to sustain those actions. Still, the dissent maintains IEEPA clearly grants the president the tariff power he asserts. To arrive at that conclusion, the dissent consults 4 clues we have sometimes employed in our major questions cases to help assess whether a statute clearly authorizes an asserted power. The dissent formulates these clues largely as I would, but to my eyes the dissent engages in a little grade inflation when applying them. First, is the president seeking to exercise an unheard of or newfound power based on a long extant statute? The dissent insists that is not the case here because President Nixon imposed a 10% tariff on most imports in 1971 and then defended that action in lower courts under a predecessor to IEEPA, the Trading with the Enemy Act, TWEA. But the words regulate importation were added to TWEA in 1941. Congress used the same language in IEEPA in 1977. And in the 85 years of TWEA's existence, with that language and the 49 years of IEEPA's, that is the only time either statute has been invoked to impose tariffs. A single time, and one never tested in this court. Nor are these statutes seldom used. Each year since 1990, presidents have issued roughly 4.5 executive orders and declared 1.5 new national emergencies citing IEEPA. That is pretty strong evidence the president here seeks to deploy an old statute in a novel way. Second, how has the executive branch interpreted IEEPA in the past? The dissent says presidents have long understood IEEPA to permit them to impose tariffs, but for support, the dissent again relies on isolated evidence about other statutes. It points to the monetary exactions President Ford ordered under the Trade Expansion Act of 1962. And once more, it points to President Nixon's invocation of TWEA to support his 1971 tariffs during lower court proceedings, though the dissent brushes aside the fact that President Nixon initially rejected the idea of relying on TWEA. Whatever one makes of this history, it hardly reveals the kind of contemporaneous and consistent executive interpretation that might advance the dissent's cause. To the contrary, the fact that no president until now has invoked IEEPA to impose a duty, even 1% on one product from one country, is telling. Third, is there a mismatch between the action the executive official seeks to take and his expertise? On this one, I agree with the dissent. If tariffs fall in any executive official's wheelhouse and not Congress's, it's the president's. Fourth, is the president relying on oblique, elliptical, or cryptic language? The dissent says no, because this case does not involve elephants in mouse holes. Put another way, the dissent insists the provisions of IEEPA before us are not ancillary ones, but are designed to convey significant powers. It's a fair enough point as far as it goes, but our cases ask not just whether a provision is a mouse hole or ancillary, they also caution against reading extraordinary powers into broad or general statutory language. Indeed, as we have seen, many of our major questions cases have found broad or general terms in significant statutes insufficient to support a claim to an extraordinary or unusual power, and here the word regulate is broad as can be, so broad that it could be read to capture much of what a government does. As I see it then, 3 of the 4 clues the dissent relies on cut against it. It is important to add as well that as helpful as these clues can be in helping courts spot when a claimed power is not supported by clear statutory authority, they do not represent some exhaustive checklist, nor does satisfying one guarantee a claim will succeed. So, for example, even if an asserted power is in the agency's wheelhouse, we might rule and have ruled against the agency if the power is unheralded because the statute has stood for decades without being interpreted to convey the power claimed. Ultimately, the central question in any major questions case remains whether the executive branch's claim to an extraordinary power is supported by clear statutory authority, and as the principal opinion explains at length, many additional clues beyond those the dissent addresses confirm that the President cannot meet that standard in this case. These additional clues include the way the key statutory term regulate is used elsewhere in the U.S. Code, how Congress has delegated tariff authority in the past, and other neighboring language in IEEPA itself. Contrary to the dissent's charge, too, the principal opinion's application of the major questions doctrine today in no way amounts to a magic words test. Of course, if IEEPA included the terms like tariff or duty, that would have sufficed. But, to borrow a phrase from the dissent, monetary exactions on foreign imports would have worked just as well. Same goes for tax on imported goods, or any similarly clear term or phrase, but IEEPA includes no such language, just a broad term that could cover almost anything a government does, and requiring specific rather than general language is just how clear statement rules work. Section B. If the President's claim fails under our usual major questions test, the dissent says we should respond by carving out an exception to it for cases like this one touching on foreign affairs. On this score, I share a limited point of agreement with the dissent. Like the non-delegation doctrine, the major questions doctrine protects Article 1's vesting clause, and, for that reason, the doctrine does not apply where the President is exercising only his own inherent Article 2 powers. Like the non-delegation doctrine, too, the major questions doctrine may speak with less force where the President and Congress enjoy overlapping authority. Doubtless, cases implicating overlapping powers can arise in the field of foreign affairs. The Constitution, for example, vests in Congress the power to raise and regulate armies, but it also vests in the President the commander-in-chief power. Similarly, Congress enjoys the power to regulate foreign commerce, but the President has power to negotiate treaties and nominate ambassadors. The President may even enjoy some residual powers pertaining to foreign affairs under Article 2's vesting clause, endowing him with the executive power. Given all this, it is easy enough to imagine statutes and disputes under them that implicate both congressional and presidential powers, where we might have reason to question whether the major questions doctrine applies with its usual force. The problem for the dissent is that none of this is relevant here. Before us, the President concedes that he does not enjoy independent Article 2 authority to impose tariffs in peacetime, nor does the President claim concurrent constitutional authority to issue his tariffs. Instead, and to his credit, the President admits the power to authorize tariffs in peacetime is constitutionally vested in Congress alone. Therefore, the President relies entirely on power derived from Congress, and that means the major questions doctrine applies in the normal way. Because of this problem, the dissent must argue for a much broader foreign affairs qualification to the major questions doctrine. Rather than ask whether an independent constitutionally vested presidential power is implicated, the dissent would have us ask instead whether the President seeks to use the statute in question for a foreign affairs purpose, for example as a tool to incentivize a change in behavior by allies or enemies. When he does, the dissent submits, the major questions doctrine should not apply. And that's true, the dissent continues even if the power the President asserts has significant domestic ramifications. This new exception to the major questions doctrine would have enormous consequences hard to reconcile with the Constitution. Article 1, Section 8 vests in Congress many powers that touch on foreign affairs. Some of those powers were expected to be, and are, the principal objects of federal legislation. They include not only the power to impose tariffs, but also the power to establish uniform rules of naturalization, appropriate money for armies, and define and punish offenses against the law of nations. Under the dissent's view, all these legislative powers and more could be passed wholesale to the executive branch in a few loose statutory terms, no matter what domestic ramifications might follow, and as we have seen, Congress would often find these powers nearly impossible to retrieve. Consider an example. Imagine Congress adopted a law that arguably could be read to let the president borrow and spend money during peacetime as he sees fit. A law like that would represent an extraordinary delegation of Congress's power both to borrow on the credit of the United States and to spend money in support of the general welfare, and would carry with it significant domestic ramifications. But if an enterprising executive could also use the law as a tool for affecting the behavior of allies or enemies, the dissent seemingly would have us exempted from scrutiny under the major questions doctrine. The dissent's exception is so broad it's hard not to wonder how it fits with some of our existing major questions precedents. In West Virginia, the court applied the major questions doctrine over a dissent expressing concern that doing so would deny the EPA, and therefore the president, the power to respond to the most pressing environmental challenge of our time, climate change. A challenge the dissent continued that threatened consequences global in scope, including mass migration events, political crises, civil unrest, and even state failure. Was West Virginia a foreign affairs case? How about our major questions cases addressing efforts to combat the global pandemic that was COVID-19? Footnote 4. The dissent suggests that trying to identify when an independent Article II authority is in play would prove jurisprudentially chaotic. But as the foregoing discussion illustrates, the dissent's alternative foreign affairs test poses its own challenges. And it seems to me only one is firmly rooted in the text of the Constitution. In this case, too, only one test promises any manner of chaos because all parties before us readily agree that the Constitution affords the president no independent power to impose peacetime tariffs. Carrying on. Seeking support for its sweeping new exception, the dissent points to three main precedents. I do not see how any of them might sustain its view. The first, Hamdi versus Rumsfeld, concerned the 2001 Authorization for the Use of Military Force, AUMF, legislation which authorized the president to use all necessary and appropriate force against those nations, organizations, or persons responsible for the September 11, 2001 attacks. The dissent highlights the principal opinion's conclusion that the AUMF allowed the president to detain enemy combatants even though the law did not mention that power expressly, and from this the dissent draws the inference that any statute addressing foreign affairs should be exempt from scrutiny under the major questions doctrine. But the dissent overlooks the fact that the principal opinion reached the conclusion it did only because it found detention of enemy combatants to be a traditional incident to war, and once Congress declares war, or likewise authorizes the use of military force abroad, that implicates the president's commander-in-chief powers. Put simply, Hamdi was a case of overlapping powers, ours is not. Second, the dissent invokes Dames and Moore versus Reagan. At its heart, that case involved an executive order by President Reagan suspending certain claims by U.S. citizens against Iran as part of a settlement involving the release of American hostages held there. Just as we do today, Dames and Moore held that the terms of the IEEPA did not authorize the president's actions. Even so, the court proceeded to uphold those actions anyway, and did so based in part on its view, right or wrong, that the president enjoyed some independent power to enter into executive agreements suspending certain claims. So unlike our case, Dames and Moore again involved overlapping powers. Along the way too, the court emphasized repeatedly the narrowness of its decision and that it should not be taken to lay down any general guidelines covering other situations not involved here. To derive from Dames and Moore a new general guideline exempting foreign affairs cases from the major questions doctrine's reach would thus require us to disregard its own cautionary direction. Third, the dissent cites United States versus Curtiss Wright Export Corporation. There, the court did suggest that non-delegation rules in the field of domestic or internal affairs should differ from those in the realm of foreign or external affairs. But what should we make of that language? If it means that the non-delegation doctrine, and perhaps by extension the major questions doctrine, must account for the president's independent Article II powers, I agree, but I would hesitate to read more into the decision than that. Consider what was really at issue there. A statute permitted the president to ban the transfer of one class of goods, armaments. It did so with respect to two countries then engaged in a war, Bolivia and Paraguay. The president's authority was conditioned on a finding that a ban may contribute to the reestablishment of peace between those countries. Before making that finding, too, Congress directed him to consult with the governments of other American republics. All told, then, the statute set forth the policy for the president to pursue. It bounded his authority by limiting his options with respect to a limited class of goods and countries. The statute further conditioned his exercise of those options on a factual finding reached after consultation with other nations. So whatever else might be said about Curtis Wright, one thing is important. In upholding the president's actions under the law in question, the court hardly allowed Congress to hand off all its enumerated powers touching on foreign affairs to the president, the tariff power included. Footnote 5. In places, the dissent also argues that the president's inherent Article II authority includes a wartime tariff power. But this only highlights the dissent's bind. Whatever the full scope of the president's Article II war powers may be, and the briefs before us reveal a healthy debate whether they include the power to impose tariffs, those powers are not implicated here. IEEPA is not a wartime statute, nor does the president claim we are at war with the countries whose goods are subject to the tariffs. Carrying on. Section C. If its effort to secure a broad foreign affairs exception to the major questions doctrine won't work, the dissent hints at a much more limited one specific to tariffs. Such an exception makes sense, the dissent says, because presidents have long been granted substantial discretion over tariffs. Indeed, the dissent contends this tradition traces back to near the founding. If the dissent were right about that, one might hesitate before accepting the president's concession that this case does not implicate any inherent Article II authority, but, at least as I read it, history offers the dissent little to work with. Americans fought the Revolution in no small part because they believed that only their elected representatives, not the king, not even Parliament, possessed authority to tax them. And they believed that held true not just for direct taxes like those in the Stamp Act, but also for many duties on imports like those found in the Sugar Act. Americans later codified these beliefs in the Constitution. Under the Articles of Confederation, the national government was laden with debt and enjoyed few ways to repay it. To address that problem, the framers afforded the federal government new taxing powers in the Constitution. Many thought these powers among the most important features of the new federal charter. But, consistent with their view that only the people's elected representatives could constitutionally tax them, the framers gave Congress alone access to the pockets of the people. And to cement that role, the Constitution required that all bills for raising revenue shall originate in the House of Representatives, the body most responsive to the people. For much of the nation's history, this taxing power was essentially a tariff power. The framers even considered, and eventually rejected, the possibility of giving the federal government the power to tax only through tariffs. No surprise, then, that Congress's first exercise of its taxing power was a tariff law. And until the 20th century, tariffs accounted for between 50 and 90% of the federal government's revenue. How did Congress exercise its all-important tariff power? It debated every detail of the first Tariff Act. Ultimately, Congress said, imported malt would incur a charge of 10 cents a bushel, brown sugar 1 cent, loaf sugar 3 cents, and so on. The first Tariff Act was set to last for 7 years. It lasted barely one. Soon, Congress was at it again, laying out another exacting schedule of duties. Throughout much of the 19th century, Congress proceeded similarly, enacting highly detailed tariff schedules one after another. An early debate over executive involvement in setting tariffs demonstrates just how strongly Congress felt that tariffs were a legislative business. In December 1791, President Washington told Congress that General St. Clair had been defeated in the Northwest Indian War, and the country would have to increase the size of the army. That meant the government needed more money. In response, a resolution was offered in the House of Representatives to solicit advice from the Secretary of the Treasury, Alexander Hamilton, on the best way to raise the additional revenue, including through new tariffs. Ultimately, Hamilton's advice was sought, but only after debate over the constitutionality of even asking a member of the executive branch for advice on raising revenue. To be sure, on later occasions, Congress turned to the executive branch for more help still, but it usually did so to address changing trade practices in foreign countries. And in doing so, Congress set the important policies with the executive branch responsible for finding facts, like what other countries' trade policies were at any given moment, or filling in the details. So, for example, Congress passed a statute in 1815 to repeal any discriminating duty of tonnage whenever the president was satisfied that other countries' discriminating or countervailing duties had been abolished. Given this history, it's no surprise that the dissent relies mostly on statutes and cases after 1890, but even they do little to support its claim. J.W. Hampton Jr. and Company versus United States, for example, involved a law instructing the president to investigate the costs of production for American firms and their foreign counterparts and issue tariffs to equalize those costs. The statute the court faced in Marshall Field and Company versus Clark spoke similarly. Even when Federal Energy Administration versus Algonquin SNG Inc. came along in 1976, the court upheld President Ford's imposition of monetary exactions on a single class of products under a statute that provided at least some guidance about how he should implement the law. And whether correctly decided or not, that case lies a far step from this one. Before us, the president insists he may use IEEPA to equalize foreign and domestic duties or not. He may use it to negotiate with foreign countries, or not. He may set tariffs at 1% or 1,000,000%. He may target one nation and one product, or every nation and nearly every product. He may change his mind at any time for nearly any reason. At least as I see it, history dating back to near the founding does not support the notion that presidents have traditionally enjoyed so much power. More nearly, history refutes it. Footnote 6. Beyond the major questions hurdle, the dissent faces another related one, the non-delegation doctrine. There, the problems are just as acute. In recent decades, this court has employed a relatively lax intelligible principle test to police delegations. But recognizing that even the intelligible principle test poses challenges for it, the dissent contends for an even laxer test yet in cases involving foreign affairs and tariffs. It's an effort that fails for reasons we have just seen. Even if the non-delegation doctrine should apply differently when congressional legislation and executive actions implicate inherent Article 2 powers, none of that means it should do so, whereas here, the president derives whatever authority he has only from Congress. Carrying on. Part 4. That leaves just one final camp to consider. Justice Thomas suggests that Congress may hand over most of its constitutionally vested powers to the president completely and forever. On his view, the only powers Congress may not delegate are those that involve rules setting the conditions for deprivation of life, liberty, or property. From this rule, it follows that Congress may give all its tariff powers to the president because importing is a matter of privilege. And as a result, this case does not implicate any separation of powers concerns at all. It's a sweeping theory, one that would require us to reimagine much of our case law addressing Article 1's vesting clause, and one that presents difficulties of its own. First, I do not see how Justice Thomas's theory resolves all separation of powers concerns in this case. Suppose, for argument's sake, that Congress can delegate its tariff powers to the president as completely as Justice Thomas suggests. Even then, the question remains whether Congress has given the president the tariff authority he claims in this case, or whether the president is seeking to exploit questionable statutory language to aggrandize his own power. Put another way, Justice Thomas's non-delegation solution does not automatically solve the major questions problem. And as we have seen, when an executive official claims Congress has delegated to him some extraordinary power, the major questions doctrine requires him to identify clear statutory authority for its exercise, a standard he must satisfy even if Congress is free to pass to him the power he seeks. In fact, this court has previously applied, with our colleague's assent, the major questions doctrine in a case that appears, under his present view, to involve a power that Congress could delegate wholesale to the president. And just as the major questions doctrine precluded the executive branch's assertion of power in that case, it does so here. Second, even when it comes to the non-delegation doctrine, Justice Thomas's theory raises many questions. I appreciate that the doctrine may apply with less force in certain areas, such as when Congress legislates in a way that implicates one of the president's inherent powers. But Justice Thomas would go much further. On his telling, the doctrine applies only to Congress's true legislative powers, which he says include only those powers addressing the deprivation of life, liberty, or property. As it turns out, only a small subset of Congress's enumerated powers in Article 1, Section 8 fit that bill. Only those few powers are exclusively vested in Congress and subject to review of any kind under the non-delegation doctrine. All other kinds of powers enumerated in Article 1, Section 8, including the power to borrow and spend money, declare war, and regulate foreign trade, are not truly legislative and may be delegated at will. So Congress may hand them off to the President completely, and he has no need to worry about legal challenges under even this court's relatively lax non-delegation doctrine. No matter, too, that Congress might find itself permanently unable to retrieve these powers. But if all that's true, what do we make of the Constitution's text? Section 1 of Article 1 vests all legislative powers herein granted in Congress and no one else. Section 8 proceeds to list those powers in detail and without differentiation. Neither provision speaks of some divide between true legislative powers touching on life, liberty, or property that are permanently vested in Congress alone and other kinds of powers that may be given away and possibly lost forever to the President. What do we make, too, of what the founders said about Article 1 both before and after the Constitution's ratification? They regularly referred to powers in Article 1, Section 8, even those that do not touch on life, liberty, or property, as legislative in nature. At the Constitutional Convention, early drafts described the powers to regulate foreign commerce, raise armies, equip fleets, coin money, and establish post offices as legislative powers. Alexander Hamilton spoke similarly. So did James Wilson. What do we make as well of early congressional debates? In the Second Congress, for example, the House of Representatives rejected on non-delegation grounds a proposal to give the President a largely unfettered power to establish postal routes, even though doing so hardly would have touched on life, liberty, or property. In the Fifth Congress, 4 representatives likewise objected on non-delegation grounds to a bill that authorized the President to raise an army of up to 10,000 men. Though the bill ultimately passed, it did so apparently because it was deemed not to violate Article 1's non-delegation principle. No member of Congress responded that the principle was wholly inapplicable because the delegated power was not one that involved setting conditions for the deprivation of life, liberty, or property. What are we to do, too, with this court's non-delegation precedents which have never turned on Justice Thomas's view of life, liberty, or property? Third, even if a distinction between true legislative powers and other kinds of powers were proper, I do not see why the tariff power would fall in the latter category and thus be something Congress could delegate away wholesale, without scrutiny, and forever. Justice Thomas suggests all that is possible because at the founding the tariff power was considered a prerogative right of the British king. That seems doubtful. Tariffs may have been among the king's prerogative powers during the reign of Edward I, but even before the year 1400, Parliament had achieved some victory over the king in the matter of imposing import duties. And after the Glorious Revolution of 1688, as this court has put it, Parliament secured supremacy in fiscal matters. By the time of the American Revolution, trade regulation was thus a prime topic of legislative concern in Britain. More importantly still, whatever the views in Britain may have been, American revolutionaries hardly shared some universal conviction that all manner of tariffs were a matter of the king's prerogative, or even something Parliament, lacking colonial representatives, could freely impose on them. Though in the mid-1760s some colonists distinguished between internal and external taxation and conceded Parliament's right to raise revenue through duties on trade, the inadequacy of that much overstrained distinction soon became obvious. Illustrative of the point, John Dickinson came to repudiate the distinction flatly and formally in his Letters from a Farmer in Pennsylvania, contending instead that laws aimed at raising revenue but enacted without representation were objectionable without distinction between internal and external taxes. And of course, it was duties on foreign tea that triggered the Boston Tea Party. Are we really to believe that the patriots that night in Boston Harbor considered the whole of the tariff power some kingly prerogative? As we've already seen, too, the growing American conviction that the peacetime tariff power is legislative and belongs only to the people's elected representatives was later reflected in both the Constitution and early congressional practice. To that discussion, I would add just this. The Articles of Confederation granted the Confederation Congress authority to make commercial treaties, but no authority to restrain the legislative power of the respective states to impose imposts and duties on foreigners. At the Constitutional Convention that followed, where the tariff power was transferred to the federal government, delegates likewise referred to it as a legislative power. And during debates over the Jay Treaty, Hamilton explained that he had no doubt that regulating foreign trade and raising money from it was a legislative power, if one that could be constrained by treaty. Reflecting the same sentiment that helped fuel the revolution, he asked, what legislative power can be more sacred? For those who think it important for the nation to impose more tariffs, I understand that today's decision will feel disappointing. All I can offer them is that most major decisions affecting the rights and responsibilities of the American people, including the duty to pay taxes and tariffs, are funneled through the legislative process for a reason. Yes, legislating can be hard and take time, and yes, it can be tempting to bypass Congress when some pressing problem arises, but the deliberative nature of the legislative process was the whole point of its design. Through that process, the nation can tap the combined wisdom of the people's elected representatives, not just that of one faction or man. There, deliberation tempers impulse, and compromise hammers disagreements into workable solutions. And because laws must earn such broad support to survive the legislative process, they tend to endure, allowing ordinary people to plan their lives in ways they cannot when the rules shift from day to day. In all, the legislative process helps ensure each of us has a stake in the laws that govern us and in the nation's future. For some today, the weight of those virtues is apparent. For others, it may not seem so obvious. But if history is any guide, the tables will turn and the day will come when those disappointed by today's result will appreciate the legislative process for the bulwark of liberty it is. Justice Barrett concurring. As the principal opinion demonstrates, the most natural reading of the International Emergency Economic Powers Act does not encompass the power to impose tariffs. I write only to address Justice Gorsuch's concurrence regarding the major questions doctrine. To the extent that Justice Gorsuch attacks the view that common sense alone can explain all our major questions decisions, he takes down a straw man. I have never espoused that view. Rather, as I explained in my concurrence in Biden versus Nebraska, the major questions doctrine situates text in context and is therefore best understood as an ordinary application of textualism. Textualists, like all those who use language to communicate, do not interpret words in a vacuum. Instead, we use context, including background legal conventions, common sense, and constitutional structure, to ascertain a text's most natural meaning. Part of this context, as I have explained, is Article 1 of the Constitution, which vests Congress with all legislative powers. Obviously, the Constitution bears on the meaning of a statute enacted pursuant to it. Because Article 1 grants all legislative powers to Congress, the reasonable interpreter would expect Congress to make the big-time policy calls itself rather than pawning them off to another branch. Footnote 1. Contrary to Justice Gorsuch's suggestion, this approach to the major questions doctrine does not risk conflating unenacted legislative intent with the law. Rather, like textualism more generally, it looks for a sort of objectified intent, the intent that a reasonable person would gather from the text of the law, placed alongside the remainder of the corpus juris, including the Constitution. Carrying on. To the extent that Justice Gorsuch also thinks that background legal conventions and constitutional structure inform the most natural reading of a statute, then we may not be very far apart. Our only disagreement may be over the level of clarity required before a particular interpretation can be deemed the most natural one. I understand Justice Gorsuch to require Congress always to speak precisely to any major power that it intends to give away. As I have said before, I think that other, less obvious clues can do the trick. I do not see any such clues here. In fact, as the court explains, the clues we have point in the opposite direction. At times, though, Justice Gorsuch suggests that the purpose of the major questions doctrine is something other than to ascertain the most natural reading of a statute. For example, he writes that the doctrine serves to prevent highly resourceful members of the executive branch from assuming new power for themselves, because men are not angels. But if the Constitution permits Congress to give the executive a particular power, who are we to get in the way? Does the judiciary really protect the Constitution by impeding the constitutional action of another branch? If Justice Gorsuch thinks that we should forego the most natural reading of a statute because it is preferable for Congress rather than the President to make big decisions, that way lies a lot of trouble for the textualist. Strong form substantive canons, canons instructing a judge to adopt an inferior but tenable reading, veer beyond interpretation and into policymaking. And while the policy may be desirable or even constitutionally inspired, judges should hesitate to impose disciplining rules on Congress. As Justice Scalia lamented, whether these dice-loading rules are bad or good, there is also the question of where the courts get the authority to impose them. Can we really just decree that we will interpret the laws that Congress passes to mean less or more than what they fairly say? Granted, strong form canons exist elsewhere in the law. I do not propose to abandon these canons, nor have I taken the position that adopting them necessarily exceeds the judicial power. But I am skeptical about adding new ones to the mix. And while the major questions doctrine has an impressive pedigree as an interpretive principle, this court has not, yet anyway, embraced it as a strong form rule that imposes a clarity tax on Congress. Justice Gorsuch seems to disagree, pointing to a few late 19th and early 20th century cases. Footnote 2. He also points to state cases and long-standing corporate law principles. While those sources support the existence of a background legal convention that informs a statute's most natural meaning, they are not evidence that this court, which is bound by the constraints of Article 3, has adopted a true clear statement rule. Carrying on. But these cases, like our modern ones, are consistent with my context-based approach. They focused on ascertaining, not shaping, what the statute in dispute communicates. I would not treat this evidence as precedent for a judicial flex. Justice Gorsuch proposes to do something new. The innovation is in significant tension with textualism, so I do not support the project. Justice Kagan, with whom Justice Sotomayor and Justice Jackson join, concurring in part and concurring in the judgment. The court holds today that the International Emergency Economic Powers Act, IEEPA, does not authorize the President to impose tariffs. I agree with that conclusion as I do with the bulk of the principal opinion's reasoning, but because I think the ordinary tools of statutory interpretation amply support today's result, I do not join the part of that opinion invoking the so-called major questions doctrine. The question that part asks, similar to the one posed in other major questions cases, is whether the President can identify clear congressional authorization for his action, here, to impose tariffs under IEEPA. The demand is for a clear statement, something more explicit or specific than the statutory basis that would ordinarily suffice to support executive action. The reason for that requirement, according to today's opinion, is that the executive has claimed an extraordinary power, one never asserted before, and having large-scale economic and political significance. I objected in the principal cases cited to the demand for a special brand of legislative clarity. In my view, the court used its clear authorization rule in those cases to negate expansive delegations Congress had approved. I explained there that the proper way to interpret a delegation provision is through the standard rules of statutory construction. That means, most concisely stated, reading text in context. More expansively put, it means examining a delegation provision's language, assessing that provision's place in the broader statutory scheme, and applying a modicum of common sense about how Congress typically delegates. The last of those inquiries includes consideration of whether Congress ever has before or likely would delegate the power the executive asserts, a matter also of import in applying the major questions doctrine. In the past, though, I have thought that the court used that doctrine to override, rather than help discover, the best reading of delegation statutes. This case presents more nearly the opposite situation. The use of a clear statement rule here is unnecessary because ordinary principles of statutory interpretation lead to the same result. Footnote 1. Justice Gorsuch claims not to understand this statement, insisting that I now must be applying the major questions doctrine and his own version of it to boot. Given how strong his apparent desire for converts, I almost regret to inform him that I am not one. But that is the fact of the matter. I proceed in this case just as I did in West Virginia and Nebraska. I consider a delegation provision's language broaden the scope to take in the statutory setting and apply some common sense about how Congress normally delegates. Contrary to Justice Gorsuch's suggestion, that conventional method of interpretation will not always favor or always disfavor executive officials given the variety of delegation schemes Congress adopts. I'll let Justice Gorsuch relitigate on his own our old debates about other statutes unrelated to the one before us. What matters here is only that IEEPA's delegation refutes the executive's assertion of authority to levy tariffs without any help from the major questions doctrine. Carrying on. It is not just that the government's arguments fail to satisfy an especially strict test, it is that they fail to satisfy the normal one. Even without a clear statement rule in the picture, the conclusion follows. IEEPA does not authorize the president to impose tariffs, and indeed the principal opinion's reasoning well explains why. The rest of this opinion draws on that analysis, I hope without too much rehashing, to demonstrate what I view as the fundamental point. Usual text in context interpretation dooms the tariffs the president has imposed. The crucial provision of IEEPA, when viewed in light of the broader statutory scheme and with a practical awareness of how Congress delegates tariff authority, does not give the president the power he wants. Most important, IEEPA's key phrase, the one the government relies on, says nothing about imposing tariffs or taxes. That text authorizes the president, upon finding a foreign threat and declaring an emergency, to regulate the importation of foreign goods. And the meaning of regulate, both in common parlance and as Congress uses the word, does not encompass taxing. To regulate according to the government's preferred definition means to fix, establish, or control, to adjust by rule, method, or established mode, to direct by rule or restriction, to subject to governing principles or laws. Nothing in that definition naturally refers to levying taxes, nor does Congress ever use the word regulate in that way. Hundreds of provisions in the U.S. Code give agencies the authority to regulate one thing or another, yet the government cannot identify a single one that is understood to grant taxing power. When Congress wants to delegate that power, it uses a whole different vocabulary, terms like duty, tariff, or surcharge, which do not appear in IEEPA. And likewise, when Congress means to cover both regulatory and taxing powers, it refers to each separately. Of course, Congress knows that taxes can be used for regulatory ends. They can be a means of controlling or adjusting behavior. But Congress still follows the path this court long ago marked out, and the one most consonant with ordinary meaning, of treating the power to regulate trade as entirely distinct from the power to levy taxes. So in granting only the former, IEEPA excludes the latter. The president has the ability to regulate, but not to impose taxes on imports. The surrounding statutory language confirms the point. As the principal opinion explains, regulate is one of 9 verbs listed in IEEPA's delegation provision. The others are investigate, block, direct, compel, nullify, void, prevent, and prohibit. Those verbs are followed by 11 objects, each describing a distinct sort of transaction involving foreign property, not just importation, but also acquisition, use, transfer, and so forth. Combine the verbs and objects in all possible ways, and the statute authorizes 99 actions the president can take to address a foreign threat, and exactly none of the other 98 involves raising revenues. Rather, each enables the president to impose penalties, restrictions, or controls on foreign commerce. So when the phrase regulate importation is invoked to impose quantity or quality limits on bringing foreign goods into the country, for example by setting quotas or requiring quarantines, the phrase fits well with its 98 neighbors. Just like the rest, it provides a way to constrain or alter various foreign transactions. But when that phrase is invoked to impose tariffs, then it becomes the odd man out, the only one of 99 permission slips to involve the core congressional power of the purse. So even if, contra both conventional and congressional usage, the word regulate might refer to taxation in some other, hitherto undiscovered statutory context, it would not do so in IEEPA. Footnote 2. The legislative history of IEEPA offers yet more proof that Congress did not authorize taxation. The Senate report, in its description of the statute, reduces the 99 authorized actions to the following: the power to control or freeze property transactions where a foreign interest is involved. The House report similarly describes the delegation provision as authorizing the President to regulate or freeze any property in which any foreign country or a national thereof has any interest. Neither of those descriptions at all suggests that Congress intended to cede its taxing power. Carrying on. Likewise, Congress's consistent practice in delegating tariff power refutes the government's position. As the principal opinion details, Title 19 of the U.S. Code includes multiple provisions granting the President authority to levy tariffs. But in each and every instance, Congress has not only used specific language, for example, duty or surcharge, but also imposed tight restraints on the power given. It has capped the tariff rate, for example, 15%, or limited the tariff's duration, for example, 150 days, or established strict procedural conditions before the tariff can take effect, for example, investigations, public hearings, and reports, or all of the above. What Congress has never done in a tariff provision is what the government claims it did here: conferred power on the President to impose a tariff of any amount for any time on only his own say-so. And construing IEEPA to give that unparalleled authority would effectively erase all the carefully confined tariff provisions in Title 19. For any president could then escape the rigors of those laws, could put in place, say, a non-time limited 100% tariff on all foreign products by the simple expedient of identifying a foreign threat. That gutting of Title 19's tariff scheme is not what Congress, when delegating power to regulate imports, could have meant to accomplish, nor has any president until now understood IEEPA to authorize imposing tariffs. Between 1977, when IEEPA was enacted, and 2024, 8 presidents had the chance to make use of IEEPA's delegation power, and all chose the same course. They invoked the statute's regulate importation provision for a variety of non-tariff purposes, but they looked elsewhere to Title 19's provisions for tariff authority. In other words, each president read the statutes as Congress wrote them, with IEEPA enabling him to regulate imports and Title 19 enabling him, in confined situations, to tax those foreign goods. None, as far as anyone has suggested, even considered doing otherwise. Footnote 3. Presidents followed the same practice, with one quasi-exception under IEEPA's predecessor statute, the Trading with the Enemy Act, TWEA. Beginning in 1941, TWEA authorized the President, as IEEPA does now, to regulate importation. During the next 3 decades, 6 presidents used that delegation for only non-tariff ends while relying on Title 19 to levy tariffs. In 1971, when President Nixon imposed tariffs in response to a balance of payments deficit, he continued in that tradition by invoking 2 statutes, the Tariff Act of 1930 and the Trade Expansion Act of 1962, found in Title 19. But in defending his act against a legal challenge, the Department of Justice argued that even if the 2 cited statutes did not authorize the tariffs, TWEA would do so. That after-the-fact claim of authority was upheld in the Court of Customs and Patent Appeals. The principal opinion well explains why that single lower court decision about TWEA has no bearing on IEEPA's meaning. Carrying on. For all those reasons, straight-up statutory construction resolves this case for me. I need no major questions thumb on the interpretive scales. IEEPA gives the President significant authority over transactions involving foreign property, including the importation of goods, but in that generous delegation, one power is conspicuously missing. Nothing in IEEPA's text, nor anything in its context, enables the President to unilaterally impose tariffs, and needless to say, without statutory authority, the President's tariffs cannot stand. Justice Jackson concurring in part and concurring in the judgment. I agree with the court's conclusion that the International Emergency Economic Powers Act, IEEPA, does not provide the President with the power to tariff. 3 of my colleagues have reached this result via the Major Questions Doctrine, a framing that asks, in essence, whether Congress would likely have intended to delegate the authority to tariff to the President through IEEPA. While probing Congress's intent is the right inquiry, my colleagues speculate needlessly. In my view, the court can and should consult a statute's legislative history to determine what Congress actually intended the statute to do. As Congress undertakes the legislative process, congressional committees in the Senate and House often generate official reports that describe Congress's aims for the legislation. Indeed, there is evidence that lawmakers themselves pay more attention to these reports than a statute's text to understand the statute's purpose and meaning. Thus, in contrast to the principled assent's rejection of committee reports as a means of ascertaining a statute's meaning, I think these Senate and House reports are among the best evidence of what Congress sought to accomplish with its enactments. In the cases now before us, that evidence shows that Congress did not intend for IEEPA to authorize the executive to impose tariffs. Instead, Congress intended to delegate to the President the power to freeze and control foreign property transactions. 4 pieces of the relevant legislative record support this conclusion. The first 2 are the House and Senate reports that accompanied the 1941 amendment to IEEPA's predecessor statute, the Trading with the Enemy Act, TWEA. First enacted in 1917, TWEA authorized the President to control foreign property during wartime, but some of TWEA's sections delegating this authority had lapsed, and there was doubt as to the effectiveness of the other sections. Accordingly, Congress amended TWEA in 1941, adding the subsection that includes the regulate importation language on which the President relies today. The reports explained Congress's primary purpose for the 1941 amendment, shoring up the President's ability to control foreign-owned property by maintaining and strengthening the existing system of foreign property control, commonly known as freezing control. Footnote 1. In addition to maintaining the President's freezing control authority, Congress also sought to authorize the President to seize foreign property and use it to serve the interests of the United States. To this end, the 1941 amendment provided that foreign-owned property shall vest in such agency or person as may be designated by the President. Congress did not include this vesting language in IEEPA. Carrying on. When Congress enacted IEEPA in 1977, limiting the circumstances under which the President could exercise his emergency authorities, it kept the regulate importation language from TWEA. The other 2 relevant pieces of legislative history, the Senate and House reports that accompanied IEEPA, demonstrate that Congress's intent regarding the scope of this statutory language remained the same. As the Senate report explained, Congress's sole objective for the regulate importation subsection was to grant the President the emergency authority to control or freeze property transactions where a foreign interest is involved. The House report likewise described IEEPA as empowering the President to regulate or freeze any property in which any foreign country or a national thereof has any interest. With this evidence of Congress's objective, interpreting the text of IEEPA becomes an easy task. Each of the listed verbs, investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit, provides a means by which the President can freeze or control foreign property transactions. Tariffs are different in kind. They are a tax on imports, a means of generating revenue from transactions between private parties. Because tariffs are not a means by which the President can freeze or control foreign assets, interpreting IEEPA to authorize tariffs would require the court to override Congress's expressed purposes for including the regulate importation language in the statute. Like the Chief Justice's opinion, the principled dissent declines the help of legislative history. The dissent concludes that IEEPA and TWEA are best understood as authorizing tariffs and that any other interpretation would not make much sense. Footnote 2. This reasoning appears to follow the court's relatively recent practice of picking what it deems the best reading of a statute without consideration of Congress's intent. Carrying on. But why would it matter which interpretation we think is best when Congress has already told us? The legislative history here plainly establishes that Congress understood and intended IEEPA and TWEA to authorize a wholly different type of power, the power to freeze foreign-owned property, and the proper role of the court is to give effect to Congress's intent, not our own instincts. In short, in these cases, the legislative history provides helpful evidence of what Congress was trying to do in IEEPA. Given that evidence, we need not speculate or worse, step into Congress's shoes and formulate our own views about what power would be best to delegate to the President for use during an emergency. When Congress tells us why it has included certain language in a statute, the limited role of the courts in our democratic system of government as interpreters, not lawmakers, demands that we give effect to the will of the people. Justice Thomas dissenting. I join Justice Kavanaugh's principal dissent in full. As he explains, the court's decision today cannot be justified as a matter of statutory interpretation. Congress authorized the President to regulate importation. Throughout American history, the authority to regulate importation has been understood to include the authority to impose duties on imports. The meaning of that phrase was beyond doubt by the time that Congress enacted this statute shortly after President Nixon's highly publicized duties on imports were upheld based on identical language. The statute that the President relied on therefore authorized him to impose the duties on imports at issue in these cases. Justice Kavanaugh makes clear that the court errs in concluding otherwise. I write separately to explain why the statute at issue here is consistent with the separation of powers as an original matter. The Constitution's separation of powers forbids Congress from delegating core legislative power to the President. This principle, known as the non-delegation doctrine, is rooted in the Constitution's legislative vesting clause and due process clause. Both clauses forbid Congress from delegating core legislative power, which is the power to make substantive rules setting the conditions for deprivations of life, liberty, or property. Neither clause prohibits Congress from delegating other kinds of power. Because the Constitution assigns Congress many powers that do not implicate the non-delegation doctrine, Congress may delegate the exercise of many powers to the President. Congress has done so repeatedly since the founding with this court's blessing. The power to impose duties on imports can be delegated. Footnote 1. I refer to charges on imported goods as duties, not tariffs or taxes. When the government charged money for importing goods, that charge was historically called a custom or impost, each of which was a kind of duty. The word tariff primarily referred to the schedule or table listing such duties, not the duties themselves. The word tax, although sometimes used loosely to refer to all kinds of monetary charges, more often excluded duties on imports. In fact, although colonial Americans staunchly contested efforts by Parliament to tax them, they often conceded the authority of the British government to regulate commerce through financial exactions, including prohibitory tariffs. In the most widely read and universally approved response to the Stamp Act, Daniel Dunley wrote, "A right to impose an internal tax on the colonies without their consent for the single purpose of revenue is denied. A right to regulate their trade without their consent is admitted." The imposition of a duty may, in some instances, be the proper regulation. Likewise, Benjamin Franklin famously conceded Britain's right of laying duties to regulate commerce, but rejected its power to lay internal taxes. Carrying on. At the founding, that power was regarded as one of many powers over foreign commerce that could be delegated to the President. Power over foreign commerce was not within the core legislative power, and engaging in foreign commerce was regarded as a privilege rather than a right. Early Congresses often delegated to the President power to regulate foreign commerce, including through duties on imports. As I suggested over a decade ago, the non-delegation doctrine does not apply to a delegation of power to make rules governing private conduct in the area of foreign trade, including rules imposing duties on imports. Therefore, to the extent that the court relies on separation of powers principles to rule against the President, it is mistaken. Part 1. The non-delegation doctrine is rooted in both the legislative vesting clause and the due process clause. The doctrine ensures that the legislative branch cannot transfer the power of making laws to any other hands. Importantly, however, the non-delegation doctrine applies only to Congress's core legislative power, not to all of its powers. Section A. The legislative vesting clause grants Congress alone the federal legislative power. It requires that all legislative powers granted to the federal government shall be vested in a Congress of the United States. It follows that those federal legislative powers cannot be exercised by anyone else, including the President. Legislative power for purposes of the vesting clause means the power to make substantive rules setting the conditions for deprivation of life, liberty, or property. I have described this power as the core legislative power to distinguish it from other powers that the Constitution grants Congress. Core legislative power includes only the power to make law in the Blackstonian sense of generally applicable rules of private conduct, the violation of which results in the deprivation of core private rights. These core private rights are the natural rights to life, liberty, and property. The non-delegation doctrine is also rooted in the Due Process Clause. That clause prohibits the federal government from depriving any person of life, liberty, or property without due process of law. The founders modeled it on Chapter 39 of the Magna Carta, which prohibited the deprivation of a free man's private rights except by the lawful judgment of his peers and by the law of the land. By the founding, the Magna Carta was understood to mean that no subject would be deprived of a private right, that is, a right of life, liberty, or property, except in accordance with the law of the land, which consisted only of statutory and common law. A rule made by someone other than the legislature, such as the king, was not the law of the land. Chief Justice Coke famously held invalid the king's proclamation prohibiting new buildings in London because the king could not create any offense without Parliament. When the founders transplanted the same principle into the Due Process Clause, they ensured that when the government wanted to deprive people of the familiar core private rights of life, liberty, and property, it could not do so on the basis of a rule or a will not enacted by the legislature. Section B. Neither the Legislative Vesting Clause nor the Due Process Clause forbids Congress from delegating its other powers. As this court put it 2 centuries ago, although Congress cannot delegate powers that are strictly and exclusively legislative, it can certainly delegate others. Many of Congress's powers fall within the core legislative power subject to the non-delegation doctrine. For example, the Constitution gives Congress the power to regulate commerce among the states. Congress can thus make substantive rules for interstate trade, such as by restricting drug shipments across state lines, punishable with fines or imprisonment. Likewise, the Constitution gives Congress many other powers that implicate life, liberty, and property, including the power to provide for the punishment of counterfeiting, the power to provide for the punishment of treason, and the power to impose internal taxes. These powers cannot be delegated, as I have repeatedly explained. They cannot be delegated even if Congress delegates them unambiguously. Congress also has many powers that are not subject to the non-delegation doctrine. We now think of the powers listed in Article 1, Section 8 as quintessentially legislative powers, but many of them were actual, former, or asserted powers of the Crown, which the drafters decided to allocate to the legislative branch. These include the powers to raise and support armies, to fix the standards of weights and measures, to grant copyrights, to dispose of federal property, and, as discussed below, to regulate foreign commerce. None of these powers involves setting the rules for the deprivation of core private rights. Blackstone called them prerogative powers and sometimes executive. By one count, 13 of the 29 powers given to Congress in Article 1 were powers that Blackstone described as executive powers. For most of American history, the non-delegation doctrine was understood not to apply to these powers. The early Congresses felt free to delegate certain powers to President Washington in broad terms. Thus, the Constitution gives Congress the power to support armies, but Congress in 1798 delegated to the President the power to establish regulations for benefits to veterans wounded in the Revolutionary War. The Constitution gives Congress the power to grant patents, but Congress in 1790 delegated to executive officials the power to grant patents in their discretion. The Constitution gives Congress the power to borrow money, but Congress in 1790 delegated to the President the power to borrow up to $12 million on behalf of the United States in his discretion. The Constitution gives Congress the power to raise armies, but Congress in 1791 delegated to the President the power to raise an army of 2,000 troops in his discretion. And as I explained further below, the Constitution gives Congress the power to regulate foreign commerce, but early Congresses often delegated to the President the power to regulate foreign commerce. These early delegations had one thing in common: they did not implicate the legislative vesting clause or the due process clause. None of these statutes disturbed natural rights or intruded into the core of the legislative power. They therefore did not violate the non-delegation doctrine. The Constitutional Convention seemed to agree with this understanding of delegation. James Madison proposed an amendment clarifying that the President had the power to execute such other powers as were delegated by the national legislature, so long as the delegated powers were not legislative nor judiciary in their nature. Thus, in Madison's view, some of Congress's powers were not legislative and could be delegated to the President. Madison's proposal was rejected after others argued it was unnecessary. Madison agreed that the purpose of the proposed amendment was only to prevent doubts and misconstructions. Nobody disputed that Madison stated the correct scope of the non-delegation doctrine. Footnote 2. Thus, although many used the word legislative in the broader sense to describe powers that should initially belong to the legislature, the founders likely understood the legislative vesting clause to refer more narrowly to core legislative power. That understanding accorded with the views of separation of powers theorists of the time, who distinguished the three core functions of government from the institutions that would exercise them in any given polity. For non-delegation purposes, therefore, the key is to distinguish between strictly legislative authority, the power to make rules binding on persons or property within the nation, and other powers assigned to Congress. Carrying on. Part 2. As a matter of original understanding, historical practice, and judicial precedent, the power to impose duties on imports is not within the core legislative power. Congress can, therefore, delegate the exercise of this power to the President. Section A. Neither of the two constitutional foundations for the non-delegation doctrine forbids Congress from delegating to the President the power to impose duties on imports. Subsection 1. The legislative vesting clause provides no basis for applying the non-delegation doctrine to the power to impose duties on imports. The power over external affairs is, in origin and essential character, different from that over internal affairs. Although internal affairs are governed by the domestic law of one sovereign, external affairs implicate the relationship between sovereigns, which is subject to the law of nations. External affairs, then, are not susceptible to being directed by antecedent, standing, positive laws made by one nation. When a person goes abroad, he must resort to the political branches and ultimately the military, rather than the judiciary, for protection, can indebt the executive to foreign nations for his personal misconduct, and can trigger a foreign conflict. The power to regulate external affairs was accordingly not viewed as within the core legislative power at the founding. Blackstone described powers over intercourse with foreign nations as prerogative powers naturally belonging to the king. Locke agreed that this power must be lodged with the executive. Baron de Montesquieu classified all powers in respect to things dependent on the law of nations as part of the executive power. The legislative power, by contrast, applied only within the realm. The power to regulate external affairs included power over foreign commerce. At the founding, the external executive power included the transactions of the state with any other independent state. In Great Britain, the king had no unilateral legislative power, but he had much unilateral power over foreign commerce. His power over foreign commerce included the power to govern foreign trade and to prohibit any of his subjects from leaving the realm. Thomas Rutherford's Institutes of Natural Law, a treatise routinely cited by the founders, explained that the external executive power included the power of adjusting the rights of a nation in respect of trade. The power to impose duties on imports was a conventional method for governing foreign trade. It originated as a prerogative right of the king. Footnote 3. Parliament took some of that prerogative power away but delegated it back in broad terms to the king, who was still agreed to have no legislative power. Carrying on. Subsection 2. The Due Process Clause likewise provides no basis for applying the non-delegation doctrine to the power to impose duties on imports. The Due Process Clause protects rights, not privileges. Importing is a matter of privilege. The government can charge money for privileges without depriving a person of property for due process purposes. The government charges people money every day for a wide range of activities, such as to enter a government park, mail an envelope, apply for a copyright, or file a lawsuit. Because a person has no core private right to engage in these activities, the government is not subject to due process restraints in setting such charges. The due process question is not whether a government action raises revenue, but whether it implicates core private rights. Thus, when Congress delegates power to make regulations on federal land, the Secretary of Agriculture can set a charge for the privilege of grazing sheep on that land without thereby exercising the legislative power. Congress has, consistent with due process, delegated the power to set charges for a wide range of privileges. A person had no core private right to import goods at the founding. On the founders' understanding, statutes allowing importation of goods from abroad were thought to create mere privileges rather than core private rights. Foreign commerce was governed by the law of nations, which is a law of sovereigns, not of private individuals. Any attempt to introduce foreign goods without the expressed allowances of the sovereign was a violation of its sovereignty. Every state had a right to prohibit the entrance of foreign merchandises, including through the imposition of duties on imports. Because no one had a vested right to import any goods from abroad, the imposition of tariffs as a condition for importing these goods did not implicate the Due Process Clause any more than when the government charges money for other privileges. The power to impose duties on imports thus does not implicate either of the constitutional foundations for the non-delegation doctrine. Hence, even the strongest critics of delegation, myself included, have recognized that regulations of foreign commerce might not be subject to ordinary non-delegation limitations. So long as Congress complies with other constitutional limitations, it can delegate this power. Section B. Historical practice and precedent confirm that Congress can delegate the power to impose duties on imports. Subsection 1. Since the 1790s, Congress has consistently delegated to the President power over foreign commerce, including the power to impose duties on imports. Practically every volume of the United States statutes contains broad delegations to the President in the area of foreign commerce. The first Congress gave the President the power to prescribe rules and regulations that would govern any person licensing trade with Indians. Trade with Indians was regulated as a matter of external relations. In delegating this power, Congress did not specify or limit what kinds of regulations the President could impose. Pursuant to that broad delegation, the President restricted trading distilled spirits, required each trader to give intelligence to the government, and subdelegated to his superintendents the power to assign the limits within which each trader shall trade. Any person who violated the President's regulation would owe $1,000 payable to the President. Succeeding early Congresses delegated many more powers over foreign commerce to the President. In 1794, Congress delegated to the President the power to lay an embargo on all ships and vessels in the ports of the United States, including ships belonging to Americans, unless Congress was in session. It authorized the President to make such regulations as the circumstances of the case may require in exercising that delegated power. Congress allowed the President to impose the embargo as, in his opinion, the public safety shall so require. In 1795, Congress delegated to the President the power to permit the exportation of arms, cannon, and military stores, the law prohibiting the exportation of the same to the contrary notwithstanding. In 1798, Congress delegated to the President the power to discontinue prohibitions and restraints on commerce with France. In 1799, Congress delegated to the President the authority to discontinue and reimpose restraints and prohibitions on commerce with France when he deemed it expedient and consistent with the interests of the United States. And in 1800, Congress delegated to the President the power to remove a ban on trade with France and to re-establish certain restraints and prohibitions when he deemed it expedient. Footnote 4. Justice Gorsuch's interpretation of two early congressional debates is thus difficult to reconcile with what early Congresses actually did. Carrying on. Congress likewise delegated to the President the power to set duties on imports. In 1815, Congress delegated to the President the power to lower reciprocal duties when he was satisfied that other nations' trade policies no longer operated to the disadvantage of the United States. In 1824, Congress delegated to the President the power to lower and to reimpose duties in response to foreign nations' trade practices. Throughout the early decades of the Republic, Congress continued to delegate to the President similar powers over duties on imports on a regular basis. Presidents frequently changed the rates of duties on imports as to various foreign nations pursuant to those delegations. Footnote 5. This is just a number of citations to relevant presidential proclamations, so I'm not going to read them all out. Carrying on. Subsection 2. This court has consistently upheld Congress's delegation of power over foreign commerce, including the power to impose duties on imports. The court has long conveyed to Congress that it may invest the President with large discretion in matters arising out of the execution of statutes relating to trade and commerce with other nations. Since shortly after the founding, the court has rejected challenges to delegations of power over foreign commerce. Even when a challenged delegation, if it were confined to internal affairs, would be invalid, the court has upheld the delegation. There is a fundamental difference, the court has explained, between foreign or external affairs and domestic or internal affairs. Thus, Congress may of course delegate very large grants of its power over foreign commerce to the President, including when it comes to imposing duties on imports. When Congress has delegated to the President the power to impose duties on imports, this court has upheld those delegations. In Clark, the court upheld Congress's delegation to the President of the power to impose duties on nations whose importation policies he may deem to be reciprocally unequal and unreasonable. It explained that Congress had frequently, from the organization of the government to the present time, conferred powers over trade and commerce to the President. In J.W. Hampton Jr. and Company v. United States, the court upheld a delegation to the President to impose duties as necessary up to statutorily limited rates to make them reciprocal. And in Federal Energy Administration v. Algonquin S&G Inc., the court upheld a delegation of the power to impose a universal duty on imported oil. Footnote 6. The court has even suggested that the President has inherent peacetime authority to impose duties on imports. After the Mexican-American War ended, executive officials imposed duties on imports at a California port within the United States before Congress had passed an act to extend the collection of tonnage and import duties on the ports of California. The executive officials unilaterally extended Congress's earlier authorized duties to new ports. Although the court's reasoning was somewhat opaque, the court upheld the executive officials' unilateral peacetime duties in part because nobody has a right to introduce foreign goods except with the sovereign's expressed allowances. Carrying on. Although these cases involved duties on imports, the court nowhere suggested that a different non-delegation rule applied because the duty was a tax or raised revenue. Footnote 7. In fact, less than a year ago, the court explicitly rejected a special non-delegation rule for revenue-raising legislation. Carrying on. Part 3. Congress's delegation here was constitutional. The statute at issue in these cases, the International Emergency Economic Powers Act, delegates to the President a wide range of powers over foreign commerce. IEEPA gives the President, on conditions satisfied here, the power to regulate foreign commerce, including importation of foreign property. IEEPA's delegation of power to impose duties on imports complies with the non-delegation doctrine. Congress delegated to the President a version of the same power it had delegated to him in many statutes since the early days of the Republic. Congress limited that delegation to foreign commerce. In delegating the power to impose duties on imports, it gave the President no core legislative power to make substantive rules setting the conditions for deprivations of life, liberty, or property. Its delegation, therefore, complied with the constitutional separation of powers and is consistent with centuries of practice and precedent. It did not need to exercise that power itself and did not need to delegate it unambiguously, even though, as Justice Kavanaugh explains, it did. The principal opinion bases its decision on the major questions doctrine. In some cases, the court has used the major questions doctrine as a canon of statutory interpretation because delegations of powers are unlikely to be subtle. In other cases, the court has used it to avoid what would have been originally understood as an unconstitutional delegation of legislative power. In today's cases, neither the statutory text nor the Constitution provide a basis for ruling against the President. I respectfully dissent. Justice Kavanaugh, with whom Justice Thomas and Justice Alito join dissenting. Acting pursuant to his statutory authority to regulate importation under the 1977 International Emergency Economic Powers Act, or IEEPA, the President has imposed tariffs on imports of foreign goods from various countries. The tariffs have generated vigorous policy debates. Those policy debates are not for the federal judiciary to resolve. Rather, the judiciary's more limited role is to neutrally interpret and apply the law. The sole legal question here is whether, under IEEPA, tariffs are a means to regulate importation. Statutory text, history, and precedent demonstrate that the answer is clearly yes. Like quotas and embargoes, tariffs are a traditional and common tool to regulate importation. Since early in U.S. history, Congress has regularly authorized the President to impose tariffs on imports of foreign goods. Presidents have often used that authority to obtain leverage with foreign nations, help American manufacturers and workers compete on a more level playing field, and generate revenue for the United States. Numerous laws such as the Trade Expansion Act of 1962 and the Trade Act of 1974 continue to authorize the President to place tariffs on foreign imports in a variety of circumstances, and presidents have often done so. In recent years, Presidents George W. Bush, Obama, and Biden have all imposed tariffs on foreign imports under those statutory authorities. President Trump has similarly imposed tariffs and has done so here under IEEPA. During declared national emergencies, IEEPA broadly authorizes the President to regulate international economic transactions. Most relevant for this case, during those national emergencies, IEEPA grants the President the power to regulate importation of foreign goods. In early 2025, President Trump declared 2 national emergencies pursuant to the National Emergencies Act. One emergency concerned drug trafficking into the United States. The other emergency involved trade imbalances with foreign nations that have harmed American manufacturers and workers. To help address those emergencies, the President drew upon his authority in IEEPA to regulate importation, and he imposed tariffs on imports from various countries. The plaintiffs argue, and the court concludes, that the President lacks authority under IEEPA to impose tariffs. I disagree. In accord with Justice Taranto's careful and persuasive opinion in the Federal Circuit, I would conclude that the President's power under IEEPA to regulate importation encompasses tariffs. As a matter of ordinary meaning, including dictionary definitions and historical usage, the broad power to regulate importation includes the traditional and common means to do so, in particular, quotas, embargoes, and tariffs. History and precedent confirm that conclusion. In 1971, President Nixon imposed 10% tariffs on almost all foreign imports. He levied the tariffs under IEEPA's predecessor statute, the Trading with the Enemy Act, which similarly authorized the President to regulate importation. The Nixon tariffs were upheld in court. Moreover, in 1976, a year before IEEPA was enacted, this court unanimously ruled that a similarly worded statute authorizing the President to adjust the imports permitted President Ford to impose monetary exactions on foreign oil imports. For both the Nixon tariffs and the Ford tariffs upheld by this court in Algonquin, the relevant statutory provisions did not specifically refer to tariffs or duties, but instead more broadly authorized the President to regulate importation or to adjust the imports. Therefore, when IEEPA was enacted in 1977 in the wake of the Nixon and Ford tariffs and the Algonquin decision, Congress and the public plainly would have understood that the power to regulate importation included tariffs. If Congress wanted to exclude tariffs from IEEPA, it surely would not have enacted the same broad regulate importation language that had just been used to justify major American tariffs on foreign imports. Importantly, IEEPA's authorization for the President to impose tariffs did not grant the President any new substantive power. Since the founding, numerous statutes have authorized and still do authorize the president to impose tariffs and other foreign import restrictions. IEEPA merely allows the president to impose tariffs somewhat more efficiently to deal with foreign threats during national emergencies. Context and common sense buttress that interpretation of IEEPA. The plaintiffs and the court acknowledge that IEEPA authorizes the president to impose quotas or embargoes on foreign imports, meaning that a president could completely block some or all imports. But they say that IEEPA does not authorize the president to employ the lesser power of tariffs, which simply condition imports on a payment. As they interpret the statute, the president could, for example, block all imports from China but cannot order even a $1 tariff on goods imported from China. That approach does not make much sense. Properly read, IEEPA does not draw such an odd distinction between quotas and embargoes on the one hand and tariffs on the other. Rather, it empowers the president to regulate imports during national emergencies with the tools presidents have traditionally and commonly used, including quotas, embargoes, and tariffs. The court today nonetheless concludes otherwise and holds that IEEPA does not authorize the president to impose tariffs to deal with the declared drug trafficking and trade deficit emergencies. But the court's decision is splintered. In today's 6-justice majority, 3 justices, Justice Sotomayor, Justice Kagan, and Justice Jackson, interpret IEEPA not to authorize tariffs as a matter of ordinary statutory interpretation. I disagree for the reasons noted above and elaborate on at length in this opinion. 3 other justices, the Chief Justice, Justice Gorsuch, and Justice Barrett, lean on the major questions canon of statutory interpretation to resolve this case. That important canon requires clear congressional authorization for an executive action of major economic and political significance, particularly when the executive exercises an unheralded power. In my view, as I will explain, the major questions canon does not control here for 2 alternative and independent reasons. First, the statutory text, history, and precedent constitute clear congressional authorization for the president to impose tariffs under IEEPA. In particular, throughout American history, presidents have commonly imposed tariffs as a means to regulate importation. So tariffs were not an unheralded power when Congress enacted IEEPA in 1977 and authorized the presidents to regulate importation of foreign goods. Therefore, the major questions doctrine is satisfied here. Second, in any event, the court has never before applied the major questions doctrine in the foreign affairs context, including foreign trade. Rather, as Justice Robert Jackson summarized and remains true, this court has always recognized the unwisdom of requiring Congress in this field of governmental power to lay down narrowly definite standards by which the president is to be governed. In foreign affairs cases, courts read the statute as written and do not employ the major questions doctrine as a thumb on the scale against the president. Although I firmly disagree with the court's holding today, the decision might not substantially constrain a president's ability to order tariffs going forward. That is because numerous other federal statutes authorize the president to impose tariffs and might justify most, if not all, of the tariffs at issue in this case, albeit perhaps with a few additional procedural steps that IEEPA, as an emergency statute, does not require. Those statutes include, for example, the Trade Expansion Act of 1962, the Trade Act of 1974, and the Tariff Act of 1930. In essence, the court today concludes that the president checked the wrong statutory box by relying on IEEPA rather than another statute to impose these tariffs. In the meantime, however, the interim effects of the court's decision could be substantial. The United States may be required to refund billions of dollars to importers who paid the IEEPA tariffs, even though some importers may have already passed on costs to consumers or others. As was acknowledged at oral argument, the refund process is likely to be a mess. In addition, according to the government, the IEEPA tariffs have helped facilitate trade deals worth trillions of dollars, including with foreign nations from China to the United Kingdom to Japan and more. The court's decision could generate uncertainty regarding those trade arrangements. In any event, the only issue before the court today is one of law. In light of the statutory text, long-standing historical practice, and relevant Supreme Court precedents, I would conclude that IEEPA authorizes the president to regulate importation by imposing tariffs on foreign imports during declared national emergencies. I therefore respectfully dissent. Footnote 1. In this dissent, when I refer to the Chief Justice's opinion, I am referring to the parts of the Chief Justice's opinion that speak for only 3 justices, namely parts 2A, 2, and 3. Carrying on. Part 1. Before turning to the specifics of IEEPA's text, history, and precedent, I briefly review several fundamental constitutional principles about the roles of the 3 branches of the United States government with respect to this case. First, the plaintiffs and their amici echoed by the court rhetorically emphasize that Article 1, Section 8 of the Constitution assigns Congress, not the President, authority over tariffs. That rhetoric is a red herring in this case because no one disputes the point. Everyone, including the President, agrees that Congress possesses constitutional authority over tariffs. The important principle here, as everyone also acknowledges, is that Congress may in turn authorize the President to impose tariffs. Indeed, since the beginning of the Republic, Congress has regularly empowered the President to order tariffs and other foreign import restrictions under various circumstances. As noted above, many current federal laws continue to grant the President expansive tariff authority, including the Trade Expansion Act of 1962, the Trade Act of 1974, and the Tariff Act of 1930. Neither the plaintiffs nor the court has suggested that the numerous laws granting tariff power to the President violate the Constitution's separation of powers. Second, and relatedly, the President does not claim unilateral authority to impose IEEPA tariffs without congressional authorization or over a congressional prohibition. On the contrary, the President's argument recognizes that in exercising his statutory tariff power under IEEPA, he must act within the scope of Congress's authorizations and abide by Congress's limitations. And the executive has further acknowledged that the judiciary maintains the final word in justiciable cases on whether Congress has authorized the President to impose those tariffs under IEEPA. The President here contends only that Congress, by enacting IEEPA in 1977, authorized the President to impose tariffs on foreign imports in declared national emergencies. To use the familiar vernacular of Justice Robert Jackson in Youngstown, the President argues that this case falls into Category 1, where the President is acting pursuant to an express or implied authorization of Congress. The President has not here asserted authority to impose IEEPA tariffs in a peacetime emergency, in a Youngstown Category 2 or 3 scenario. Footnote 2. Category 2 applies when the President acts in absence of either congressional grant or denial of authority. Category 3 occurs when the President takes measures incompatible with the expressed or implied will of Congress. Carrying on. Third, Congress possesses a variety of tools to limit the President's tariffs, directly via new legislation or, perhaps more readily, by not approving annual appropriations necessary for the executive branch to continue to implement the tariffs. Importantly, the House, the Senate, and the President annually approve most appropriations. As a result, each House of Congress and the President independently possess de facto veto power over particular appropriations. Footnote 3. 2 technical points for clarity. Given current Senate filibuster rules, a determined minority of the Senate could block an appropriation. Also, even over presidential veto, 2/3 of both houses could together approve certain appropriations. Carrying on. Of course, many different appropriation items are usually considered and packaged together, so the negotiations can be complex. But the point stands, Congress is not a helpless bystander when it comes to the President's exercise of tariff authority under IEEPA. In Congress, moreover, everything is related to everything else, as the saying goes. Members and committees of Congress possess substantial tools of leverage over the executive branch. Congress could, for example, wield its authority over oversight, legislation, confirmations, or appropriations to pressure the President to reduce or eliminate some or all of the IEEPA tariffs. In light of Congress's appropriations authority and its other robust powers, it is not correct to suggest, as the Chief Justice's opinion today elliptically does, that 2/3 of majorities of both houses of Congress would need to pass new legislation over a presidential veto in order to limit these IEEPA tariffs, or more generally, to restrict the President's use of IEEPA to impose tariffs. Part 2. This case represents one straightforward question of statutory interpretation. Does Congress's explicit grant of authority in IEEPA for the President to regulate importation of foreign goods in declared national emergencies authorize the President to impose tariffs? The answer is a clear yes. Footnote 4. The relevant statutory provision provides in full, quote, "At the times and to the extent specified in Section 1701 of this title, the President may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, b. Investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercise of any right, power, or privilege with respect to, or transactions involving, any property in which any foreign country or a national thereof has any interest by any person, or with respect to any property subject to the jurisdiction of the United States." End quote. 50 U.S.C. Section 1702A1. Carrying on. Section A. I begin, as always, with the statutory text. In 1941, a few days after Pearl Harbor, Congress first enacted the relevant language regulate importation in an amendment to the 1917 Trading with the Enemy Act known as TWEA. After that 1941 amendment, TWEA authorized the President to regulate importation both during wartime and during peacetime national emergencies. Then, in 1977, Congress split TWEA into two separate statutes. As relevant here, Congress amended TWEA to authorize the President to regulate importation during wartime only, and Congress enacted a separate statute, IEEPA, that granted the President the power to regulate importation during peacetime national emergencies. The relevant IEEPA text authorized the President to regulate importation by means of instructions, licenses, or otherwise. As the term otherwise indicates, the broadly worded statute did not exclude tariffs or dictate any specific means of regulating importation. Footnote 5. Congress no doubt appreciated that quotas, embargoes, tariffs, and the like can be powerful tools for regulating foreign commerce. Congress calibrated the statute by exempting various categories of goods, meaning that those categories of goods are not subject to tariffs under IEEPA. Carrying on. At the time of TWEA's amendment in 1941 and IEEPA's enactment in 1977, the ordinary dictionary definition of regulate was to control, to adjust by rule, or to subject to governing principles or laws. Imposing tariffs on imports is clearly a way of controlling imports, governing or directing imports according to rule, adjusting imports by rule, method, or established mode, or, more generally, subjecting imports to governing principles or laws. So the dictionary definitions amply demonstrate that tariffs are a means to regulate importation of foreign imports. Footnote 6. As other statutory authorities textually confirm, moreover, Congress has long understood tariffs to be a tool for regulating imports. For example, Section 350 of the Tariff Act of 1930 refers to duties and other import restrictions, and Section 122 of the Trade Act of 1974 uses the phrase restrict imports to cover duties. Both statutes take it as a given, therefore, that tariffs are a means of regulating imports. Carrying on. Consistent with those dictionary definitions and statutory references, tariffs historically have been, and still are, a common means for the United States to regulate importation of foreign goods. Footnote 7. As the parties and the court used the terms tariffs and duties are synonymous. Carrying on. In determining the ordinary meaning of regulate importation, the meaning of the related phrase regulate commerce is also instructive. That phrase has long been interpreted to encompass tariffs. Since the founding, the Constitution's assignment to Congress of the broad power to regulate foreign commerce has been understood to include tariffs on foreign imports. As Chief Justice Marshall explained, the right to regulate commerce, even by the imposition of duties, was not controverted. So too Justice Story. The power to regulate commerce includes the power of laying duties to countervail the regulations and restrictions of foreign nations. And still more Story. To lay duties is a common means of executing the power to regulate commerce. James Madison likewise stated that it cannot be inferred that the power to regulate trade does not involve the power to tax it. Marshall, Story, and Madison make for a formidable trio, and this court has long echoed the Marshall, Story, Madison understanding that tariffs regulate foreign commerce. The laying of a duty on imports, although an exercise of the taxing power, is also an exercise of the power to regulate foreign commerce. And again, even though the taxing power is a distinct power that embraces the power to lay duties, it does not follow that duties may not be imposed in the exercise of the power to regulate commerce. The contrary is well established. Footnote 8. Importantly, those historical sources also fully demonstrate that the Foreign Commerce Clause, not just the Taxing Clause, authorizes tariffs on foreign imports. Carrying on. The plaintiffs and the court today seize on the word regulate in isolation and say that it does not encompass the power to tariff. But the relevant statutory phrase is regulate importation, and we must look to the meaning of the phrase as a whole as our precedents dictate. As I have explained, since the founding, tariffs on foreign imports have been a common means of regulating foreign commerce, including imports. Notably, under the court's reading of the word regulate, Marshall, Story, and Madison all erred by concluding that the power to regulate foreign commerce includes the power to impose tariffs on foreign imports. That seems dubious. If the federal government's constitutional power to regulate foreign commerce includes tariffs, as this court has repeatedly said, and if the power to regulate importation is the power to regulate foreign commerce with respect to imports, as it plainly is, then IEEPA's authorization for the President to regulate importation clearly encompasses tariffs. Historical usage and that textual syllogism further buttress the dictionary definitions and help establish that tariffs are a means to regulate importation. Footnote 9. The plaintiffs in the court offer a double bank shot argument that regulate importation cannot include monetary exactions because IEEPA also authorizes the President to regulate exportation, and imposing duties on exports would violate the Constitution. But as the government thoroughly explains, when a statute contains a long string of verbs and nouns, each term should be understood in context. The relevant section of IEEPA contains 9 verbs and 11 objects for a total of 99 combinations. We do not need to construe each word of the statute to ensure that it is perfectly aligned in all 99 pairings. Carrying on. Section B. Perhaps even more significantly, when IEEPA was enacted in 1977, Congress and the public clearly would have understood that the phrase regulate importation encompassed tariffs. We know as much not only because of the dictionary definitions and the traditional understanding of tariffs as a tool to regulate foreign imports. We also know as much because of tariffs imposed by 2 presidents and approved by federal courts, including the Supreme Court, in the years shortly before IEEPA's 1977 enactment. First, in 1971, President Nixon imposed 10% tariffs across the board on virtually all imports from every country in the world. Those tariffs were justified under IEEPA's predecessor statute, the Trading with the Enemy Act, or TWEA. Footnote 10. President Nixon did not explicitly cite the regulate importation language of TWEA when imposing those worldwide tariffs, but that merely reflected a diplomatic nicety given the title of the Trading with the Enemy Act and the desire to avoid publicly suggesting that allies were enemies. Once in court, the president openly invoked the regulate importation language of TWEA as justification for the tariffs. Carrying on. Like IEEPA now, TWEA at that time authorized the president to regulate importation during national emergencies as well as wartime, and like IEEPA now, TWEA did not specifically use the words tariff or duty. The Nixon tariffs did not fly below the radar. On the contrary, President Nixon announced the worldwide 10% tariffs in a primetime address to the nation on August 15, 1971. He imposed the tariffs as a tool to make certain that American products will not be at a disadvantage and that the product of American labor will be more competitive. President Nixon sought to remove the unfair edge that some of our foreign competition has, and he declared that when the unfair treatment is ended, the import tax will end. The Nixon tariffs apply to almost all imports of foreign goods into the United States, and the tariffs had no time limit. To be sure, they did not end up lasting forever, but President Nixon terminated them only because the tariffs, as intended, induced major American trading partners to negotiate new agreements. The Nixon tariffs garnered substantial national and international attention and were generally popular in Congress. Predictably, however, the tariffs sparked litigation challenges. In 1975, the Court of Customs and Patent Appeals, the predecessor to the Federal Circuit, upheld the Nixon tariffs as a lawful exercise of the President's authority to regulate importation under TWEA. The losing plaintiffs did not seek further review in this court. 2 years later, in 1977, when Congress divided TWEA into two, Congress retained that same regulate importation language in both laws, in TWEA for wartime and in IEEPA for peacetime national emergencies. In doing so, members of Congress were plainly aware, after all, how could they not be, that the regulate importation language had recently been invoked by the President and interpreted by the courts to encompass tariffs. Indeed, the House Committee report noted that the relevant regulate importation provision in TWEA came into play when, on August 15, 1971, President Nixon declared a national emergency with respect to the balance of payments crisis, and under that emergency imposed a surcharge on imports. The report further referenced the appeals court's holding in Yoshida that TWEA authorized imposition of duties because of the existence of the national emergency. Footnote 11. I cite the committee report not for determining the meaning of IEEPA, but rather to help show as an historical and factual matter that members of Congress were aware of both the Nixon tariffs and the appeals court decision upholding those tariffs as a tool to regulate importation. Carrying on. The Nixon tariffs persuasively demonstrate that members of Congress and the public would have understood the phrase regulate importation to include tariffs when IEEPA was enacted in 1977. If Congress wanted to exclude tariffs from IEEPA's scope, why would it enact the exact statutory language from TWEA that had just been invoked by the President and interpreted by the courts to cover tariffs? Neither the plaintiffs nor the court today offers a good answer to that question. Understandably so, because there is no good answer. The court tries to dodge the force of the Nixon tariffs by observing that one appeals court's interpretation of regulate importation to uphold President Nixon's tariffs does not suffice to describe that interpretation as well settled when IEEPA was enacted in 1977. Fair enough, but that is not the right question. The question is what members of Congress and the public would have understood regulate importation to mean when Congress enacted IEEPA in 1977. Given the significant and well-known Nixon tariffs, it is entirely implausible to think that Congress's 1977 reenactment of the phrase regulate importation in IEEPA was somehow meant or understood to exclude tariffs. Footnote 12. The Chief Justice's opinion also tries to dismiss President Nixon's tariffs as being of limited amount, duration, and scope. That claim appears incorrect on all 3 points, as Judge Taranto carefully explained in his Federal Circuit opinion. President Nixon imposed 10% tariffs on virtually all imports from every country in the world for an unspecified duration. Carrying on. Second, if one holds any lingering doubts about Congress's and the public's understanding of the power to regulate importation as of 1977, a second episode shortly before IEEPA's enactment should answer them. In 1975, President Ford imposed significant monetary exactions on foreign imports of oil. He acted under Section 232 of the Trade Expansion Act of 1962. Like TWEA and IEEPA, the relevant provision of Section 232 did not use the word tariff or duty. Rather, Section 232 broadly authorized the President to adjust the imports of a product. Language akin to the regulate importation language in IEEPA and TWEA. In contrast to the Nixon tariffs, the Ford tariffs on oil imports generated some pushback in Congress, and a group of utility companies and states quickly sued, arguing that the relevant statutory phrase adjust the imports did not authorize monetary exactions such as tariffs. Over a dissent, the D.C. Circuit agreed with the plaintiffs challenging the Ford tariffs. Much like the court's decision today, the D.C. Circuit in the Ford matter concluded that Congress must explicitly authorize monetary exactions and that the applicable statutory phrase adjust the imports did not do so. In 1976, the Ford tariffs case came to the Supreme Court. In this court, the plaintiffs pressed nearly identical arguments and rhetorical flourishes as those advanced by the plaintiffs and repeated by the court in today's case. The plaintiffs argued that the Ford-imposed monetary exactions involved the broadest exercise of tariff power in the history of the American Republic, reminiscent of George III's Stamp Act. They contended that the statute's authorization for the president to adjust the imports did not allow for such monetary exactions because the statute did not mention the tariff on its face. They asserted that this court had never implied a tax, never in the history of this court from language which does not explicitly provide for tax, and here there is no such language. There is no language that mentions a measure of tax or a method of calculation of tax. There is no such thing. They echoed the D.C. Circuit's holding that reading the phrase adjust the imports to encompass tariffs would be an anomalous departure from the consistently explicit, well-defined manner in which Congress had delegated control over foreign trade and tariffs. And they claimed that interpreting the statute to include fees undermines the whole tariff structure of the United States. Importantly, the Algonquin plaintiffs acknowledged, as do the plaintiffs and the court in today's case, that the statutory language adjust the imports would allow the president to impose quotas and embargoes on foreign imports, so a president could completely block all imports or limit their quantity. But according to the plaintiffs, Congress's adjust the imports language precluded the president from exercising the lesser power of imposing monetary exactions such as tariffs. The Supreme Court decided the Ford tariffs case in 1976. The court unanimously reversed the D.C. Circuit and flatly rejected the plaintiffs' arguments. The court held that the statutory phrase adjust the imports, even though it did not include terms such as tariff, tax, duty, or fee, granted President Ford the authority to impose not only quotas and embargoes, but also monetary exactions on foreign imports. The court analyzed the statutory text and found no support in the language of the statute for the plaintiff's argument that adjust the imports should be read to encompass only quantitative methods, i.e. quotas, as opposed to monetary methods, i.e. license fees, of effecting such adjustments. The court later explained, unless one assumes, and we do not, that quotas will always be a feasible method of dealing directly with national security threats posed by the circumstances under which imports are entering the country, limiting the president to the use of quotas would effectively and artificially prohibit him from directly dealing with some of the very problems against which Section 232B is directed. In short, according to the unanimous Algonquin Court, the statutory text, structure, and logic of Section 232 definitively established that the president's authority to adjust the imports encompassed not only quotas and embargoes, but also monetary exactions such as tariffs and fees. Today's case should follow a fortiori from Algonquin. No meaningful daylight exists between the statutory phrase adjust the imports in Section 232 at issue in Algonquin and the phrase regulate importation in IEEPA at issue here. The plaintiffs and the court in this case do not even try to distinguish adjust the imports from regulate importation, nor could they. Recall that the dictionary definition of regulate includes adjust by rule. To adjust imports is to regulate imports. Indeed, if anything, the phrase regulate importation is broader in scope than the phrase adjust the imports. So if Section 232's adjust the imports includes tariffs, as this court unanimously concluded in Algonquin in 1976, just a year before IEEPA, how can IEEPA's regulate importation not include tariffs? Algonquin's importance for this case rests not merely on its status as a unanimous, on-point Supreme Court statutory precedent, although it is surely significant for that reason as well. The case is especially consequential for present purposes because it helps show the ordinary public and congressional understanding of regulate importation in 1977 when Congress enacted IEEPA. To be clear, the question here is not what individual members of Congress might have subjectively intended in 1977. The question is the ordinary meaning and understanding of the words that Congress used, given that the phrase adjust the imports, again, in a statutory provision that did not use specific words such as tariff or duty, was unanimously held by this court in 1976 to include tariffs, and given that President Nixon had similarly relied on his statutory authority to regulate importation to impose 10% tariffs on virtually all imports from all countries, could a rational citizen or member of Congress in 1977 have understood to regulate importation in IEEPA not to encompass tariffs? I think not. Any citizens or members of Congress in 1977 who somehow thought that the regulate importation language in IEEPA excluded tariffs would have had their heads in the sand. The court today tries its best to distinguish Algonquin on the ground that Section 232 included sweeping language authorizing the president to take such action that he deems necessary, whereas IEEPA does not. But the Algonquin court did not rely on that language and instead focused on whether the phrase adjust the imports included monetary exactions. Moreover, IEEPA itself broadly authorizes the president to regulate importation by means of instructions, licenses, or otherwise in order to deal with an unusual and extraordinary foreign threat to the national security, foreign policy, or economy of the United States. That language is similarly expansive, authorizing the president to impose various tools to regulate importation. In short, just as the phrase adjust the imports includes tariffs, as Algonquin held, so too the phrase regulate importation includes tariffs. Footnote 13. In addition, IEEPA expressly authorizes the president to require licenses, and to obtain a license, a business may need to pay license fees that can be equivalent to tariffs. Carrying on. The court also attempts to brush aside Algonquin by citing an entirely different provision of the Trade Expansion Act, one that was not at issue in Algonquin, that expressly refers to a duty. The Algonquin court did not rely on or even mention that provision when concluding that the statutory phrase adjust the imports includes tariffs, for good reason. That provision, which states that no action shall be taken to decrease or eliminate an existing duty or other import restriction, concerns only the power to reduce existing tariffs and plainly does not bear on a president's power to impose tariffs under Section 232. To sum up on the Nixon and Ford tariffs, when enacting IEEPA in 1977, Congress employed the exact language recently invoked by President Nixon to justify 10% worldwide tariffs, and IEEPA came fast on the heels of this court's unanimous 1976 decision in Algonquin, which held that substantially similar adjust the imports language authorized President Ford's tariffs on oil imports. Importantly, moreover, the statutory provision authorizing the Nixon and Ford tariffs did not use specific words such as tariff or duty. The Nixon and Ford tariffs, this court's decision in Algonquin, and the ordinary and historical understanding of tariffs as a means of regulating imports together render it all but impossible to conclude that Congress in 1977 implicitly excluded tariffs when retaining TWEA's regulate importation language in IEEPA. If Congress in 1977 wanted to exclude tariffs from the president's IEEPA toolkit, either it would have not retained the phrase regulate importation, or it would otherwise have made clear in IEEPA that the power to impose tariffs was excluded. Congress did neither. Section C. Two additional historical points strongly reinforce that analysis of text and precedent, and further demonstrate that regulate importation in IEEPA encompasses tariffs. First, U.S. history from the 1800s through IEEPA's 1977 enactment illustrates how the statute came to incorporate the president's long-recognized authority to impose tariffs during wartime and then also during peacetime national emergencies. Long before the initial 1917 enactment of the Trading with the Enemy Act, which was IEEPA's predecessor, the president possessed inherent wartime authority to prohibit commercial relations with enemy nations. That inherent authority included the power to impose tariffs on foreign imports. For example, during the Mexican-American War in the 1840s, President Polk permitted only limited trade with Mexico subject to tariffs. Some members of Congress publicly questioned whether the president possessed that tariff authority. In response, President Polk justified the tariffs on the ground that the military right to exclude commerce altogether from the ports of the enemy in our military occupation included the minor right of admitting it under prescribed conditions. In 1854, the Supreme Court agreed with President Polk's view, stating, "No one can doubt that the President, as Commander-in-Chief of our naval force, possessed the authority to regulate import duties." In 1862, President Lincoln partially lifted an existing blockade against the Confederate States during the Civil War. Like President Polk, he then permitted limited trade subject to a monetary fee. A group of cotton sellers later sued, arguing that the fee was essentially a tax and not authorized by any act of Congress, which alone had the power to impose taxes. The Supreme Court rejected that argument, holding that there was no question that requiring a monetary fee to trade with the Confederate States was part of the war power of the United States government. The existence of war meant a suspension of commercial intercourse between the opposing sections of the country, so if such a course of dealing were to be permitted at all, it would necessarily be upon such conditions as the government chose to prescribe. And in 1898, during the Spanish-American War, President McKinley imposed duties upon the occupation of any forts and places in the Philippine Islands. This court subsequently recognized those McKinley duties as a lawful wartime measure. Why does that wartime history matter? Because when Congress first enacted the Trading with the Enemy Act in 1917 during World War I, it statutorily codified some of the president's long-standing inherent wartime powers over foreign trade, which included the power to tariff. For the duration of World War I, TWEA authorized the president, when he found the public safety so requires, to make it unlawful to import into the United States from any named country certain goods except at such time or times and under such regulations or orders and subject to such limitations and exceptions as the president shall prescribe. In 1933, during the Great Depression, and 5 days after President Franklin Roosevelt took office, Congress expanded TWEA to apply not only in wartime but also during a national emergency declared by the president. 8 years later, in 1941, a few days after Pearl Harbor, Congress again amended TWEA's language by more succinctly providing that the president may regulate certain transactions, including importation, under TWEA during war or any other period of national emergency declared by the president. So as of 1941, and from then to 1977, TWEA expressly authorized the president to regulate importation both during wartime and during peacetime national emergencies. Historically, presidents had regulated importation by imposing tariffs, as the Polk, Lincoln, and McKinley tariffs illustrated. So TWEA from 1941 to 1977 was best understood to authorize tariffs. During that period, as I have discussed at length above, President Nixon in 1971 imposed 10% tariffs on almost all imports of foreign goods and relied on TWEA's regulate importation language to justify them. Those tariffs were upheld in court. Then in 1977, Congress amended TWEA and divided it into two statutes. TWEA retained the president's power to regulate importation, but only during wartime. The newly enacted second law, IEEPA, also retained the power to regulate importation, and it would apply during periods of declared national emergencies. As this court has previously recognized, IEEPA was directly drawn from TWEA, and the relevant authorities are essentially the same. Therefore, IEEPA's specific language, regulate importation, was not new statutory text when Congress enacted IEEPA in 1977. Far from it. Beginning in 1941, TWEA had already authorized the president to regulate importation of foreign goods in wartime and national emergencies. And the earlier Polk, Lincoln, and McKinley examples, as well as the later Nixon example, demonstrated that the power to regulate importation historically encompassed tariffs as well as quotas and embargoes. The plaintiffs and the court today assert that wartime precedents do not govern peacetime, but Congress modeled IEEPA on TWEA precisely so that the president could continue to exercise certain wartime authorities such as quotas, embargoes, and tariffs during peacetime national emergencies as well. Congress first explicitly extended that wartime power to national emergencies in 1933 during the Franklin Roosevelt administration, and Congress has continued to authorize the president to exercise that power in both wartime and peacetime emergencies. In short, Congress in 1977 enacted the same regulate importation language that had long been understood to encompass tariffs. Second, contrary to the tenor of the plaintiffs' and the court's arguments here, it would not have been at all unusual or surprising for Congress, when enacting IEEPA in 1977, to authorize the president to impose tariffs. Since the early days of the Republic, Congress has regularly granted the president the power to regulate foreign trade, including via tariffs. A few examples. In 1810, Congress authorized the president to prohibit imports from Great Britain or France if either nation violated the neutral commerce of the United States. In 1890, Congress granted the president the power to impose import duties in response to duties imposed by other countries on American exports. In 1922, Congress empowered the president to levy import duties under certain conditions. In 1930, Congress enacted Section 338 of the Tariff Act, which authorizes the president to impose tariffs when he finds that any foreign country places any burden or disadvantage upon the commerce of the United States. In 1962, Congress authorized the president in Section 232 of the Trade Expansion Act to adjust the imports of a foreign good that threatens to impair national security. In 1974, under Section 201 of the Trade Act, Congress granted the president the power to take all appropriate and feasible action within his power, including imposing a duty on imports that, according to the U.S. International Trade Commission, have caused or threatened serious injury to a domestic industry. So, too, Section 301 authorizes the president to direct the U.S. Trade Representative to impose duties on countries engaging in unfair trade practices. And Section 122 of the Act grants the president the power to impose a temporary import surcharge to deal with large and serious United States balance of payment deficits. Those many statutes definitively establish that Congress, since near the founding, has delegated to the president broad power to impose tariffs on foreign imports. So it would hardly have been unusual or surprising for Congress to have granted tariff power to the president during wartime and peacetime national emergencies, as it did in TWEA and IEEPA. To be sure, given those other statutes that authorize the president to impose tariffs on foreign imports, one might reasonably ask, why did the president need distinct tariff authority under IEEPA during peacetime emergencies, or for that matter under TWEA during wartime? The basic answer is that IEEPA is an emergency statute that allows the president to impose tariffs somewhat more quickly, as would be expected in a declared national emergency. Similarly, in wartime, TWEA allows the president to impose tariffs more rapidly. But critically, TWEA and IEEPA do not authorize the president to exercise some new substantive power. Rather, they authorize the president to exercise a commonly granted power, tariffs, more efficiently than under the many ordinary tariff statutes. The plaintiffs and the court assert that interpreting IEEPA to authorize tariffs would in effect evade specific limits on tariffs in certain other tariff statutes, but as Judge Taranto explained in the Federal Circuit, Congress in IEEPA understandably afforded the president more flexibility to act during declared emergencies, just as Congress had done in TWEA for wartime since 1917. Moreover, IEEPA is not a blank check. IEEPA contains its own limits, including the requirement that the tariffs deal with an unusual and extraordinary foreign threat, a default one-year limit on emergencies, an enumerated list of exceptions, and comprehensive congressional reporting requirements. And as noted above, each House of Congress possesses a variety of tools to revoke, limit, or influence a president's IEEPA or TWEA tariffs. Relatedly, it is also not surprising that the many ordinary tariff statutes expressly refer to tariffs, duties, and the like, while IEEPA and TWEA do not. As Judge Taranto astutely explained, Congress in those statutes was overwhelmingly focused on tariff issues, whereas Congress in IEEPA, as in TWEA, was focused on the subject of emergencies and giving plainly broad emergency authority regarding foreign property. In sum, in authorizing the president to regulate importation, IEEPA embodies an eyes-open congressional grant of broad emergency authority in this foreign affairs realm, which unsurprisingly extends beyond authorities available under non-emergency laws, and Congress confirmed the understood breadth by tying IEEPA's authority to particularly demanding procedural requirements for keeping Congress informed. Section D. Finally, all of that text, history, and precedent is further reinforced by two compelling pieces of context. First, interpreting IEEPA to exclude tariffs creates nonsensical textual and practical anomalies. The plaintiffs and the court do not dispute that the president can act in declared emergencies under IEEPA to impose quotas or even total embargoes on all imports from a given country. But the president supposedly cannot take the far more modest step of conditioning those imports on payment of a tariff or duty. Textually, however, if quotas and embargoes are a means to regulate importation, how are tariffs not a means to regulate importation? Nothing in the text supports such an illogical distinction. And it does not make much sense to think that IEEPA allows the president in a declared national emergency to, for example, shut off all or most imports from China, but not to impose even a $1 tariff on imports from China. As Judge Toronto forcefully pointed out in the Federal Circuit, tariffs are just a less extreme, more flexible tool for pursuing the same objective of controlling the amount or price of imports that, after all, could be barred altogether. All of that explains why this court in Algonquin definitively rejected such a strange slice-and-dice approach to the president's statutory power to adjust imports. If quotas and embargoes are authorized, so are tariffs. In short, whether through prohibiting imports via embargoes or regulating the quantity of imports through quotas or regulating the price of imports with tariffs, Congress granted the president flexibility in declared national emergencies to take various actions affecting imports of foreign goods. The plaintiffs and the court have no coherent textual or commonsensical explanation for why a rational Congress would, in such a momentous and carefully considered statute as IEEPA, grant the president the power to impose quotas and embargoes, but not tariffs, on foreign imports during emergencies. Second, IEEPA was not debated and passed in a vacuum in 1977. It was enacted around the same time that Congress significantly constrained executive power in multiple ways in the wake of Watergate and Vietnam. The list of major new statutory restrictions on presidential power enacted in the 1970s is long and extraordinary, with lasting effects to the present day. Footnote 14. This is just a citation to a number of acts of Congress restricting executive power, so I'm not going to read them all out. Carrying on. And Congress, during that comprehensive examination and recalibration of government power, did not overlook TWEA and the President's emergency authorities. Led by Senators Church and Mathias, Congress carefully studied the President's emergency authorities, including TWEA. Then, in 1976 and 1977, Congress enacted a variety of legislation to tighten up the President's emergency powers, including by passing a new National Emergencies Act that cabined the President's authority to declare emergencies by setting forth various procedural requirements. Yet, when enacting IEEPA in 1977, Congress continued to grant the President the power to regulate importation in declared national emergencies, a power that the President had possessed since 1941 under TWEA and that had recently been invoked by President Nixon to justify his 1971 tariffs. In IEEPA and TWEA in 1977, Congress consciously balanced concerns about expansive exercises of emergency powers against the necessity of equipping the president with tools to address exigencies that are difficult, if not impossible, to foresee. That broader congressional context, general skepticism, and scaling back of executive power combined with reenactment of the familiar regulate importation language in IEEPA strongly indicates that Congress said what it meant and meant what it said when it enacted IEEPA and continued to authorize the President to regulate importation during national emergencies. Part 3. In an ordinary statutory interpretation case, I am confident that a majority of this court would flatly reject the plaintiff's exceedingly weak statutory arguments and would hold that IEEPA's authorization for the President to regulate importation during national emergencies includes the power to impose tariffs. Notably, the court today does not claim that the phrase regulate importation on its own excludes tariffs as a matter of ordinary statutory meaning. Only 3 members of the court, Justice Sotomayor, Justice Kagan, and Justice Jackson, do so. The Chief Justice's opinion in Part 2A2, which is joined only by Justice Gorsuch and Justice Barrett, instead relies on the major questions doctrine. The major questions doctrine is an important canon of statutory interpretation that the court has applied in a number of significant cases over the last 45 years. Justice Scalia articulated the canonical statement of the major questions doctrine. We expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. Stated otherwise, in cases where the executive branch takes an action of major economic and political significance, it must point to clear congressional authorization for the power it claims. The requirement of clear congressional authorization for executive actions of major economic and political significance is grounded in two overlapping and reinforcing presumptions. One, a separation of powers-based presumption against the delegation of major lawmaking authority from Congress to the executive branch, and two, a presumption that Congress intends to make major policy decisions itself, not leave those decisions to agencies. As this court later recounted in West Virginia, both separation of powers principles and a practical understanding of legislative intent make us reluctant to read into ambiguous statutory text the delegation it claimed to be lurking there. Footnote 15. The major questions doctrine has also been analogized to, among other things, the mischief rule, the absurdity doctrine, common sense, and context. Carrying on. The doctrine guards against unintentional, oblique, or otherwise unlikely delegations of the legislative power. Footnote 16. I have long been and fully remain a strong proponent of the major questions doctrine. Carrying on. I agree that this case involves an executive action of major economic and political significance, which is typically the trigger for requiring clear congressional authorization. But in my respectful view, the Chief Justice's opinion's application of the major questions doctrine in this case is incorrect for two alternative and independent reasons. First, the statutory text, history, and precedent constitute clear congressional authorization for the President to impose tariffs as a means to regulate importation. Second, and in the alternative, the major questions doctrine does not apply in the foreign affairs context. In the foreign affairs realm, courts recognize that Congress often deliberately grants flexibility and discretion to the President to pursue America's interests. In that context, courts therefore engage in routine textualist statutory interpretation, reading the text as written, and do not employ the major questions doctrine as a thumb on the scale against the President. Section A, subsection 1. Because the major questions doctrine demands clear congressional authorization, this court has repeatedly recognized that the doctrine is distinct from routine statutory interpretation. Importantly, therefore, the doctrine applies and makes a meaningful difference only in cases where the executive's reading of a statute would, under more ordinary circumstances, be upheld. To properly set up the inquiry, a major questions issue arises when 1. The executive relies on the text of a generally worded statute to exercise a specific power of major economic and political significance. 2. The generally worded statute does not explicitly mention the specific major power. But 3. The asserted major power falls within the generally worded text of the statute such that the executive's assertion of that power would, under more ordinary circumstances, be upheld. Footnote 17. Of course, if the major power does not fall within the generally worded text as a matter of ordinary statutory interpretation, the major questions doctrine is not implicated or necessary to apply because the government's statutory argument fails to begin with. Carrying on. The question then is whether the generally worded statute supplies clear congressional authorization for the executive to exercise that specific but not explicitly mentioned major power. Here, for example, does the generally worded statutory authorization for the President to regulate importation clearly authorize the President to impose tariffs? The requirement of clear congressional authorization is easy enough to state, but how do we apply it? How do we decide in a particular case whether a generally worded statute actually constitutes clear congressional authorization for a major power that otherwise falls within the general terms? For starters, and critically, this court has repeatedly emphasized that the major questions doctrine is not a magic words requirement. In other words, the doctrine does not require an explicit reference to the specific major power itself. As the court's cases amply demonstrate, the major questions doctrine does not force Congress to delegate in highly specific terms. Rather than require magic words, such as the words tariff or duty here, the court's cases have focused on four somewhat overlapping factors or considerations in order to assess whether a generally worded statute constitutes clear congressional authorization for the specific major power. Footnote 18. Both Justice Gorsuch and Justice Barrett have likewise read the court's precedents to identify those same four factors as they explained in their incisive separate opinions in West Virginia v. EPA and Biden v. Nebraska, respectively. Carrying on. First, the Major Questions Doctrine's most prominent work has been to ensure that the executive cannot suddenly seize an old and generally worded statute to exercise a power of great economic and political significance when that power would not reasonably have been understood at the time of enactment to fall within that generally worded statute. As the court has said, when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy, we typically greet its announcement with a measure of skepticism. The doctrine thus precludes an agency's attempt to effectuate a fundamental revision of the statute. Stated otherwise, an agency's attempt to deploy an old statute focused on one problem to solve a new and different problem may be a warning sign that it is acting without clear congressional authority. The court's skepticism about major executive action in those scenarios has been heightened when Congress has conspicuously and repeatedly declined to enact legislation that would have authorized the executive action in question. A prototypical example occurred when OSHA, in order to justify a nationwide COVID-19 vaccine mandate for workers, relied on a statutory provision that was adopted 40 years before the pandemic and focused on conditions specific to the workplace. Another example arose when EPA invoked newfound authority to regulate emissions from millions of small sources, including retail stores, offices, apartment buildings, shopping centers, schools, and churches. Yet another happened when the CDC tried to impose an eviction moratorium for rental housing through an unprecedented assertion of its authority to regulate public health. Second, courts examine the agency's past interpretations of the relevant statute. The executive's track record can be particularly probative in the major questions context. A contemporaneous and long-held executive branch interpretation of a statute is entitled to some weight. Just as established practice may shed light on the extent of power conveyed by general statutory language, so the want of assertion of power by those who presumably would be alert to exercise it is equally significant in determining whether such power was actually conferred. The NFIB court therefore found it critical that OSHA, in its half-century of existence, has never before adopted a broad public health regulation of this kind under the statute that the agency sought to invoke as authority for the vaccine mandate. Likewise, in Brown and Williamson, the FDA had repeatedly and consistently asserted that it lacks jurisdiction under the FDCA to regulate tobacco products, and in West Virginia, EPA had not previously interpreted the relevant provision to confer on it such vast authority to transform American industry. Third, courts assess whether there is a mismatch between an agency's challenged action and its congressionally assigned mission and expertise. In other words, whether an agency is trying to regulate outside its wheelhouse. In the NFIB case, OSHA, which is empowered to set workplace safety standards, not broad public health measures, mandated COVID-19 vaccines. In Alabama Association of Realtors, the CDC, a public health agency, attempted to regulate housing. In Gonzalez v. Oregon, the Attorney General sought to assert authority over the drugs used in physician-assisted suicide. All of those cases involved serious mismatches between the agency's usual regulatory activities and its asserted major power. Fourth, the court looks at whether the relevant statutory language used to justify the executive's exercise of a major power is oblique, elliptical, or cryptic. As the court has often said, Congress does not hide elephants in statutory mouse holes. In MCI Telecommunications Corporation, for example, the court refused to allow the FCC to eliminate rate regulation and fundamentally overhaul the telecommunications industry based on a subtle provision that merely permitted the FCC to modify rate-filling requirements. In Brown and Williamson, the court rejected the FDA's attempt to regulate the tobacco industry based on a cryptic statutory provision that referred to safety. In Gonzalez, the court said that Congress would not have granted the Attorney General the power to regulate physician-assisted suicide through oblique statutory language, And in West Virginia, the court found it unlikely that Congress would have granted major power to reshape the energy industry in a previously little used backwater of the statute. Subsection 2. So in this case, we must apply those 4 factors in order to determine whether Congress, when it afforded the President the power to regulate importation, clearly authorized the President to impose tariffs. As I see it, those factors show that Congress clearly authorized tariffs in IEEPA when it empowered the President to regulate importation. First, unlike the OSHA vaccine mandate in NFIB or the greenhouse gas regulation in utility air, for example, the President here is not exercising an unheralded or newfound authority based on a long extant statute, that is, exercising a power that was unanticipated or unforeseen when Congress enacted IEEPA's Regulate Importation language in 1977. On the contrary, as was fully explained above, the tariff authority exercised here is not remotely unheralded. To recap, any citizen or member of Congress who paid the least bit attention in 1977 would have readily understood that the President's authority to regulate importation encompassed the power to tariff. There are the dictionary definitions and the historical usage and practice, and among other things, just a few years before IEEPA, that regulate importation language was invoked by President Nixon and judicially approved to sustain his 10% worldwide tariffs. President Ford then implemented significant tariffs using substantially similar adjust the imports statutory language, and this court unanimously upheld President Ford's tariffs in Algonquin. So IEEPA's grant of authority to the President to impose tariffs in order to regulate importation is not unheralded or newfound. That authority was plain as day in 1977. Footnote 19. The court downplays the significance of the prominent Nixon and Ford tariffs, but the Nixon and Ford examples as well as Algonquin are critical for a proper and full understanding of the meaning of regulate importation when Congress enacted IEEPA in 1977. We cannot ignore or diminish that history. The Chief Justice's opinion and Justice Gorsuch's concurrence also say that no president since 1977 has invoked IEEPA to impose tariffs. But since 1977, presidents have imposed numerous tariffs under non-emergency tariff statutes, including Section 232, which, like IEEPA, also does not explicitly reference tariffs or taxes. The fact that recent presidents have not often had occasion under the National Emergencies Act to declare national emergencies in which tariffs would help deal with the specific emergency at issue does not mean that presidents have now lost the authority exercised by President Nixon to impose tariffs. IEEPA was not designed as a use-it-or-lose-it source of emergency authority. Carrying on. Second, the President is not interpreting the regulate importation language in IEEPA differently from how past presidents have interpreted it. At least as far as the briefing and arguments in this case have disclosed, no presidential administration since the enactment of the regulate importation language in TWEA in 1941 or since its reenactment in IEEPA in 1977 has interpreted the statute to exclude the power to impose tariffs. Moreover, before IEEPA's enactment, President Nixon imposed tariffs based on the same regulate importation language, and in 1975, President Ford invoked authority to adjust the imports in order to similarly impose monetary exactions. In addition, if more is needed, Marshall, Story, Madison, and this court have all long recognized that the power to regulate foreign commerce includes tariffs. The current president's reading of IEEPA follows from and is entirely consistent with those past interpretations, making his position nothing like, for example, FDA's when it changed its long-standing position that it lacked the authority to regulate cigarettes, or OSHA's when it implemented a vaccine requirement even though it had never before adopted a broad public health regulation of this kind. When, as here, established practice and the executive's track record convincingly show that the general statutory language has long been understood to cover the specific power asserted by the executive, that record should all but resolve the matter for major questions purposes. Third, there is no mismatch. The power to tariff falls squarely within the president's wheelhouse. From the founding, as the Chief Justice's opinion today acknowledges, numerous other statutes have afforded and still do afford the president broad power to impose tariffs. This case is entirely different, therefore, from our prior major questions cases, where, for example, the CDC attempted to impose an eviction moratorium, OSHA sought to implement a nationwide vaccine mandate, the FDA tried to regulate cigarettes, and the Attorney General attempted to regulate physician-assisted suicide. Presidents imposing tariffs, whether pursuant to inherent wartime authority, pursuant to TWEA and IEEPA's regulate importation language, pursuant to Section 232's adjust the imports text, or pursuant to the many other tariff statutory authorities, is hardly an unusual occurrence in our nation's history or in recent times. For example, Presidents George W. Bush, Obama, and Biden all imposed tariffs pursuant to congressional authorization. There is no mismatch between the tariff power and the president's mission and expertise. Fourth, the president is not relying on oblique, elliptical, or cryptic language. This case does not involve elephants in mouse holes. This case instead involves an elephant, tariffs, in a statutory elephant hole, the power to regulate importation to deal with foreign threats in national emergencies. IEEPA was a major and thoroughly studied statute carefully crafted to grant the president a suite of powerful tools, including to regulate importation and thereby allow him to respond swiftly to national emergencies and to help America respond to crises. Since its enactment, presidents have invoked IEEPA more than 70 times to deal with emergencies and threats, from the September 11, 2001 al-Qaeda attacks to Iran to North Korea and many others. By 1977, moreover, it was well known that tariffs on foreign imports, along with even more powerful tools such as quotas and embargoes, were a common way to regulate importation. IEEPA thus bears zero resemblance to the paradigmatic, previously little-used backwater statutory provision that cannot support significant executive actions. All of that makes this case dramatically different from, really the opposite of, the major questions cases where the court has ruled against the government. The text, the history, the context, and the precedent all point strongly to the conclusion that as of 1977, tariffs were a well-recognized means of regulating importation like quotas and embargoes. As Judge Taranto persuasively summarized, this case bears none of the hallmarks of past major questions cases where the court found a lack of clear congressional authorization for the government's asserted major power. IEEPA's facial breadth in an emergency context makes the straightforward application of the statute's words hardly unheralded, and if a more specific herald is needed, it is present in the Nixon 1971 proclamation, Yoshida CCPA, and subsequent congressional adoption of the relevant language in 1977. IEEPA seeks to provide flexibility in the tools available to the president to address the unusual and extraordinary threats specified in a declared national emergency. This is not an ancillary, little-used backwater provision or a delegation outside the recipient's wheelhouse. This court's recent decision in Biden v. Missouri strongly supports the president's position here. That case involved a challenge to President Biden's COVID-19 vaccine requirement for millions of healthcare workers. The executive action there, too, was undoubtedly major, but the court upheld the government's vaccine mandate based on a general statutory authorization for HHS to impose safety requirements for healthcare facilities, notwithstanding the lack of explicit statutory reference to vaccines. In doing so, the court emphasized that state vaccination requirements were common for healthcare workers and that the federal government regularly required healthcare workers to take various safety precautions. Notably, the court upheld the vaccine mandate even though, as the dissenters pointed out, the federal government had not traditionally imposed such vaccine requirements on healthcare workers. The clarity of the congressional authorization in today's case is far stronger than in Biden v. Missouri. The Nixon and Ford tariffs, the Algonquin decision, and the president's long-standing authority to regulate trade and impose tariffs establish much more comprehensively and clearly than in Biden v. Missouri that the president is not claiming some unheralded power that represents a transformative expansion of his authority. Because the court upheld the executive's exercise of a major power in Biden v. Missouri, it follows that the court today should likewise uphold the president's assertion of a major power here. Like cases should be treated alike. In response to all of that, the Chief Justice's opinion clings to its primary argument in this case, that a statute must use the word tariff or duty or tax or the like to authorize tariffs in foreign imports. But this court has repeatedly emphasized that the major questions doctrine is not a magic words requirement. The Chief Justice's opinion identifies no case that has demanded such specificity, and in Algonquin, this court unanimously and squarely rejected the same argument that the statutory provision must specifically mention tariffs or duties or taxes for the president to impose tariffs on foreign imports. Under the Chief Justice's opinion, the Nixon and Ford tariffs would also have been unlawful. So too might other tariffs imposed under the long-standing Section 232 tariff statute, which broadly authorizes the president to adjust the imports of a foreign good without mentioning tariffs or taxes. And so would tariffs imposed in wartime under TWEA's authority to regulate importation. Footnote 20. Under the court's decision today, the president's authority to impose tariffs under TWEA during wartime is presumably now gone, given that TWEA has the same regulate importation language, unless the court thinks that the statutory text somehow means one thing in TWEA and another in IEEPA, which would be historically inaccurate and textually unsupportable. One might think that the court's opinion would also mean that tariffs cannot be imposed under Section 232, which authorizes the president to adjust the imports. After all, that statutory provision likewise does not refer to tariffs, duties, taxes, fees, or the like. But in Algonquin, the court read Section 232 to authorize tariffs. I assume that the court today does not intend to overrule Algonquin. Carrying on. The Chief Justice's opinion's approach to the major questions doctrine is a magic words test under another name, in contravention of our precedents that make clear that Congress need not use magic words or highly specific terms. Footnote 21. Taken at face value, moreover, the court's major questions analysis would presumably also preclude presidents from imposing quotas under IEEPA. Quotas are justified under the same regulate importation language. How could the court distinguish quotas from tariffs for major questions purposes? After all, quotas can be of even greater economic and political significance than tariffs. Carrying on. In previous cases, the court has looked at 4 factors to determine whether there is clear congressional authorization precisely because the major questions canon has no magic words requirement. If magic words or the equivalent were necessary, that would be the only factor, and the court would not need the 4 factors that the court has consistently applied. Footnote 22. In his concurrence, Justice Gorsuch opines that the phrase monetary exactions on foreign imports would constitute clear congressional authorization, but that the phrase regulate importation does not. But if the phrase regulate importation has historically and commonly encompassed monetary exactions on foreign imports, as it has, and if the 4 major questions factors taken together support the executive, as they do, then I cannot agree with the line that Justice Gorsuch is drawing between those 2 formulations. Carrying on. In sum, under the major questions doctrine as the court has applied it, this should be a straightforward case. Congress supplied clear authorization for the president to impose tariffs under IEEPA. Section B, subsection 1. Second, there is an alternative and independent reason why the major questions doctrine does not apply here. This is a foreign affairs case. A plethora of statutes in the U.S. Code grant the executive the power to act in foreign affairs, and most of the important actions that presidents take today, including in foreign affairs, rest at least in part on statutory authorization. Yet this court has never before applied the major questions doctrine or anything resembling it to a foreign affairs statute. I would not make this case the first. Rather, in the foreign affairs context, this court has interpreted statutes as written with respect for the primacy of Congress's and the president's roles in foreign affairs and without using the major questions doctrine as a thumb on the scale against the president. That deeply rooted textualist approach to interpreting foreign affairs statutes is nothing new. What is new and rather extraordinary is the approach embodied in the Chief Justice's opinion for the 3 justices, which would extend the major questions doctrine into the foreign affairs realm for the first time. Recall that the major questions doctrine is based on 2 overlapping foundations: separation of powers principles and a practical understanding of legislative intent. With respect to separation of powers, the major questions doctrine serves to reinforce the non-delegation doctrine. But in the foreign affairs realm, the court has recognized that Congress often broadly delegates authority to the executive. From the founding, numerous foreign affairs statutes authorizing action by the president in respect of subjects affecting foreign relations either leave the exercise of the power to his unrestricted judgment or provide a standard far more general than that which has always been considered requisite with regard to domestic affairs. If success for America's foreign affairs aims is to be achieved, congressional legislation must often accord to the President a degree of discretion and freedom from statutory restriction which would not be admissible were domestic affairs alone involved. Stated otherwise, Congress, in giving the executive authority over matters of foreign affairs, must of necessity paint with a brush broader than it customarily wields in domestic areas. As Justice Robert Jackson summarized, the court's non-delegation cases, consistent with the unbroken legislative practice which has prevailed almost from the inception of the national government, have recognized internal and external affairs as being in separate categories and held that the strict limitation upon congressional delegations of power to the President over internal affairs does not apply with respect to delegations of power in external affairs. As Justice Jackson further noted, the court's precedents recognize the unwisdom of requiring Congress in this field of governmental power to lay down narrowly definite standards by which the President is to be governed. If the major questions doctrine is designed in part to protect non-delegation principles, but the non-delegation doctrine does not play a substantial role in foreign affairs cases, as the court has held, then it follows that courts should not employ the major questions doctrine to put a thumb on the scale against the President when interpreting foreign affairs statutes. Rather, as Justice Robert Jackson stated, courts should interpret those statutes as written. Relatedly, to the extent that the major questions doctrine is designed to reflect a practical understanding of legislative intent, the doctrine appropriately plays no role in the national security or foreign policy contexts, because the canon does not reflect ordinary congressional intent in those areas. In the foreign affairs realm, Congress has good reason to, and intends to, authorize many executive branch actions related to foreign affairs in broad or general terms. Congress ordinarily seeks to give the President substantial authority and flexibility to protect America and the American people. After all, the President exercises the vast share of responsibility for the conduct of our foreign relations. So Congress often gives the President a degree of discretion. That unbroken legislative practice from the founding means that courts interpreting statutes in the foreign affairs field should assume that Congress meant what it said. Stated otherwise, if the major questions doctrine turns on a contextual inquiry into likely congressional intent, it is likely for a variety of reasons to have less purchase in the foreign affairs area. To be clear, Congress, of course, maintains the ultimate power over how broadly or narrowly to write statutes in the foreign policy and national security contexts. For example, Congress can write foreign affairs statutes narrowly. Indeed, even for wartime powers, Congress rarely gives the President a blank check, and when Congress writes a narrow foreign affairs statute, this court has enforced those statutory limits as written. Moreover, when it does legislate more broadly, Congress sometimes claws back the statutory authorization by rescinding or amending overbroad statutes or by restricting previously granted presidential power through the leverage it possesses over appropriations, new legislation, or confirmations. Either house of Congress alone, through the appropriations process, can insist on certain limits as a condition of approving funding. At the end of the day, given the appropriations power, Congress holds the cards. In short, in the foreign affairs context, this court has never before superimposed the major questions doctrine or any similar canon or principle onto ordinary statutory interpretation to place a thumb on the scale against the President. Rather, the court interprets the relevant statutes according to their text with respect for Congress's and the President's central roles in the foreign policy and national security fields. Subsection 2. This tariffs case plainly falls into the foreign affairs category. IEEPA directly and expressly relates to foreign affairs. And like quotas and embargoes, tariffs regulate the goods that are imported into the country from foreign nations. The tariffs do not apply to goods produced in America. Moreover, tariffs on foreign imports are significant tools of foreign policy and national security, whether imposed under IEEPA, TWEA, Section 232, Section 122, Section 201, Section 301, or Section 338. They are often used to advance foreign policy goals or as negotiating leverage in trade negotiations. Like other economic tools, tariffs can serve as a bargaining chip to be used by the President when dealing with a hostile country, or to incentivize a change in behavior by allies, partners, or enemies. With respect to foreign trade specifically, Congress often invests the president with large discretion in matters arising out of the execution of statutes relating to trade and commerce with other nations. Since the founding, that long-standing practice has included tariff statutes. Congress has granted the president expansive power over tariffs and foreign trade. And this court has uniformly rejected challenges to tariffs imposed by presidents under those statutory authorities. As Professors Bradley and Goldsmith well summarized, there is a settled practice of about a century of the executive branch exercising emergency powers in many important contexts pursuant to the broadly worded IEEPA and its predecessor, the Trading with the Enemy Act. And there is an even longer practice dating to the founding of presidents exercising trade-related sanctions authority pursuant to broadly worded statutes. Notably, the court has already suggested in both of these contexts that one should expect Congress to, in effect, paint with a broad brush. As with tariffs on foreign imports historically, the IEEPA tariffs on foreign imports at issue in this case implicate foreign affairs. According to the government, the president has leveraged the IEEPA tariffs into trade deals with major trading partners including China, the United Kingdom, and Japan, among other countries. The government says that the tariffs have helped make certain foreign markets more accessible to American businesses and have contributed to trade deals with foreign nations worth trillions of dollars. Moreover, consistent with the history of the traditional use of tariffs, the president is exercising his IEEPA authority in connection with highly sensitive negotiations he is conducting to end the conflict between the Russian Federation and Ukraine. To that end, on August 6, 2025, the president imposed tariffs on India for directly or indirectly importing Russian Federation oil. And on February 6, 2026, the president reduced the tariffs on India because, according to the government, India had committed to stop directly or indirectly importing Russian Federation oil. To be sure, most foreign affairs and national security actions, whether war, international agreements, trade deals, or tariffs, lead to significant domestic ramifications within the United States, and this case is no exception. Nonetheless, in the foreign affairs field, courts interpret statutes as written with appropriate respect to Congress and the president and without a major questions doctrine weight on the scale against the president. Lest there be any remaining doubt that the major questions doctrine does not apply to tariffs on foreign imports, recall again this court's decision in Algonquin. That case involved significant tariffs imposed by President Ford on oil imports. The relevant statute granted the president the authority to adjust the imports. The court upheld the tariffs by interpreting the statute as written. Neither the major questions doctrine nor anything resembling that doctrine played a role in that case. In short, presidential actions pursuant to broad congressional authorizations related to foreign affairs often have long historical pedigrees that can, in various ways, inform congressional intent to approve the actions in question. To the extent that this is so in particular instances, the major questions doctrine clear authorization requirement does not apply. So it is here. Presidents have long been granted substantial discretion over tariffs. This court has never before applied the major questions doctrine to a statute authorizing the president to take action with respect to foreign affairs in general or tariffs in particular. And it should not do so today. The Chief Justice's opinion's reliance on the major questions doctrine in this foreign affairs case is a first, a novel and unprecedented use of the major questions doctrine to invalidate presidential action taken pursuant to a congressional authorization in the foreign affairs area. I firmly disagree with that use of the major questions doctrine here. In the foreign affairs context, including tariffs, the long-standing rule is simple. Interpret the statute as written, not with a thumb on the scale against the president. Footnote 23. In his thoughtful concurrence, Justice Gorsuch agrees that the major questions doctrine often does not apply to foreign affairs statutes, but in his view it does not apply only when the president also has inherent or independent Article II power. The Chief Justice's opinion for 3 justices also gestures at that position. I see some analytical and practical problems with that approach. First, as Justice Gorsuch elsewhere notes, the major questions doctrine serves in part to reinforce non-delegation principles. Yet, as I have explained, the court's non-delegation cases from the founding to the present, including numerous cases involving tariffs, have recognized internal and external affairs as being in separate categories and held that the strict limitation upon congressional delegations of power to the president over internal affairs does not apply with respect to delegation of powers in external affairs. In those cases, the court has not further subdivided the foreign affairs power in the manner that Justice Gorsuch now suggests. Second, terms such as inherent or independent in this context continue to be used often interchangeably and without fixed or ascertainable meanings. So it would be both novel and jurisprudentially chaotic to try to now create a new approach tying the applicability of the major questions canon in the foreign affairs context to such uncertain triggers. Carrying on. Subsection 3. Related precedent further demonstrates that the major questions doctrine has not traditionally applied in the national security or foreign policy contexts. Consider two prominent examples. First, in Hamdi v. Rumsfeld, this court considered the 2001 authorization for the use of military force, which Congress passed and President George W. Bush signed on September 18, 2001, in the wake of the al-Qaeda attacks on the United States. The law broadly empowered the president to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001. In Hamdi, the government militarily detained in the United States an American citizen who had taken up arms with the Taliban. The plaintiff Hamdi argued, among other things, that the AUMF generally authorized the use of force but did not specifically authorize military detention, at least detention of American citizen enemy combatants in the United States. He contended that his military detention was therefore illegal. In the principal opinion by Justice O'Connor, the court rejected Hamdi's statutory argument, explaining that it was of no moment that the AUMF does not use specific language of detention. Rather, because detention to prevent a combatant's return to the battlefield is a fundamental incident of waging war, in permitting the use of necessary and appropriate force, Congress has clearly and unmistakably authorized detention in the narrow circumstances considered here. Consider the similarities between Hamdi and this case. Both involve major questions of foreign affairs. Hamdi involved U.S. military detention of an American citizen in America pursuant to a generally worded authorization for use of military force. This case involves tariffs on foreign goods imported into America pursuant to a generally worded authorization to regulate importation. Detention is a traditional incident of the president's delegated power to wage war. Tariffs are a traditional incident of the president's delegated power to regulate imports and foreign commerce. In Hamdi, the court said that as a matter of history, practice, and precedent, the AUMF's general authorization for the use of military force clearly encompassed detention of enemy combatants. Here, as a matter of history, practice, and precedent, IEEPA's general authorization for regulation of importation likewise clearly encompasses tariffs on foreign imports. Second, in 1981, in Dames and Moore, the court did not apply the major questions doctrine, even though the court had recently applied that principle in a significant domestic policy case. The Dames and Moore case arose in the wake of the Iran hostage crisis, where Iran held more than 50 American hostages in the U.S. Embassy in Iran for more than 14 months. As one part of the ultimate settlement of the hostage crisis with Iran, President Reagan suspended claims by U.S. nationals against Iran that were pending in American courts. The president did so under IEEPA and the Hostage Act. There can be little doubt that the question of suspending American citizens' claims against Iran was one of a major economic and political significance, and the court further recognized that the case touched fundamentally on the manner in which our republic is to be governed. Yet the court did not require clear congressional authorization for the president's exercise of that authority to suspend the Americans' claims against Iran. On the contrary, the court openly acknowledged that the relevant statutes, IEEPA and the Hostage Act, did not provide clear or specific authorization for the president to suspend those claims. The court nonetheless concluded that the general tenor of Congress's legislation in this area, combined with Congress's long-standing acquiescence to the president's practice of settling claims, supported the president's suspension of those claims. Congress's general tenor and acquiescence are of course far less than the clear congressional authorization that the Chief Justice's opinion today newly demands for the president's tariffs. Again, consider the similarities between Dames and Moore and this case. Dames and Moore involved complicated questions of foreign policy and national security. The statutes in Dames and Moore were generally worded and did not specifically authorize suspension of claims. but presidents had historically exercised a similar power. Here, we likewise have a generally worded statutory authorization to regulate importation, and presidents have historically imposed tariffs. If IEEPA permitted the president to lawfully suspend claims in Dames and Moore, despite the court's transparent acknowledgement that the actual statutory text did not clearly authorize the president's actions, then surely IEEPA's authorization to regulate importation easily justifies these tariffs. The Chief Justice's opinion would chart a new course for the Major Questions Doctrine, extending it for the first time deep into the foreign affairs sphere. If the court had applied the Major Questions Doctrine in Hamdy and Dames and Moore, those two landmark cases almost certainly would have been decided differently, so today's opinion marks a significant change. Will the court apply the Major Questions Doctrine in the foreign affairs context again in the future, or is this a ticket good for one day and one train only? Time will tell. But in the meantime, the decision could engender significant uncertainty over the executive's exercise of statutory authority in the foreign affairs realm. As the Hamdy and Dames and Moore examples demonstrate, applying the Major Questions Doctrine in the foreign policy and national security contexts in the past would have seriously hindered the president's ability to exercise power granted by Congress to achieve important foreign policy and national security objectives for America. And if applied in the foreign affairs context in the future, it could impair presidents' vital statutory authorities with respect to foreign policy and national security. Footnote 24. What is the status going forward of the Major Questions Doctrine in foreign affairs cases? Only 3 justices at most today suggest that the Major Questions Doctrine should apply in the foreign affairs context: the Chief Justice, Justice Gorsuch, and Justice Barrett. I doubt that the Major Questions Doctrine analysis in the Chief Justice's opinion for those 3 justices is controlling for future cases as a matter of precedent under the Marx rule. That is because 3 justices, Justice Sotomayor, Justice Kagan, and Justice Jackson, do not recognize the Major Questions Doctrine at all. And this dissent would not apply it in the foreign affairs context, so it appears that 6 justices would not apply it in the foreign affairs context. In my view, the question of whether or how the Major Questions Doctrine applies in foreign affairs cases remains at least an open question. Carrying on. Having said all of that on foreign affairs, I reiterate that the Major Questions Doctrine, even if it applies in this foreign affairs context, does not defeat major executive actions that are clearly authorized by Congress. As explained in Part 3A above, in IEEPA, Congress clearly authorized the President to impose tariffs to regulate importation in national emergencies. In other words, even if the Major Questions Doctrine applies in the foreign affairs context exactly as it does in domestic affairs, the President should still prevail in this case. Part 4. Finally, no member of the Court today relies on the non-delegation doctrine, but the plaintiffs briefly raise such an argument, and I will therefore briefly address it. The argument is unavailing for many of the reasons already noted in the Major Questions analysis above. This court has repeatedly rejected constitutional challenges to congressional delegations to the President in the foreign affairs area, including delegations of tariff authority. For matters of foreign affairs and national security, the court has traditionally recognized that Congress must of necessity paint with a brush broader than it customarily wields in domestic areas, and to reiterate, numerous statutes authorizing action by the President in respect of subjects affecting foreign relations either leave the exercise of the power to his unrestricted judgment or provide a standard far more general than that which has always been considered requisite with regard to domestic affairs. Therefore, as Justice Thomas has explained, the Court's precedents establish that the Constitution grants the President a greater measure of discretion in the realm of foreign relations. Justice Robert Jackson likewise noted the unwisdom of requiring Congress in this field of governmental power to lay down narrowly definite standards by which the President is to be governed. As such, the strict limitation upon congressional delegations of power to the President over internal affairs does not apply with respect to delegations of power in external affairs. Because statutes that involve the external relations of the United States do not trigger the same kind of delegation concerns as purely domestic ones, the Court has regularly upheld delegations of power to the President in the national security and foreign policy realms. Indeed, if a strict non-delegation doctrine applied in those areas, numerous statutes, including many authorizations for use of military force in this nation's history, would have been unconstitutional delegations of authority to the President. As to tariffs in particular, broad delegations of tariff authority to the President have been in the heartland of permissible delegations upheld by this court. Congress may, without running afoul of the Constitution, invest the President with large discretion in matters arising out of the execution of statutes relating to trade and commerce with other nations. Congressional delegations of tariffs and other foreign trade authorities to the President date back to near the founding, and this court has uniformly rejected non-delegation challenges to statutes delegating that authority to the President. This court's decision in Algonquin is again instructive. There, the court held that Section 232 did not constitute an unconstitutional delegation. The court found it sufficient that the President could act only to the extent he deems necessary to adjust the imports of an article such that it will not threaten to impair the national security. To be clear, I am not suggesting that there is no non-delegation doctrine in the foreign affairs realm, but the court has consistently recognized that the doctrine affords more flexibility to Congress and the President in that area to deal with the complex foreign relations issues and national security threats facing America. In all events, for purposes of this court's non-delegation precedents, IEEPA sufficiently constrains the President's authority to declare an emergency and impose tariffs. The President may exercise the authorities in IEEPA only to deal with an unusual and extraordinary threat that has its source in whole or in substantial part outside the United States and with respect to which a national emergency has been declared. Congress placed numerous limits on IEEPA, including a default one-year time limit, an enumerated list of exceptions, and comprehensive congressional reporting requirements. It is also useful to underscore the extraordinary nature of the plaintiff's non-delegation argument here. The plaintiff's submission would mean that these tariffs would be unlawful even if IEEPA explicitly authorized tariffs. Unlike their statutory and major questions doctrine arguments, their non-delegation argument is not based on a lack of an explicit reference to tariffs or duties or the like. Their non-delegation argument instead goes much further and would require very specific congressional directions to the President on when and under what circumstances he could impose tariffs and how high those tariffs could be. The plaintiff's theory would have dramatic consequences and likely wipe out many of the existing tariff statutes that have long been upheld by this court as well as TWEA. And if the tariff authority here is unlawful, so too are most, if not all, IEEPA authorities, such as asset freezes, embargoes, and quotas. And it would not stop there. The plaintiff's non-delegation theory would threaten various other national security and foreign affairs statutes that similarly grant substantial discretion to the President. The court today, thankfully, does not go down that road. Footnote 25. Some last points for completeness. The plaintiffs also raise two other arguments that the court today does not address or rely on. First, they argue that Section 122, a non-emergency tariff statute that addresses trade deficits, implicitly displaces IEEPA's tariff authority. Second, they argue that the tariffs here do not deal with an unusual and extraordinary threat as to which a national emergency has been declared. In my view, those arguments are insubstantial, as Judge Taranto persuasively explained in the Federal Circuit. Because the court today does not address or rely on them, I will not discuss them further here. Finally, I agree with footnote 1 of the court's opinion regarding jurisdiction. Carrying on. Part 5. The overarching theme of the court's opinion is that tariffs are not a clear means to regulate importation, and that Congress was therefore required to use the word tariff, duty, or the like in IEEPA in 1977 if it wanted to authorize tariffs on foreign imports. But that conclusion contravenes text, history, and precedent. To summarize, Algonquin in 1976 unanimously held the opposite. The Nixon and Ford tariffs were based on statutory provisions that did not use the word tariff or duty. There is a long tradition of presidents imposing tariffs as a means of regulating importation and commerce. The predecessor's Trading with the Enemy Act has long been understood to authorize tariffs during wartime as a means to regulate importation, even though it does not use the word tariff or duty. The history of the Polk, Lincoln, and McKinley tariffs shows that tariffs are a means of regulating importation. Marshall, Story, and Madison stated that tariffs are a means of regulating foreign commerce. The dictionary definitions and ordinary usage establish that tariffs are a means of regulating importation. All of that and much more, in my view, overwhelmingly establish that IEEPA clearly authorizes the President to impose tariffs. That said, with respect to tariffs in particular, the court's decision might not prevent presidents from imposing most, if not all, of these same sorts of tariffs under the statutory authorities. The court's decision might not prevent presidents from imposing most, if not all, of these same sorts of tariffs under other statutory authorities. For example, Section 122 of the Trade Act of 1974 permits the president to impose a temporary import surcharge to deal with large and serious United States balance of payments deficits. Section 201 of the Trade Act of 1974 provides that if the International Trade Commission determines an article is being imported in such quantities that it is a substantial cause of serious injury or the threat thereof to domestic industry producing an article like or directly competitive with the imported article, the President may take appropriate and feasible action, including imposing a duty. Section 301 of the Trade Act of 1974 authorizes the President through a subordinate officer to impose duties if he determines that an act, policy, or practice of a foreign country is unjustifiable and burdens or restricts United States commerce. Section 338 of the Tariff Act of 1930 permits the President to impose tariffs when he finds that any foreign country places any burden or disadvantage upon the commerce of the United States. And Section 232 of the Trade Expansion Act of 1962 authorizes the President to, after receiving a report from the Secretary of Commerce, adjust the imports of an article and its derivatives so that such imports will not threaten to impair the national security. So the court's decision is not likely to greatly restrict presidential tariff authority going forward, but the court's decision is likely to generate other serious practical consequences in the near term. One issue will be refunds. Refunds of billions of dollars would have significant consequences for the U.S. Treasury. The court says nothing today about whether, and if so how, the government should go about returning the billions of dollars that it has collected from importers. But that process is likely to be a mess, as was acknowledged at oral argument. A second issue is the decision's effect on the current trade deals. Because IEEPA tariffs have helped facilitate trade deals worth trillions of dollars, including with foreign nations from China to the United Kingdom to Japan, the court's decision could generate uncertainty regarding various trade agreements. That process, too, could be difficult. The tariffs at issue here may or may not be wise policy, but as a matter of text, history, and precedent, they are clearly lawful. I respectfully dissent. And that finally does it for all of the opinions in this case. As promised at the start of the episode, we're doing something a little different. It won't just be me ranting to the listeners today. We'll actually have two people ranting at the listeners today, so it'll be a little bit more of a discussion and hopefully a little bit more interesting, a little less one-sided. You'll get to hear somebody else's opinion, and I do think my friend here tends to have very different opinions to me on a lot of things, so... Hopefully
Got double the trouble today.
Yeah. So yeah, if you want to introduce yourself, feel free.
Yeah. I'm William. I'm an attorney for the state of Minnesota, and I've known Bailey for many, many years now. And he invited me to the podcast to help share in our opinions on the opinion that the Supreme Court released in February, Learning Resources v. Trump. So I'm very excited to be a part of this. You know, I doubt it's ever been mentioned before, but Bailey was actually featured in a podcast of mine that I did briefly in law school. And so I think it's pretty fun and interesting that it's come full circle in a way on this.
Yeah, that's true. I hadn't forgotten about that, but I wasn't thinking about that when I invited you on. But yeah, that was a thing. But yeah, and I figured it was appropriate to invite you on because I mean, one, it's a good excuse to talk to you about Supreme Court stuff, which is always fun, and two, you're probably a big part of the reason this podcast exists because you're a big part of the reason that I actually started learning a little bit more about the Supreme Court and constitutional law and all that.
Oh, well, thanks.
Yeah. But yeah, introductions out of the way, I guess we can get into our thoughts on the opinion. I guess to kind of start things off, you know, being the one that had to read the thing, my first thought on the opinion was, what the hell? Why is it so long?
Oh my
And
gosh. Yeah, I'm probably gonna interject a lot, it's kinda what I do, but, the fact that, because I counted at one point, Kavanaugh's dissent is 63 pages, which is
Mhm.
the majority of the opinion, easily, like, if not exactly half, but pretty close to half. Uh, 3 times as long as the majority opinion. It's insane.
Yeah, like, as I was reading through Gorsuch's concurrence, I thought, "Oh, Gorsuch is talking a lot, he's gonna be the plurality of this thing." I think it was, like, 40 some pages.
Mhm.
And I was thinking like, "Oh, that makes sense that his would be the longest because he's kind of going through all of the other opinions, except I think for Jackson's, and, like, kinda picking them apart and, talking about his thoughts on them." And then Kavanaugh comes out with over 60 pages. I'm like, "Oh my god."
Yeah, I think when we get down to Kavanaugh's, that'll be where a lot of the meat of the discussion is because, um, to give a brief prelude, I don't agree with much of anything that Kavanaugh said, but I think a lot of what he said has discussion material. Let's say that he says a lot, and there's a lot to be said about what he said.
Yeah, I don't know, I do feel like Kavanaugh's like, as I was reading it, I'm like, a lot of this just feels repetitive, or at least some of it did. I get this impression of Kavanaugh whenever I read him that he's just kind of long-winded and just goes back over kind of the same point or, like, reiterates the same point multiple times,
Mhm.
which, I don't know, I kinda have the tendency to do the same thing, but it still annoys me in a Supreme Court opinion.
Well, and we've talked about this too on the side, how uh, verbose these opinions can get, seemingly to the point where you're more confused than if they had just said what they meant clearly. Uh, I can stomach a 20 to 30 page opinion now and then, but what I don't need is every single person giving
Mhm.
50, 60, 70 pages of exactly what they think over and over and over again.
Yeah, and yeah, this is definitely an outlier where, like, there were 7 opinions. 7 of the 9 justices on the Supreme Court wrote an opinion on this case, and, like, when you look at the little summary of, like, who wrote what opinion and who joined with who and whatnot, it's kinda wild because it's just a complete mess. It's like a 6-3 opinion with respect to part of the, of Roberts' opinion, but
Yeah.
then 3 of the justices, Sotomayor, Kagan, Jackson, they drop off for another part of it, so then it becomes kind of like a weird 3-3-3 mix, and yeah,
Yeah, and
it's
sometimes this happens. It's a really weird breakdown, where you get to see how the doctrinal or the ideological tensions on the court sort of pull apart the opinion in these complex and novel ways. Most people don't think about the fact that uh, all that the Supreme Court has to do is really agree about the consequence of what they're deciding,
mhm,
that X is unconstitutional or Y does not grant this authority. The ultimate conclusion of the case. But in terms of how you get there, you could have as many different opinions as there are judges. And some judges occasionally write their opinion and then an alternative opinion where they're just
Oh,
like,
yeah.
well, even if people don't, and you got some of this here where, uh, the judges are explicitly or implicitly referring to each other's opinions and being like, well, here's why this argument is stronger, this why this argument is
Mhm.
weaker, um, even
Yeah.
though they ultimately agree.
I've heard of I haven't seen a case where this has happened before, but I've heard of cases where this happens before, where, a judge, in a lower court or a justice in the Supreme Court will write their opinion for the majority, and then a concurrence in their own opinion, which is really funny. But yeah, all that to say, it's a really weird mix of the justices and, like, concurring as to only parts of the opinion and, not as to others and just weirdness, but, I do remember when reading that little summary and seeing, oh, the three liberal justices kind of backing off of the majority's opinion as to these parts. I'm like, oh, I bet that's the major questions stuff, major
Right
questions
on the
doctrine
dot.
stuff. And yeah,
Yep.
it was, because yeah, I I don't remember if I got this impression from oral arguments or from seeing some of the commentary before I got a chance to read the opinions, but I knew it was going to be like very major questions doctrine centric, and I knew the three liberal justices don't really like the major questions doctrine. So yeah, that was kind of a fun prediction to to have come true. But
Yeah. Have you? I assume you've described the major questions doctrine before for your like audience.
I'm not sure if I have. But yeah, I guess if anybody is left confused from the descriptions of it in the opinion, it's essentially like, I guess the best way that I've heard it described is like, we don't read elephants in statutory mouse holes or something, something to that effect. Basically,
Yeah.
like, if we've got some language, maybe some slightly vague language, or broad language or something that could be read to encompass this really like major power that an executive agency is asserting or something like that, you read that with a degree of skepticism that, like, okay, we don't think Congress like contemplated this when they wrote this like little statutory provision that maybe you could read that way if you squint at it, I guess.
Yeah. Exactly. The and I feel like the major questions doctrine has come up a lot more in recent years,
Mhm.
which tends to be the case. I think conservative justices generally rely on it more often than not when making decisions about statutory interpretation. But right on the money. The long and short, of course, and you're right. They did refer to it. Not just all the time throughout the opinion, but more or less like alluding to the elements. If Congress hasn't given this explicit statutory authorization for the federal government to do something, especially if the issue is like very economically or politically significant, then the rule is that you shouldn't interpret the law as granting that authority.
Yeah. And yeah, I guess as you mentioned, yeah, this is very much very much something that like conservative justices and judges tend to be bigger fans of than the liberal justices. The liberal justices, in you know their own opinion in this case, they say like, no, we can just resolve this as a matter of straight up statutory interpretation. And it's kind of funny, like Gorsuch, in his opinion, he says like, oh well, they're just doing major questions doctrine analysis in a different name, and I'm not really sure I agree with that so much. Most of the stuff that I think he points to, that he says, oh, this sounds like major questions analysis, kind of wasn't, or at least it didn't strike me as though it was. I think there was one thing in there that I agreed with him on, but most of it was like, no, they're just doing regular statutory interpretation. But I don't know. I do I do agree with him in a lot of his like sort of accusations of hypocrisy almost, against both the liberal and the dissenting conservative justices, where he's like, hey, you guys really like the major questions doctrine, and you're like, no, we shouldn't apply it in like this one specific case because something foreign affairs, and you guys really don't like the major questions doctrine. But then you come out on this side in this case, but then look at all of these other major questions cases where the power asserted is as dubious or more so, and you come out on the other side. Like, what? Y'all suck.
Yeah, there's it is just rife with hypocrisy. So many of these, you see it bear out in the disagreements and the concurrences and the dissent. Uh, Definitely a situation where these justices, because it's interesting to see it too, where you have a politically mixed decision,
Mhm.
where it's not a 6-3 along conservative liberal lines, because you can really see where as I mentioned before, the ideological intuitions of the justices sort of break from the practical implications, and it manifests in this sort of yeah, hypocritical valence where, as Gorsuch, I think, points out pretty well, that uh, the liberal justices are tending to pick and choose when to apply major questions doctrine, if they apply it at all, um, and same for the conservative justices. The we can kind of we can kind of go through like each of the concurrences, or because we're kind of on Gorsuch right now.
Mhm.
Um, and one of the things that he said or emphasized that I kind of want to get your take on, because I don't think we've ever talked about it before. In addition to sort of defending the major questions doctrine, he also emphasizes the need for the court to sort of recognize the non-delegation doctrine
Mhm.
as an important direction for the court to explore in this and future opinions. Gorsuch has been an delegation for a long time. I know this is not the first time that he's referenced the doctrine, and it certainly won't be the last as long as he's on the court. And I can't recall actually if he explores what non-delegation means in his opinion, but for the sake of posterity and covering our bases, the non-delegation doctrine is basically the idea that if major questions doctrine is like, hey, Congress has to explicitly authorize something, non-delegation is saying Congress can't authorize something.
Mhm.
Congress is vested with this legislative power under Article 1 of the US Constitution, and therefore it should not be permitted to delegate that power to executive agencies, private entities, or the judiciary. There are stronger and weaker versions of this, and it's sometimes hard to tell which version Gorsuch is advocating for. The weaker version of the non-delegation doctrine is more of a, like a normative, like, oh, well, this should be avoided. Obviously, Congress could do this, and there's like historical and perhaps even some constitutional precedent for doing this. But in general, it should be avoided versus the strong non-delegation, which is anytime Congress does something like this, it is per se invalid or per se unconstitutional. And insofar as that's the position that Gorsuch is maintaining, this stronger non-delegation doctrine, I think you run into a lot of problems that are foreseeable in a modern administrative state, where there are so many unique and particular issues of bureaucratic, scientific, industrial significance, all this minutia, that if Congress was not allowed to delegate or subdelegate some of those legislative responsibilities, what you would end up with is either almost no regulation because Congress is not in a competent position to properly regulate, or you would have uh, a much slower regulatory process than we already have. Which, if you've ever worked in industry, it's hard to imagine a regulatory process or a bureaucratic process that's slower than what it already is. But Congress can barely act in the first instance, and now is Gorsuch actually suggesting that Congress's proper role is to make sure that every nook and cranny is covered by their legislative power and their legislative power alone? It's
Yeah.
unthinkable.
Yeah, and I mean, in fairness, there's a bit of a chicken and egg issue there of like, that Congress can barely act. It's like part of that I part of that I suspect is because their inaction has been enabled by very very broad non-specific delegations to the executive of like, yeah, you guys just kind of figure it out and we'll just make the agency and you guys can go from there. And so there's an argument that like, okay, maybe constraining these broad delegations at least somewhat would sort of force Congress to act, but yeah, there are also like kind of hard constraints on how much Congress can do and how quickly, like, okay, how much of a majority does the party controlling, the if one party controls both chambers of Congress, like how much of a majority do they have? A filibuster-proof one or not? And if they don't have a filibuster-proof one, then they have to work across the aisle in the Senate, and that slows things down and makes things harder. And like how polarized are the two parties? Like, are they willing to agree on anything? Just all sorts of hard constraints that even if Congress was incentivized to act, they still might not. So
Yeah.
yeah, I like I anybody who's listened to the previous episodes will know I like Gorsuch quite a lot. It's probably my favorite justice on the court at the moment.
Doesn't surprise me at all.
Yeah. And yeah, I like him calling out the non-delegation doctrine because as I understand it, it's been sort of like almost neglected by the court or like turned into not much of anything at all. Like, as I understand it, the standard is something to the effect of, well, if Congress does a delegation, they have to include some intelligible principle by which that delegation is supposed to work. And it's like, okay, well, that's a very low standard for a delegation of powers that, at least as far as the Constitution is concerned, look like they're exclusive to Congress. So yeah,
Yeah.
I definitely agree there needs to be a stronger non-delegation, or I agree with Gorsuch, there needs to be a stronger non-delegation doctrine. And I think it's kind of hard to have a major questions doctrine that makes any sense without a non-delegate, a meaningful non-delegation doctrine. But I don't know how strong it
Yeah,
needs to be.
I definitely agree that, these are sort of two sides of the same coin. And uh, Gorsuch's argument for non-delegation I'm pretty sympathetic to it. And Congress has exercised in the past its ability to explicate itself on why this delegation is necessary. You have sense of Congress or findings of Congress written into so many bills
Hmm.
that it would take little more than additional section and 5 lines of text for Congress to appropriately carve out the contours of any delegation that it is handing down. And so this softer, weaker non-delegation doctrine, I am generally sympathetic to. I would love to see it discussed more in future opinions, because insofar as I am a constitutionalist, constitutional originalist, I should say, I think it is very important to preserve this sort of barrier between the branches, and it can be incredibly problematic to see Congress openly, if not always vaguely, uh, ridding itself of the responsibility to craft laws in a way that address narrow, legitimate concerns of the government's function and the American people's relationship to that.
Yeah, and yeah, for those that uh maybe weren't clear, I forgot I was going to mention this. This sort of like the barrier between the branches is one of the kind of sources of this doctrine is the principle of the separation of powers that sort of underlies the structure of the Constitution. And then I think another kind of source of the doctrine is kind of a negative inference from like, there's these enumerated powers in Article 1, or well, in any of the first three articles of the Constitution, there's these enumerated powers that the Constitution says these belong to this branch, and so there's a negative inference that like, okay, they don't belong to anybody else. And then yeah, just how far you take those ideas, like, okay, well then is that a hard limitation on Congress delegating any of these powers, or is it like maybe they shouldn't, but if they're careful about it or limited enough or whatever, then they can.
Yeah, there's certainly some. You get this budding between the practical implications of the law and the rigid legality if somebody wants to interpret something, law in abstract. And the court wrestles with it in this case, and the court wrestles with it a lot of the time. Where and this might be another hypocrisy talking point that we can circle back to later, but the court, and by that I mean individual justices on the court, um, tend to decide if and when practical implications of their decisions matter. And for what it's worth, even when I disagree with the justices and the conclusions they draw on this distinction between practicality and legality, I have grown to accept the fact that, like, the weight that you give practical concerns is itself a kind of framework for interpreting statutes. Um, and so there has to be granted some, like, intellectual legitimacy to that. I think it's important to not disregard out of hand the fact that the decisions that the court is making about what words mean and when they mean those things uh, could vary wildly from how the words are commonly used in daily life, and therefore the practical implications could be massive or minuscule depending on the narrowness of their interpretation.
I have not grown to accept this. Yeah, no, I'm very much of the tendency to be like, I don't to disregard practical implications, and like, okay, well, especially if they're practical implications that like the government has kind of made for itself. Like in this case, one of the complaints from the government was like, well, refunding the tariff revenue will be really, really hard. It's like, yeah, yeah, it will. That sucks.
Oops.
Yeah, it's like maybe you shouldn't have illegally taken a bunch of money from people that you now have to refund. Um,
Yeah, Kavanaugh spends some time on that. A lot of what he says is just like it feels like griping about like how unfortunately difficult this is going to be for the Treasury,
yeah.
and it's like, well, um,
But yeah, like I guess my sort of take on it is like, well, the the text of the text that Congress ratified or the people ratified, whether you're talking about statutes or the Constitution, that text is the law, and nothing else. Like part of the point of having written laws is that they don't change unless the text does. So you've got a degree of stability and predictability and legibility there. And so if you let stuff external to the text, like practical considerations, like, oh, well, it's going to be hard to refund this money. Not that I'm saying that's a practical implication that you credit, but if you let that influence your interpretation of the text, then the law is no longer, exclusively anyway, written law. The law is no longer text, and it becomes a lot less predictable, legible, consistent. And so, yeah, I'm very much sympathetic to like Gorsuch and the other textualists on the court. Like, no, the law is the text, and so that's what we should be giving effect to.
and in general, I will say I do agree with that approach. I'm not anti-textualist by any
Right.
means, but Kagan's concurrence, because I would say that there's not much to discuss with respect to Barrett's concurrence. I mean, she's very concise.
Mm-hmm.
She's just takes a little bit of issue with Gorsuch's framing of the major questions doctrine. A good example of these petite uh, disagreements with how the court should be phrasing its decisions. There's you could probably find somebody else more qualified who could talk at length for hours just about the distinctions that Barrett and Gorsuch are trying to draw here with how to construe major questions doctrine. I'm not about that life, so I'm pretty content with just tabling Barrett and just be like, yeah, she agrees with the other ones.
Yeah, it's kind of just this like really ticky tacky issue of like Barrett doesn't like that Gorsuch is kind of framing the major questions doctrine as almost a freestanding rule. She says no, the major questions doctrine is just statutory interpretation. And yeah, they just kind of go back and forth on that issue, and it kind of reflects this tendency that I've heard others point out about Barrett that I think she was a law professor before she was a Supreme Court justice, and she kind of writes like it, like
Yeah, she taught constitutional law, I believe,
yeah.
and she
Uh,
does kind of write like it. Yes.
yeah, but yeah, Kagan's concurrence, I I don't know that I have a ton to say about Kagan's concurrence, to be honest. I mean, other than like just about Kagan herself, like she tends to be one of my favorite liberal justices on the court. And she writes very well, but yeah, her concurrence, as I understand it, was pretty much just, hey, we don't need to do major questions doctrine stuff, and we don't like major questions doctrine stuff. We can just resolve this on regular statutory interpretation. And shut up, Gorsuch. We're not being hypocrites. Like,
Yeah. It's so fun to see, like, the little bickering that you can read into to all this. Uh, Kagan's concurrence, again, these these other concurrences are very short, compared to Gorsuch, so
mhm,
it's easy to shoot right through them. My only note, or I guess my only talking point on Kagan is that I do appreciate her explicit reemphasizing of ordinary rules of statutory interpretation, or the more common law original rules of statutory interpretation. I thought her usage of the phrase that the court was putting its thumb on the scale, I thought that was a little confusing to me, because again, I am sympathetic to Gorsuch's, or rather to Barrett's position, that
mhm,
the major questions doctrine is just a rule of statutory interpretation. um, And so, in that sense, using the major questions doctrine is not meaningfully different in my mind than any other rule that you would use to reach a certain result. As a slight tangent, it can be said, if you're more cynical of lawyers in the law, or judges in the law, that judges already know what conclusion they want to get to once
mhm.
they've heard the arguments. They just need to find the right statutory interpretive rules in order to get that result. And I think it might be another chicken and egg situation where there's a little bit of play between the doctrines themselves and the result that the judge foresees. But this might be an instance of that, where Kagan and Gorsuch, or Barrett and Gorsuch, you know, they agree again with the conclusion, but they might argue that one rule of statutory interpretation is better or more appropriate than another.
Mhm.
And those kinds of legalistic distinctions are rarely significant to anybody outside the courtroom.
Yeah. Except, of course, nerds that sit on podcasts and talk about them. uh, yeah, I will say, just like going back to a point that I made earlier, that like I didn't really think, like, Gorsuch accuses Kagan of basically engaging in major questions doctrine analysis without saying so, and I kind of disagreed, except as to one point, that uh, Kagan seems to rely on like common sense about how Congress would likely delegate certain powers, and like, oh well, of course Congress wouldn't delegate these really really major powers in really vague language in like this random provision of a statute. And it's like, that sounds a lot like the major questions doctrine. That sounds like
It
kind
is.
of the whole point.
I think that is perhaps the only good example of Gorsuch's criticism. Yeah, your court. Kagan is reinventing the wheel in a way by doing that. I have nothing to add, I guess. No, yeah, I completely agree.
Yeah. um the one thing, since we're talking about the liberal justices' concurrence, is, if I remember correctly, Jackson wrote a concurrence as well that was basically like, oh, but also legislative history, guys. And Gorsuch just doesn't even bother to, to
Oh,
address her.
yeah, Gorsuch explicitly, I think, like, cautions against using legislative history materials. Uh, and I don't really understand why. Again, I think we're getting a lot of the some stuff is made very clear, and some other stuff is hidden behind the curtain a little bit. You'd have to read more on of Gorsuch's opinions to sort of get a more
Hmm.
thorough understanding of his position with respect to legislative history materials. But yeah, Gorsuch doesn't really pay Jackson's position any mind, short of him being generally skeptical of the utility of legislative history. Because again, when you have this textualist approach, the thought is, of course, that any significant interpretations that should be applied to the law will be put into the law, right? It
Mm.
would have been written down if it was actually significant. I'm not as sympathetic to that kind of strict textualism as well. I think that the text of reports written concurrently with the drafting of bills can be illuminating, especially when there are these statutory ambiguities. But it doesn't detract, I think, from the fact that it's clear that Jackson and Gorsuch disagree about the utility of legislative history.
Yeah. Well, and it kind of seems like Jackson disagrees with the rest of the court at this point about the utility of legislative history because, like, I don't know, like, right, I didn't notice this right at the start of her tenure on the court, but especially recently, it's become clear, like, every oral argument, like, so many of her opinions, there's this really heavy emphasis on legislative history, whereas even among the other two liberal justices, there's kind of not. Like, they'll use legislative history or refer to legislative history as like kind of a confirmatory thing. Like, okay, we've done our statutory analysis like we're supposed to, and also like we can kind of buttress this with what the Congress people said, but like the at least the structure of their opinions gives the impression that if the statutory analysis didn't come out that way, they wouldn't look to the legislative history as like, oh, but actually, this is more important than our regular statutory analysis. It kind of overrides that impression. Whereas, yeah, Jackson seems to really want to like push that into the forefront in a court that has kind of rejected that approach.
Yeah, I think that, not to get too deep into the history of the court, I think Jackson is sort of returning to form of what the more liberal bend of the court looked like prior
Mm-hmm.
to the 1980s with Scalia.
I was gonna
I
say,
think
yeah, prior to
Scalia,
Scalia.
yeah, exactly. Scalia really moved the court in that direction of, you know, anti-judicial activist textualism that is very much characteristic of conservative jurisprudence. And Jackson, as one of the, if not the, I can't remember if she's older or younger than Barrett, but as one of the younger members of the court, um, firmly liberal judicial history, it seems that she is trying to bring back, revive from the dead, the statutory approach of using legislative history as a meaningful tool for construing what Congress intended. Getting sort of the meta material that Congress, for whatever reason, decided didn't belong in a bill, but does belong in understanding the mind of Congress. Her returning to form that way, I think, is pretty interesting. I'm excited to see as her tenure continues whether or not other justices pick up on that and move in that direction, or if this is a sort of flash in the pan instance.
Yeah, I mean, I'll just be straightforward in that. I hope it's the latter because I don't really like relying on legislative history for reasons that conservative justices and whatnot have talked about. And kind of the same thing that I talked about earlier, like the law is the text,
Yeah.
and it's it kind of runs into similar problems that people accuse originalists of having of like, oh, you're just cherry picking the history. It's like, well, you can cherry pick congressional debates and reports all day long. Like there's almost, you're not going to find a consensus among the ratifying Congress. And they're not legal scholars, so they might not even know
Yeah.
what they're ratifying.
No, it's and that's to follow this tangent. That is one of my favorite things to point out about constitutionalism in general. If you're an originalist with regard to the Constitution, you almost have to cherry pick by design, and that's not an indictment per se. It's not an endorsement. You do have to cherry pick. Like the Constitution itself was a series of compromises.
Hmm.
I can't remember who it was exactly, whether it was Franklin or some lesser founding father, lesser known, I shouldn't say lesser known
Lesser.
founding father, an inferior founding father, who said something to the effect of, we have this constitution now. Everyone has agreed to it. Nobody likes it,
Mm,
and that's how a lot of legislating happens in general. Is you read through some of these uh, legislative reports from the House and the Senate, and you see just how much disagreement and discord and compromising there was throughout the entire process. To then step back and try and abstract those reports and say, "Oh, well, this was Congress, the whole's intent."
right.
It is, messy work at best and straight up voodoo at worst. Like,
Well,
again, justices like to pick the approach that they think will get them to the result that they like, and sometimes that is more legitimate than other times.
mhm. But yeah, speaking of, I guess, originalists, since we went on a bit of a tangent there, the predominant liberal originalist on the court, Thomas, had a frankly insane approach to this case, I think. I remember like reading Gorsuch's concurrence where he talks about Thomas's dissent, and I'm like, no, like there's no way this is accurately representing. Like this has to be a bit of embellishment. No, it's Thomas is just taking a super weird approach, which he does, and sometimes I appreciate him for it, but this one was just I don't get it. I don't know where it comes from.
He did something which, I shouldn't say I'm surprised that Thomas did this, but it was certainly a lot because he writes more than most of the other concurrences as well. His section was only a couple pages shorter than the majority opinion.
Mm.
And what Thomas does or tries to do is take all of these historical applications of tariff power and many of which were referred to in the Gorsuch opinion or in the Roberts majority opinion, and flip them on their head. I guess try and argue that, oh no, these actually are examples of why President Trump's tariff authority is valid, and the court should construe it this way. It was very bizarre. I don't have much more to say about it than that. I think that it is certainly one of, if not the weakest Thomas dissent that I've read in a very long time.
Yeah, I kind of got that impression too. Well, and like the really crazy part to me, because like looking at the historical stuff and like trying to twist it in a way, like okay, that's not crazy. Like I mean, the Kavanaugh dissent tries to do this as well. Uh, but the thing that was crazy to me was his almost like or like anti non-delegation doctrine for specific powers of Congress. Like his sort of thesis seems to be no, there are core legislative powers, like true legislative powers that Congress cannot delegate, and those are only powers that like affect deprivations of life, liberty, or property, and everything else, including the tariff power, is like this, I don't know, additional or like ancillary legislative power, and Congress can delegate that at will, like no restraints whatsoever.
Yeah,
And
it's
I,
so profoundly bizarre. Sorry,
yeah,
you can continue.
well, yeah, I mean, that's what I was gonna say. It is just bizarre, and Gorsuch points this out. He's like, where is the distinction between these core legislative powers and these other legislative powers in the Constitution? Like, there's a list of powers that Congress is granted in Article 1, I think Section 8, and it just goes down the list, and there's no like, and here are the big ones, and here are the small ones. It's like, no, it just goes from one to the next, and there's the tariff power.
Yeah, and that's something that Roberts points out is that, in arguing from this prior case, arguing from Gibbons v. Ogden,
Hmm.
you know, Article 1 of the Constitution gives Congress the power of the purse, essentially. The Commerce Clause is what grants Congress is authority to control the avenues of trade and uh, the ability to raise money for the Treasury. All these things that when you list them out feels like transparently related to tariffs. Like, uh, and to just to take, like you said, I think Section 8, to take it out of that context, and especially the context of like, which are referred to less and less, but the context of the Federalist Papers, which also explicate a lot of these contours for interpreting the Constitution. When you take the list of powers out of that context and then try to decide, oh well, some of these are quote unquote core powers and some of these aren't. It's just a very weird game, and I don't know how else to articulate it than that. Is reading reading Thomas's opinion just felt strange. Like I wasn't like I wasn't reading about the Constitution as it exists anymore. It was some kind of alternate version of it that he was advocating for.
Yeah, and I mean, Thomas is often weird. He's probably the justice that most commonly has like lone concurrences, lone dissents that, other justices just don't join on to because either they're like, what the hell, or they're just like, we don't need to talk about that. To be on this case, like, one that I appreciated, on it's kind of a tangent, but one that I appreciated was I think it was McDonald versus Chicago, Chicago versus McDonald. I always forget which way it goes. Where he's like, no, the Second Amendment isn't incorporated against the states through this clause of the 14th Amendment. It's actually this one. And, he's the only one forwarding that view. And it's like, okay, I'm kind of appreciative that you stuck your neck out to, defend this interpretation. But yeah, in this case, a bit of a miss, but still, I don't know. It's still kind of neat to see him just like taking his own position and defending it.
Something admirable about the ability of someone to uh, advocate for their position, regardless of how it might be perceived.
Yeah.
Speaking of advocacy, the final and ultimate dissent by Kavanaugh, which was joined by Thomas and Alito. So you have
Mhm.
consensus here amongst the dissenting conservative justices. Kavanaugh, provided this really comprehensive defense of the government's position. I think that, and especially from oral arguments, you could really get this sense that Kavanaugh wanted to. I'm not trying to undercut his legal reasoning either, although I disagree with it. He really wanted for the government to maintain this tariff power
Mhm.
under the IEEPA. He structures the case describing it as like the president acting pursuant to this congressional authorization under the act. He argues that this, terminology fighting, this semantic debate between regulation of imports and adjustment of imports, it's not like a meaningful distinction. He relies on something that Roberts explicitly rejects, which is the idea that, the precursor to IEEPA, the Trading with the Enemy Act, was precedential in terms of how this act should be construed, for the president's tariff ability to impose tariffs. And then we get, to the part where I think you and I agree is certainly not as strong, which is the arbitrary decision to say that, hey, foreign affairs, no, we don't need to apply the major questions doctrine here for some reason.
Yeah.
It relates back to this, I think, this impulse, and it's very common, especially more so nowadays amongst the conservative amongst conservative justices and within conservative jurisprudential thought, that foreign affairs and foreign relations are something that are more or less expressly and exclusively delegated to the executive branch to conduct. I think that interpretation comes into conflict when you think about Congress's explicit authority to declare war, amongst other foreign affairs.
Mm.
But there's certainly this impulse to say, for conservatives like Kavanaugh to argue that, hey, foreign affairs is something that is firmly within the purview of the executive branch. Any act of Congress that restricts or imposes upon that should generally be construed as inapplicable, or that there is some exception at play here. I don't think that Kavanaugh really fleshes that out well enough to rest his laurels on it.
Well, yeah, and like I tend to agree that foreign affairs is, if not exclusive to the president, with such exceptions as are made in Article 1, like the power to declare war, regulate foreign commerce. Like, okay, yeah, those are definitely within the purview of Congress because the Constitution says so, but the rest of foreign affairs, being at the very least firmly, within the wheelhouse of the executive, I'm definitely sympathetic to. But a big problem that, like, this idea, uh, like the idea that, okay, so then we shouldn't apply the major questions doctrine to foreign affairs issues like setting tariffs runs face first into the problem that Congress is granted the like explicitly granted the power to impose tariffs. Not it doesn't use the Constitution doesn't use the word tariffs, but Congress is granted the power to set like taxes and duties, and I forget what other terms are used on imports. It's like that's tariffs.
Mhm.
um,
Yeah.
and so yeah, I don't know where this comes from or like how you can really defend the idea that no, we just shouldn't apply the major questions doctrine here.
Another thing that Kavanaugh says, which I thought was bizarre. Maybe we're getting into that hypocrisy territory now. Finally circling back. He warns, and this is again too. I think Kavanaugh plays a very practicalist card
Hmm.
during his arguments or explication of his opinions. Uh, he warns that applying the majority's new approach would have altered the outcomes in prior decisions, which he seems on the one hand like, oh, maybe there's some legal value here he's trying to assign to precedent.
Hmm.
But in previous cases, Kavanaugh has demonstrated that he's not married to the idea of precedent. So this
Yeah.
argument really feels like a toothpick in a log cabin. Like why are you trying to argue that prior decisions would be different if we applied this rule now? When you yourself acknowledge that the rules that we use to interpret the law can change and evolve over time. It feels like a departure from his previous opinions. And I think it's pretty easy to say you don't have to be cynical to say that like he's probably doing that because he agrees with the result,
Mm.
right? He wants the executive branch to be able to utilize tariff powers, and insofar as he believes that under his previous arguments, he comes back to this and says, "Well, icing on the cake. Let's just say too that precedent would be violated if we did this now."
Yeah, and I mean, I do think I kind of agree with Kavanaugh that the majority has a difficult time distinguishing some of its precedents from this case, like very similar language in other statutes. I mean, I think his points about like the Trading with the Enemies Act is not as good. Because as I understand it, the argument is, or wait, I forget if the Nixon tariffs were done under the TWA or if it was IEEPA.
That was the Trading with the Enemy Act,
Okay.
or the Nixon era tariffs.
Yeah, and yeah, I think like the Nixon tariffs are not the strongest point for reasons that the majority points out, but other statutes that use very similar language that the court has understood to include a tariff power, yeah, I think are harder to for the majority to distinguish, but okay, then maybe their precedent's wrong. So, like, oh, how do I put it? I'm not married to stare decisis either. I think the kind of conservative jurisprudence tendency to be like, well, if we were wrong, then we were wrong. And we shouldn't be married to prior precedents just because they exist if they're wrong. And yeah, for Kavanaugh to then lean so heavily on, well, these cases are really hard to distinguish. It's like, okay, well, if we can't distinguish them, then maybe they were wrong, and that's fine.
No, yeah, I am not a huge especially given the fact that our entire legal system is descendant of this common law approach, where judges were, practically speaking, making law
Mhm.
at every juncture, right? It feels weird to marry oneself to start as a necessary principle of judicial interpretation, because again, justices are just people, and so they can get the law wrong too, and often do.
Yeah.
So, and this, I think that I am sympathetic to Kavanaugh, and that the majority does struggle a little bit. The majority refers specifically to like Section 232 of the Trade Expansion Act, as being like one of these acts that gives the power to uh, implement duties, tariffs under its terms. And, so I'm sympathetic to Kavanaugh's reason that the majority opinion has some trouble between that and the IEEPA, amongst other examples. But I don't think that it is an impossible fight for the majority to win. I think that they lay out their points effectively enough that this criticism is appropriately thwarted. I'll
Mhm.
say that. And Kavanaugh might disagree. Kavanaugh might think that, the court is simply adding or interpreting language into these other statutes in order to make a distinction that isn't actually there. Uh, History will prove out. I often say that as many people do, the Supreme Court is not last because they are right. They are right because they are last. And so, what the majority says goes, for better or for worse.
Yeah. One point that I did want to call out that, like, I hear people make very often, that Kavanaugh makes here, and I really dislike it whenever it gets made, like that. Well, in this case, the IEEPA authorizes the president to do, a whole slew of things with respect to imports, including but not limited to, like, setting like caps on the amount of tariffs coming from some country, or to just straight up prohibit them. And so Kavanaugh argues, like, well, that's a really, like, that's a really strong power to affect imports, and tariffs are a relatively less strong power to affect imports. Like, so the greater includes the lesser sort of argument. And I really don't like
Mhm.
that, because I really don't think that's true. The greater doesn't always include the lesser. Like, just because tariffs are sort of a lesser power in some sense doesn't mean they're included with the greater powers. They are, in, I would say, different in kind.
Yes, yeah, and I think the majority does make that point. Kavanaugh is pulling directly from the government's briefs when he
Mhm.
makes that argument. This idea that there's a pole, or there's a polar relationship between the statute saying that the president can compel on one end and prohibit on the other. Kavanaugh reasoning, of course, that, well, tariffs as a power lie somewhere in between those two poles, and so it must be allowed. I do not like that interpretation, Sam. I am. Uh, I think that it is important, for any well-respecting textualist to recognize that you should not necessarily interpret what is meant simply by the neighbors of what's been said. And Roberts lays out that argument pretty effectively, I think. So there's no need to reiterate that point more. Uh, the IEEPA lists a lot of things that the president can do. I think if Congress wanted one of those things to be impose duties or impose tariffs, that they could have just said that.
Mhm.
And you get more and more further along Kavanaugh's dissent, and I think as he runs out of legalistic arguments to make, while still trying to fit his 63-page quota, he gets more and more into the practical implications. First, with the well, not really practical implications of this decision, more just like aggrandizing the government's decision to impose tariffs in the first place. It's really bizarre, honestly. It feels, uh, whereas I think that oftentimes, if not always, the court is implicitly political. part of Kavanaugh's dissent feels like an explicit political endorsement. He says, something to the effect of that, tariffs have aided Trump's foreign policy and
Mm.
helped to facilitate trade deals worth trillions of dollars. First and foremost, I'd like to see the numbers on that.
Yeah, like
So
trillions of
we're
dollars asterisk over the course of 27 years if
if X, Y, and Z happen. We're
yeah.
taking the government at its word for a lot of things. But even granting that, right? I don't know why this is relevant.
Yeah.
uh, if you use an illegal mechanism as leverage to do good things for the country, it's still illegal. There's this Napoleonic thought that anything done in the service of your country is always legal, which is what this felt like to me reading it. And I was like, I don't, this is really
And
dangerous territory, Kavanaugh. I don't think that this is relevant. And if you think it's relevant, it really shouldn't be.
yeah, and to be clear, the Trump administration has explicitly endorsed that concept, like explicitly quoting Napoleon, something to the effect of, he who does best by his country does or breaks no law or something like that. And
Yeah,
it's like,
exactly.
uh, but yeah, no, I don't, I didn't really like the, as you say, like almost explicitly political endorsements either. It did seem it did seem to just kind of be swallowing the administration's like pitch for these tariffs hook, line, and sinker. I'm like, why does it matter? And also, why are you doing that? And it's especially annoying because Kavanaugh starts the opinion talking about how judges shouldn't be concerned with practical considerations and like their role is just to interpret the law, and then he goes on about how great these tariffs have been and how refunding the money is going to be super difficult and all the rest. It's like, okay.
Yeah. That's the last point, of course, which is that it's going to have a significant impact on the treasury if we have to refund all these tariffs. And you know what? Like, again, the Supreme Court is allowed to craft its own solutions. I think to a lot of these problems,
Mhm.
they might not want to use that hammer all the time, but ultimately they can. The court didn't have to decide that refunds were the proper solution. I think they were right to,
Yeah.
or to suggest that refunds were the right solution. But that didn't necessarily have to be the case. That said, though, I think again Kavanaugh is appealing to these uh, practical implications that were pushed forward by the government, where they didn't want to be administratively responsible for repairing the damage that they've done. Which again, as a ranking conservative member of the court, I'm flabbergasted why Kavanaugh of all people would be making this argument. It's like the government, the Goberman,
The
don't step on
Goberman.
me, snake. The government has in this instance taken money from the pockets of American corporations and by proxy American taxpayers in application of a law that was illegal. The application of the law itself was illegal.
Mhm.
Um, and so, if there was ever an instance where one should be advocating, if not celebrating, the refund of ill-gotten gains from the government to the people, it should be here.
Yeah, and
Maybe that's a little too soapboxy, but I think that Kavanaugh really misses the mark in that argument.
yeah, this is kind of a tendency that I've seen others point out, and since having it pointed out to me, I've kind of noticed a little bit more that Kavanaugh's a lot friendlier to the government than, like, for example, Gorsuch, which, I mean, Gorsuch is a pretty high bar for unfriendliness to the government as far as Supreme Court justices go, uh, but yeah, Kavanaugh tends to not like to impose a lot of hardships on the government, especially it seems like the executive branch. Like anytime I can't remember the specific example, but there's been a few cases where like some police action has come up before the Supreme
Yeah.
Court, and Kavanaugh seems a lot friendlier to the police than
It,
some of the other
yeah, it was
justices.
it was recent decision. I can't remember if it was shadow docket or if it was um a fully argued case. But yeah, there were concerns about racial profiling in ICE enforcement, and
Oh, yeah, I do
Kavanaugh
remember that one.
wrote a concurrence or wrote the majority opinion, and said that this isn't an issue, and even if it was an issue, the burden would be too great on the government in order to enforce the policy that the challengers are advocating for. So now that kind of enforcement is appropriately referred to as a Kavanaugh stop, where you could be pulled over for speaking Spanish or looking Hispanic or whatever. And that's a whole nother can of worms for another day.
Mhm.
But yeah, Kavanaugh certainly has this bend. I see now. I hadn't really thought about it before. Kavanaugh certainly has this bend in contrast to conservative justices before him, where he's certainly more sympathetic to the government's arguments.
Yeah, with that, I don't know if I have anything too much more to say. Racking my brain to see if there's anything else I can ramble about, but uh,
No, we covered a lot of ground. I think that
mhm.
that's the meat and potatoes of it.
Yeah, so with that, if I may ask you, my friends on the other side of the screen, like, share, comment, do all that fun stuff. Follow the podcast wherever you follow podcasts, and if you'd like to support it, you can do so on Patreon. Main content of the show will always remain free, but Patreon members have access to bonus or exclusive content and can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will be continuing on through the 2025 term. I don't know if you have plans to come on for the next episode or just specific episodes in the future, but hopefully we will be seeing more of Will in some of those episodes as well.
Yeah, I'd be happy to come back and contribute whenever I can. Thank you
All
so
right.
much for having me.
Yeah, absolutely. Thanks for joining.